30.
Ah.
Initially, it was fixed at 2 p.m. on March 5, 2025, and it had appeared. Lordship sees the last March 5 order. It had appeared before this court. The Lordship was of the view that because this arises out of the testamentary jurisdiction, it will go to the other court. Now we went to the other court, and thereafter now the matter is specially assigned before this court. I was only praying, Mala, this is at the ex parte stage. It appeared last Friday at item number 52. My lord,
Testamentary, why assigned here?
my lord, assigned. Now it is assigned because first order passed by this court of status quo, which has been violated. I am for the executor. Now this order has been made absolute also. I was praying, well, the Lordship's kind permission, this will take 9 to 10.
What's the stage?
It is at the new, it has not been moved. Now it will be moved for the first time. Contempt. I was only praying on 27th, which is next Friday. If I can, it will not take more than 10 minutes, 8 to 10 minutes. Any time can be free, either at 12:30 or 1. I will take maximum 8 to 10 minutes. We have waited for last 3 months, and now, my lord, last Friday it was way bottoming. And they have, what is our information? They have also tried. They have also dealt with this property, my lord, in blatant violation. If 27th, my lordship normally takes up this matter on Friday.
But 27 fixed, na?
It will take hardly 8 to very short matter. It's in the new motion ex parte stage.
Fix hai kya kuch?
No, Friday, 27th.
27 Friday, June.
हाँ. Either at 1 p.m. or 1:10, I can.
तुम लोग को है ना? नहीं, दोनों कमर्स ने कोई टॉप अप करके है कुछ, इसको रख दो.
Lordship is keeping it at?
May I have your lordship's kind leave to mention? One testamentary matter, beneficiary is 100 years of age. That is my urgency.
Testamentary is, this court is not having jurisdiction.
Your lordship has been given jurisdiction since Justice Arinda Mukherjee is in circuit bench.
So what you want now?
Well, for urgent listing, my lord.
2 days.
Sorry. 100 years of age. Beneficiary filed the matter not in
2 days, nothing will happen. Go on Monday.
May I have your lordship's kind leave, my lord? This is, my lord, a matter, my lord, where, my lord, the suit has been transferred from the, my lord, city civil court, my lord, to the commercial determination of this honorable court. My lord, we are to, my lord, carry out the amendment of the plaint. My lord, the difficulty arises, my lord, that we have to, my lord, we have been asked to, my lord, file, my lord, serve the summons again, my lord, whereas, my lord, in this case, my lord, the summons had already been served, my lord, it is an undefended suit. My lord, in my, my lord, subject to correction, at best, I will serve a notice upon the defendant. But summons need not be served again, my lord. So, my lord, registry, my lord, wants, my lord,
number has been assigned.
Leave before your lordship.
After transfer, number is assigned.
Yes. My lord, kindly seize the last order of your lordship. The amendment would be only structural regarding the format, nothing more.
That all the formalities have been completed.
My lord, the formalities, my lord, while filing the amended plaint, my lord, there the difficulty arises, my lord, they are not accepting, my lord, without, my lord, the summons again being served. My lord, this is a matter where, my lord, summons had been served, my lord, no written statement has been filed.
That is different. This has been transferred from the city civil court.
My lord.
After transferring the matter here, so all the post title, all the things has been patent or truth and all the thing has been
my lord,
filed.
that's where, my lord, we are stuck. My lord, the next day is 25th, lordship was pleased to fix it. My lord, we are trying to, my lord, do that with the, my lord, registry and the master. My lord,
so now what you want?
My lord, we have the, my lord, we want the, my lord, leave, my lord, without, my lord, the summons, because we are already in that stage. We have already crossed those stages.
What is this?
Well, this is the, my lord, the amended plaint.
Yes. Amended plaint.
Well, amendment so far as, my lord, the cost titles and all these formalities are concerned.
With the presentation form.
With the presentation form.
How it can be? How it can be?
My lord,
you do one thing, let the matter come on 25th, I will see to
very well.
Come on 15th, because the whole record will come, then we'll see.
Very well. I am grateful to you,
lordship. I am mentioning a suit. I have mentioned earlier also, lordship. This suit, your lordship does not have the determination to try or entertain the suit. But the suit is lying with your lordship. So kindly release the matter.
Which suit?
CSCOM 501 of 2020.
CSCOM, this court is not having jurisdiction.
commercial suit.
This court is not having determination.
The matter dispute in the suit pertaining to the intellectual property rights, Lordship.
Okay, say that. So it is pending before this court. It is listed.
Not listed, Lordship.
Then-
Kindly keep it as.
So mention before the intellectual property court, it will go there.
The difficulty I am facing that until or unless your Lordship releases the matter,
I don't know how very it is not in my list. Which serial number?
not in the list, not running in the list.
So how you can say that matter is pending before this?
It's a commercial suit, Lordship.
So you have not made an application for converting into the IP.
Yes, Lordship, I have done.
If IP is done, then how this matter will appear?
But from the department, they are saying until or unless there is an order from the court, they cannot transfer the matter, Lordship. I have tried mentioning before your Lordship.
एक काम करो number ले लो उससे मास्टर से बात करेंगे. What is the number?
Yes, from
May I be?
My lord, may I seek my lord's leave, my lord? My lord,
Yes.
may I seek my lord's leave to mention, my lord, one matter? Your lordship had heard this matter at length. Your lordship, the hearing, my lord, the arguments of the plaintiff has been completed. My lord, Mr. Mohinat Bose argued for the plaintiff. Shataru Banerjee is there, my lord, for the defendants. My lord, due to change of determination, my lord, this suit has gone to the other court, wherein, my lord, it was released and it was assigned, specially assigned to your lordship. My lord, your lordship has all completed the argument. He heard the, my lord, plaintiffs. Arguments are complete, my lord. Your lordship used to fix dates.
Now I will fix Saturday or Sunday, the specially assigned matter.
Very well, my lord, we'll attend. We'll attend, my lord. So, my lord, your lordship wishes, we will attend. Absolutely, my lord. My lord, any date, my lord, last Friday it appeared in the list, my lord, it could not be taken up. I would be beseeching your lordship if a date could be fixed. Any date subject to your lordship's convenience. It's a hearing matter. Plaintiff has already completed his argument, my lord. We are for the defendants. We will, my lord, start our argument.
The non-commercial though.
Yes, your lordship.
ठीक है, Friday
Yes.
रखो.
My lord, may I be permitted to mention?
Deeply obliged, your lordship.
My lord, may I be permitted?
Yes.
Well, may I be permitted to mention urgent matter pertaining to the list of Honorable Justice Mukherjee, my lord.
What is the urgency?
My lord, urgency is that the pala is of the trust is going to start from 1st July, my lord. Now, because the inertness of the defendant number 1, my lord, the trustees are unable to operate the bank account. They are spending money from their own pockets. There are huge income tax dues, in spite of the fact that the state has a substantial corpus, my lord, because the corpus is lying with the bank and the defendant number 1 is not cooperating with the trustees, my lord, present trustees, my lord. They are unable to bring out the money from the bank, my lord. Now the pala starts from 1st July, my lord. My lord,
So now the court will be there from 23rd on.
my lord, but unless there is an order, my lord, the bank has also to be ordered, my lord, too.
Pala will be on 1st of July, but the court will be there from 23rd onward.
If it's so common sense, lordship can take up the matter, my lord.
Sorry. Or one day.
I have a lordship's leave, my lord, pertaining to Honorable Justice Arindam Mukherjee's bench, my lord. I'm so sorry, Mr. Bhagwat, but it's only because Mr. Dashgupta has some urgency there in the other court. But this pertains to Honorable Justice Mukherjee's determination. As I mentioned yesterday, the application has been numbered. It's GA6. The meeting is scheduled to be held on Sunday.
What application?
The application where we are challenging some of the agendas which have been proposed to be discussed in the meeting and approved in the meeting.
When the meeting will be held?
Scheduled to be held on Sunday, on the
Milord, may I?
22nd.
The notice was of 4th of June. Milord, every year they used to wait one day prior to the meeting to show the urgency. Last day also, Milord, last year also they did that. My lord had entertained. My lord, recollect, Milord, they had obtained an interim order without disclosing to your lordship that plaintiff has expired. Now, Milord, that amendment application is pending. That amendment application is pending. We are opposing. My lord was hearing that. Milord, I have filed a demerger application saying that this court has no jurisdiction. Is the principal civil court is city civil court. My lord had passed an order that the point of maintainability should be that GA should be heard first. Now, Milord, on that note, Milord, determination got changed. Now, Milord, before Justice Mukherjee, the matter was called twice. I'm carrying the order. Milord, there are orders that Grelord passed by lordship, but they have taken adjournment. Now, Milord, entire year they used to sleep over. Only Milord, even
when the notice was issued,
4th June.
June. They have
The meeting is on 22nd.
They are the back.
Meeting is on 22nd.
So once the notice is issued on 4th of June, the court was there, but you are not.
Which was there.
Court was there.
But the meeting is on Sunday, if your lordship, kindly, keep this matter to kindly, my lord, otherwise the application will become infructuous.
Here.
Lordship may keep it tomorrow. My learned friend will make his submissions, my lord.
Proposing this.
My learned friend will make his submissions, my lord. If your lordship keeps it tomorrow, we'll meet the points. Otherwise, my lord, this application will become infructuous.
At that court.
But when the meeting is to be scheduled?
My lord, it's this Sunday, my lord, 20.
Sunday means 29,
22nd, my lord.
22nd.
That is why. My lord, I mentioned this matter yesterday. My lord, there was
Sunday you are conducting the meeting.
Like 4 June, my lord, there was 2 vacation benches, 5th and 6th.
Might be vacation bench, but thereafter there is bench is not there. Now they are mentioning it. Let it.
My lord to hear out the entire bunch of applications. My demeanor, this plaint is invalid now because plaintiffs have expired. Amendment is
So,
pending.
okay. You lay your hand till 30th. In the meantime,
My
the
lord,
regular bench.
my lord wanted to list the entire applications.
They are not. That's why if you're so that you do one thing, you lay your hand till 29.
Let my application be heard first. My point of demeanor.
That cannot be taken by this court with regard to ad interim. They're asking interim order. So now 22nd they have fixed the 22nd, 23rd the regular court is coming. So you lay your hand till 28.
If it's at 2 p.m., my lord hear out. Because till 4th of June they have waited. Only this is the ploy to show the urgency. This gimmick of urgency.
So why you not mentioned prior to that?
4th June.
But we prepared the application during the weekend, but it was prepared.
When you file the
But I had mentioned this matter yesterday. But it was affirmed yesterday. It was also numbered yesterday.
Sorry. Yes.
It was numbered. But Lordship will kindly. Otherwise nothing will survive.
You received the notice, sir.
Sorry. May I say this? Yesterday when I mentioned, my voice was not so audible.
But you received the notice on 4th June.
My lord.
Now 20 days you have waited.
But otherwise, if my application will become infructuous, the meeting will be held. But if your lordship kindly considers my interim order.
And why you are not up at 2 days? Why you are taking that?
But I was present yesterday to mention after it was served. But it was served 2 days back. But it was served 2 days back. If your lordship kindly considers this.
Mentioning notice not mentioned.
March, an order was passed by which 3 months was granted to the learned commissioner. So the process of commission action is ongoing. There are 6 witnesses. At the beginning, we knew it's one witness. But now there are 6 witnesses. I'm only praying for another 3 months by which we conclude the entire process. But maybe listed as to be mentioned tomorrow because I'm not carrying the orders, unfortunately.
But may I seek one last opportunity? Lordship will kindly consider this. 22nd, the meeting is there.
You received the notice on 4th. Okay.
4th of June is
when there, then this court is taking the matter since 9th. Now we are on 19th. 10 days you have waited. More than 15 days you have waited.
We had prepared it during the weekend. But the notice is also not given. Notice is also not given according to the bylaws. Well, Lordship has considered this aspect of the matter before also.
Have been telling that, yes.
No, but on the last occasion, Lordship had considered this aspect of the matter.
May I have a leave to file application in the department? The reason is the color of the bond paper is different. It has come from
the bond paper.
Yes, my lord. We are using my lord milky white. So snow white paper is there. So their department is saying the paper's color is different, my lord. It has come from Ujjain, my lord. So they are using my lord snow white papers. And we are using off-white papers.
Now this is a white paper.
White paper, but we are using off-white paper. Kindly see the other papers, my lord. I have filed the wakalatnama.
We are having the executive papers, executive bond.
This is also executive bond, my lord. This is also executive bond, my lord. They are using it. I have told them to print it on the executive bond, my lord. They are using this type of paper.
So what you want?
Only leave, my lord, leave to file in the department.
And the seal of your notary public is also not kept. See how you can read.
No, my lord, it is on the others. It is there. It is there.
बताओ इसको note.
Earlier it was attached, my lord. I took leave, my lord, but
here also.
It is.
Not this. I am telling with the affirmation part, that big one. This one. Who has put this seal? This seal. Who has put this seal? That also.
Yes. This is the seal there. This is the seal.
Whose seal?
Notary seal.
So where is that eligible?
Yeah, affirmed my,
What you read it? Read.
my initial is there and then the notary Ujjain MP.
What is written in the seal portion?
Affirmed by me.
The total, the contents. What are the contents of the seal?
Contents of the seal, my lord. Yes, my lord, is they not legible, my lord, but it has been.
And that is not the seal of the notary in terms of the act. In terms of the act, the read over and explain in Hindi, English, Bengali, whatever it is, in my presence, after knowing the content, the deponent sign. That should be the contents of the seal in the notary.
May I check?
May I make one
Hello.
It's a matter of admiralty jurisdiction. The decree was passed on 9th of September 2024, my lord. That we have not drawn it up. There's an execution. My lord, here there's a risk we are running now. That one of the parties was, my lord, who had agreed to a terms of settlement. But now they want to initiate arbitration proceedings in London. It's a maritime arbitration, my lord. And when they cannot do that, they're clearly barred. So we're filing an execution, my lord. The difficulty now we are facing is because the decree has not been drawn up. Only leave to draw up the decree, my lord. I understand with order 20, my lord, 6A, this is a out of time. Very, very deeply obliged, my lord.
Yes.
The defendant number 2, my lord.
Yes.
Defendant number 1, my lord.
And number 3, my lord.
Yes. Considering the above suit as well as the counterclaim is dismissed. Both are dismissed.
Counterclaim is dismissed.
Suit
Great.
also dismissed, counterclaim also dismissed.
I'm sorry, my lord. The suit
Suit
only the
also dismissed and counterclaim also, both dismissed. Yes.
But the plaintiff, my lord.
With regard to the GA1, this court has allowed that interim order prayer. You have admitted that GA1 is disposed of, and GA3, GA6, I have directed the notice be issued to the authorities, and 5 questions have been framed that they have to give answer. And with regard to the 7, the call, this court has directed that you have to place the collapsible gate.
Obliged.
Collapsible gate to be installed.
I'll just indicate you know,
Within 2 weeks. Within 2 weeks.
my lord, I'll indicate
2 weeks, my lord. If it is possible, my lord, kindly give little more time. Making all arrangement, it will.
Not collapsible gate, it's a flush door. Flush door. How much time?
4 weeks, my lord, give 4 weeks time. But
3
it
weeks.
can be done before that, at least extended time maybe necessary.
Okay.
4 weeks.
I'll just indicate your lordship.
Yes.
My application pertains to this matter. It's application under order 1, rule 10 application.
Which one?
GA5.
Ah.
That is, my lord, any day maybe 6 minutes for kept any day.
You mentioned that next day you mention, I will fix.
I'll
Yeah, after notice to the parties, mention.
My lord,
I will-
great.
Yes, next.
My lord, I appear for the petition, your lordship. On the last occasion, your lordship had directed for personal presence of the directors, my lord.
Yes, and you are
Lordship,
present.
Lordship, they are present via video call, Lordship, and 2 things I have to show your Lordship. I know Lordship's patience has been tested in this matter, Lordship. Hey, it had to be now.
My lord, before that, may I indicate your lordship today also? One minute.
One short interruption, my lord.
Yes.
The first item, my lord, kindly not excuse me, my lord.
Yes, yes, no problem.
If your lordships recollect, my lord, we had applied before the Honorable the Chief Justice, my lord, in view of the Supreme Court's verbal observation, my lord. There was a letter from our side. There was a letter from the side of the respondent also, my lord. But we are yet to, my lord, get any, my lord, sort of
I'm told that this both matters have been written, my lord, in both the courts.
No,
My lord,
there is no
this-
communication as such, to us at least, written or verbal, because my
advocate on record was not called from the Chief Justice's secretariat.
So what we want, what you want?
But what,
I am adjourning for 1 week, let you.
My lord, kindly fix it, my lord, any day, my lord. I think, my lord, that
could I
communication,
say
my lord,
this?
we have
My lord, could I say this, my lord? Subject, of course, to correction by Mr. Banerjee and my lord, your lordship's consideration. May the file be sent before the Honorable Chief Justice so that whatever the Chief Justice
my lord,
decides,
I'm sorry, my lord.
That is not the
My lord,
procedure.
sorry, my lord, we have followed up. I am told, my lord, it's both courts, my lord, are retaining, my lord, the jurisdiction by the State
was,
Department.
my lord, contrary to what the Supreme
No,
Court
no,
said.
no. That's what the Honorable Chief Justice said. Supreme Court said, place it before the Chief Justice.
What I am placing in the next week. In the meantime, the Chief Justice determination order will come. Then automatically.
Very well.
Then
My lord,
may I
kindly put
kindly
on
keep it after a fortnight, my lord.
No, my lord, next week, my lord, we want to start this. It's their section 34. I'm surprised, my lord, they don't want to proceed with it.
I am in some difficulty till the 4th. Well, there are some unled outstation.
Well, this is only for the purpose of fixing dates. So, can you fix it, Malad? Put it on the 24th or 25th. We can come back. And then, Malad, any day convenient to learn it advocate.
I don't think his execution is
I am fixing on 26 as to be mentioned.
23 has to be mentioned.
26 I am fixing.
Malad, 24th or 25th. Malad, can it be
25th?
25th.
Okay, 25th I am fixing as to be mentioned.
Well, both Mr. Shah
only for
and my
fixing date.
instructing counsel will not be there.
It's only for fixing
When,
date.
when you tell which date?
27th.
I mean, but put in order. If you're there, do it.
Could it be after 4th because Mr. Shah won't be?
Malad, we are only putting it for the purpose of fixing dates. I do not understand.
On dates, my lord.
एक काम करो
I leave it to your lordship.
खाली है 11:30 12:30 खाली है
Is there section 34? They don't want to proceed. I'm very surprised.
जुलाई में कोई 11:30 12:30 खाली है जुलाई में 12 जुलाई के बाद है कितना बजे 12 okay I am fixing at 23rd at 12:30 whatever the result if it is not done the case will proceed.
Very good.
Yes.
Fix it.
Advocate General.
But 23rd for fixing a date.
Yes.
No, 23rd I am fixing at 12:30.
Yes, for fixing a date.
For fixing a date. So suffering for the petitioner, so suffering for the respondent. It is informed by the counsel for the petitioner that the request made before the Honorable Chief Justice for assignment of the case to the other Honorable Court is pending. In view of the above, let the matter appear on 23rd July at 12:30. 23rd July at 12:30.
And Malad, that's our Malad communication. Malad, the officers Malad can also follow up and find out more what's happening because that's
yes.
what Malad.
It's item number 9 here. Last order. Lordship, the last occasion, Your Lordship directed Your Lordship to the presence of all the directors. Lordship, all the 3 directors are present virtually, and 2 things Your Lordship have to show. One is the acknowledgement of by the NSC.
Court has directed to appear.
I am on behalf of the contemners.
Court has directed to personal the virtual mode.
Lordship, they stay in different parts of the country.
Take instruction when they will appear before this court. Today at 2 p.m. Today I want this 2 p.m. Otherwise I will immediately I reissue the direction.
Lordship, I know.
Let
Lordship
them be brought on the
has
surface
been
on Monday.
tested. If Your Lordship wishes, Lordship can.
Not wishes.
Lordship can direct a warrant also. Not.
You are playing with the court. Every time changing the lawyer and making a submission.
No, Lordship, since the beginning only I have been in the advocate on record in this.
What is your name?
My name is Abhishek Kabir. Previously,
where is Arun Chakraborty?
Arun Chakraborty is tied in Lordship in court number 30.
Because he knows what the court will do now today. That's why he's not appearing before this court. And send the junior. Ask your client whether they will be able to appear before this at 2:30 or not.
Lordship issues a warrant if required, Lordship. I will not come in the way, my lord. Because they are one director is in Madhya Pradesh, the other is in Pune, and the another is in Gujarat, if I am not mistaken, my lord.
Give the police station number, all the things. How they will not appear before this court, I know. Give the police station details.
Police station details. Contempt. We have given the address, Your Lordship, but police station details we
That
require.
you persons are making the content application without the PS address.
Lordship will provide, Your Lordship. We have given the address, Your Lordship. We'll just find out, Your Lordship, and we'll provide the police address of the police station, Your Lordship. Abhi nikal ke do, फटाफट.
So and so appearing for the petitioner. So and so appearing for the alleged contempt. This court find that several orders have been passed by this court for appearance of the alleged contemptors before this court. Lastly, on 11th of June 2025, this court has directed the alleged contemptor namely Diwakar Sharma, Dipesh Godha, and Mr. Rajesh Pipalwa to appear before this court today at 10:30 a.m. and the case is especially fixed at 10:30 a.m. for personal appearance of the alleged contemptor. When the matter is taken up today, the learned advocate on record of the alleged contemptor submit that they are the busy persons and are the directors residing at Pune, Madhya Pradesh, and
Lordship, if I am not mistaken, subject to correction, Lordship, Gujarat, if I am not mistaken.
all are Gujarat.
No, Lordship, three different places.
That's why Pune, Madhya Pradesh, and
Gujarat, if I am not mistaken.
And Gujarat. All the three alleged contemptors are present through the virtual mode. Instead of appearing before this court in person in compliance of the order passed by this court. In view of the above, let the warrant of arrest be issued against Sri Diwakar Sharma, Dipesh Godha, and Rajesh Pipala for bringing them under arrest of arrest before this court. The petition is directed to take appropriate steps and to file requisites in the department for immediately for issuance of warrant against the said person through the SP of concern area where the alleged contemptors are residing. Let the matter appear on 26th of June 2025.
Grateful.
Not 10:30. Contempt mirror. Yes.
My lord, this is my suit, my lord. It's appearing at my instance. I'd mentioned it yesterday, my lord. If your lordship takes your lordship's order of 17 June 2025, their application, which is GA3, which was for amendment of their written statement, come counterclaim in my suit. My lord, they had sought for an adjournment, my lord. Your lordship had kept it in September. Yesterday, I mentioned it. Your lordship said that once the order is uploaded, your lordship will. My lord,
Yes,
my only
but your counterpart is not able to file the affidavits. What can be
My lord,
done?
affidavits are done.
So, no, they are not able to.
My lord, kindly dismiss the application then. My lord, my plaint cannot.
My lord, kindly take it up next week, my lord, any day, my lord, subject to your lordship convenience. Only,
Saturday?
my lord, only on.
I'm fixing Saturday, 10:30 to 4:30. Whole day I will give the time to you as per your convenience. I am also free. You are also free.
My lord, I'm sorry, my lord, but kindly, my lord, any day, my lord.
Don't worry, I will not ask for the lunch and dinner. I will manage for my lunch.
The application is otherwise ready, my lord, if your lordship keeps it any.
So and so suffering for the plaintiff, so and so suffering for the defendant. By on the matter is mentioned by the learned counsel for the defendant.
Plaintiff.
For the plaintiff. Plaintiff and submit that this court by an order dated 17 June 2025 has fixed the matter in the combined monthly list of September 2025, but there is an urgency in the matter and prays for fixing a specific date and time so that the application number GA-COM 3 of 2025 can be disposed of. What about the GA7?
My lord, it's CS-COM 7. It's the suit.
Achha, only one application.
One application, their application.
In view of this submission made by the counsel for the parties, counsel for the plaintiff, let the matter appear. क्या date है? At 24th of July at 12:30. for hearing of GA3 of 2020.
My lord, if your lordship kindly fix it on 25th, my lord, instead of 24th.
Again,
Only, my lord, one day, my lord, 25th, my lord.
25th, I don't think my diary will permit. Hey, 25th में 25th कर दो.
Well, 25th, 12:30. Deeply.
Yes. Yes. Have you taken steps for warrant?
Well, yes, my lord.
My lord, I appear, my payment has been done. The warrant, my lord, has whatever, my lord, the order of the court has prevailed. Payment has been done. Very, very precarious situation for me appearing for a judgment debtor in trying to, my lord, defend
This
the
court.
warrant in this
Before
court.
this court.
Before after the earlier two matters. I was telling my learned junior that today there might be missiles and we don't even have any apparatus to protect us. But thankfully, my lord, our client has done the needful. He has put in the entire principal amount. Has been given. There's only one. There's only one. I can't even say it's a prayer. It can't be a prayer. There's a soliloquy, if your lordship kindly permits. There is an interest at the rate of 12% per annum, which has been given by your lordships. That was perhaps because in one of the mails, the client volunteered to pay interest at the rate of 12% or something like that.
Yes.
I have not gone through the judgment in detail. We don't wish. I have advised that there should be no left or right in this. My learned friend is appearing on behalf of the decree holder. He's entitled to the last naya paisa. But I am only making a prayer. I'm wondering aloud.
When you will pay the interest? Tell me
The
directly.
remaining part, if he can consider a bit, and come say a 9% or an 8%, then perhaps this I can't make to court. I'm not making this prayer to court.
That is up to you.
Right, Mr. Banerjee, my lord, coming from Mr. Banerjee, my lord, he knows the law. This court cannot go beyond the decree. Neither, my lord, I am also, my lord, bound by my client's instructions, my lord. My lord, this, my lord, may I just make my submission here, my lord? This judgment debtor, my lord, made payment immediately upon receipt of knowledge that the warrant of arrest has been issued, my lord. It's only a matter of few clicks, my lord. He has, my lord, I'll just indicate what assets does he have, my lord. 20,000 crore is the net worth of this company, my lord.
This company
My lord,
doesn't have any net
yes,
worth,
yes,
but kindly don't bother. I have ensured and I will ensure that appropriate payments are made.
Yes.
Entire principle
I
is
am
paid.
bound to make this statement because of the submissions. My lord, kindly takes, my lord, these statements.
Submissions were for you
May
to
I,
see whether you
Mr.
can
Banerjee,
consider.
may I?
No,
You make your submission, then I can reply. Let's not speak together.
No, he is only asking whether
I am
it
saying
can,
whether
the concession can be given.
Have I ever
This
said
has
that?
been-
I have never even looked at the tabular statement when I made this submission, and I'm saying it's not a submission; it's almost a soliloquy for you.
No, my lord, I think the clients had negotiated, my lord, and this request has been refused, my lord. Kindly takes, my lord, one aspect of the matter, my lord. This payment has come from one Mr. V. Sengu Vatan, my lord, who is one of the directors of the judgment debtor. So, my lord, I don't want a situation tomorrow, my lord, a suit is filed against my client saying return my loan that I've given you. So, my lord, let this be recorded that the judgment debtor, my lord, has not paid it. It's some director who has paid from his personal account. One. Second, my lord, the balance, my lord, is a sum of rupees 62,87,000, about 400 rupees, my lord. My lord, kindly let them, my lord, make payment and let this litigation come to an end immediately, my lord. It's only a matter of, my lord,
I can only appeal to him or to his client. I can't make a statement in court in support of a judgment debtor who suffered a warrant of arrest that the court will mitigate the interest. Executing court cannot, and I'll not make that submission. I am still hoping and wishing aloud that if my friend's client can consider this in a day or two, I made sure that they arrange the money from somewhere or the other, because I said I am not going to go up before this honorable court saying that I am in support of a person who's suffered a warrant of arrest. Kindly do not execute it. I undertake to pay. I said no undertaking. Money goes from X account to Y account.
Okay. I am accepting
I
this.
am-
I am fixing after 4.
My lord, my client is here. My lord, may I say this?
Fix it after a photo.
My client is here. I have taken instructions. My client is not willing, my lord, to give any concession, my lord. Kindly fix a date for balance payment. I mean, it's very clear, my lord, straight away.
Today the weather
After
is
that
not
degree,
good.
this court cannot go.
Yes. Today the weather is not good. Maybe within 2 weeks the weather will improve. Let it come after 2 weeks. If he doesn't Definitely. So they went to hobby. Entire principal amount, Lord.
Judgment debtor and decree holder. So offering for the judgment
কত
debtor.
কত দিয়েছি আমি?
Concept for the judgment debtor submitted out of the total decretal amount of rupees 2 comma total decretal amount along with the interest of rupees 2 comma 08 comma 87 comma 399.20 comma the decree holder has paid rupees 1 comma 46 comma 00 comma 000 and by leave and the balance amount of 20 to the decree क्या बोला? Judgment debtor has paid. Judgment debtor has paid rupees 1 comma 46 lakh crore 1 crore 46 lakhs, leaving the balance amount of rupees 62 lakh 87,399.20. Counsel for the decree holder submitted. The decree holder has received an amount of 1 comma 46 crore 1 crore 46 lakhs, but it is found that this amount has been transferred from the account of one of the director of the company and not from the account of the company, and as such the amount which the decree holder has received shall be treated the amount received from the company. Counsel for the judgment debtor prays for 2 weeks time to pay the remaining amount.
To pay the remaining amount
under the decree.
Under the decree, unless he is able to convince Lord. Can you keep that slightly open? I will still
Pay the remaining amount. If otherwise the parties will settle the issue outside of
Very well.
I am obliged. Deep Lord, that keeps the window open, my Lord. Today is bad weather. Tomorrow it will be good, I hope.
In view of the above, full stop. Let the matter appear on 22nd of July 2025. Okay.
Can it be slightly shorter, my lord? Can it slightly shorter?
First week this court might not be there.
Very well.
22nd.
As well.
22nd.
Though the decree holder has paid the amount, accordingly warrant issued against the decree judgment debtor has paid the amount. Accordingly, warrant issued against the judgment debtor is recalled.
Very well.
Judgment debtor and its director.
Warrant issued against the director for the present.
Very well. Deeply obliged.
I've never seen my lord as angry as today. But that's a compliment for an executing court.
I'm deeply obliged.
Sorry, my lord. So sorry, again, my lord. So, my lord, that item number 1, my lord, I think it was fixed on 23rd June, my lord. I'm told now, my lord.
23rd July.
No, June, my lord, because they're not there in June. It was only fixed, my lord, for the purpose of fixing a date.
It's fixed.
That's one of the impression we got, my lord, all of us. Even the other side.
23rd July में कुछ है क्या? June में क्या है?
That's what, my lord, the advocation and, my lord, the others. Only, my lord,
Date
for
fix
fixing
के लिए
date.
ना? रहने दो. Within bracket fixing date करके.
Yes, that's what my lord had said also.
June fixing.
I'm so grateful. I'm so sorry, my lord. I didn't want to.
Yes, next.
So that's what. Grateful.
Sued for recovery money on account of money lent in advance. Lordship, leave under clause 12. Lordship, this plaint was presented before your lordship earlier. Your lordship, after hearing the injunction application, was pleased to return the plaint to be presented before the commercial division. So, your lordship, we have come after the non-starter report. Your lordship's order in the previous suit is at page 93.
93.
Lordship, observations at page 109. Last paragraph 26, where your lordship observed that this matter
on merit.
Lordship, it's a commercial matter. Therefore, your lordship was pleased to return the plaint to be presented before the commercial division. Your lordship, we went for pre-institution mediation. A non-starter report is also there. And your lordship at page 111.
Yes.
Lordship, only leave under clause 12, which was earlier granted by your lordship. The pleading is at paragraph 55.
Record. So bring for the plaintiff. The plaintiff has filed the present suit, praying for a decree for a sum of rupees 3,44,95,551 along with interest. Interest will the counsel for the plaintiff submitted part cause of action arose within the jurisdiction of this court and part cause of action arose outside the jurisdiction of the court. Accordingly, the plaintiff has prayed for leave under clause 12 of the latest patent. In view of the submission made by consider the submission made by the counsel for the plaintiff, peruse the pleading and the documents. Leave this court find that part cause of action arose within the jurisdiction of this court and part cause of action arose outside the jurisdiction of this court. Accordingly, leave under clause 12 of the latest patent is granted. Plaintiff is admitted subject to scrutiny by the
Grateful Lordship.
Item number 5, my lord, I am for the plaintiff, my lord. The suit for recovery of money arising out of a business transaction. The plaintiff has sold the goods and delivered to the defendant. Defendant has received, and upon receiving of the goods, my lord, defendant has issued the checks which were dishonored.
How it is a commercial suit?
Arising out of a commercial transaction, goods sold and delivered.
Goods sold and delivered. Okay. When the last payment was made, sir?
My lord, no payment has been made, my lord. When
the last material was supplied?
It was supplied, my lord. And in between, my lord, September 20, the transaction between July to September 2024, my lord. My lord, immediately, my lord, upon receiving of the goods, my lord, defendant had issued the check to the plaintiff, my lord. All the checks were deposited to the bank, my lord.
When the check was dishonored? Have you mentioned?
Yes, my lord, it is mentioned, my lord. We have annexed chart, my lord, here also. First, October in we have annexed a chart, my lord, that is in page 179.
But you have not disclosed the check.
Yes, my lord, it is annexed, my lord, 31st July, since 31st July, my lord, till 8th August, my lord. During that period, my check were deposited, my lord.
Yes, fine. So what?
My lord, there is a prayer of under clause, leave under
Why clause 12?
Well, the defendant, the plaintiff's office is within jurisdiction, my lord. But the defendant's office is outside the jurisdiction. All the payment orders was placed from the office of the plaintiff, and the checks were deposited in the bank of the plaintiff, which is in jurisdiction of this honorable court, my lord.
Supreme Court, the plaintiff. The plaintiff has filed the present application suit, praying for decree for a sum of rupees 45,80,749 along with interest at the rate of 18% per annum. Counsel for the plaintiff submitted where is the premediation process non-starter report?
That is the last annex, my lord.
Part cause of action arose within the jurisdiction of this court and part cause
that is in page 189, annex L, my lord.
Outside the jurisdiction of this court. Outside the jurisdiction of the court. Accordingly, plaintiff has prayed
for paras in volume 2, my lord.
The latest patent. At the learned counsel for the plaintiff peruse the pleadings and the document. This court finds that the part cause of action arose within the jurisdiction of this court and part cause of action outside the jurisdiction of this court. Accordingly, leave under clause 12 of the latest patent is granted. Plaintiff is admitted subject to scrutiny by the department.
This is a similar kind of nature, my lord. Goods, owns and
how many suits you have filed?
3 suits, my lord. My lord, the Molar is the parties are the same, my lord. The name of the company is different, my lord. The
plaintiff is same.
Yes, my lord. But not the plaintiff is same, my lord.
Plaintiff is different.
Plaintiff different, my lord. The partners are same, my lord. The two different entity, my lord. Same goods, owns and delivered, my lord. Checks were issued, my lord. All the checks were deposited. All the checks were dishonored, my lord.
तीनों में कर देना. Same order 6 and 7 also. Admitted subject to scrutiny.
Great.
My lord, this is my suit for permanent or injunction and declaration. My lord, I am representing a consortium of 10 banks. My lord, here, my lord, I am praying for 2 leave, my lord, under clause 12 and 12A of the Commercial Code Act.
Why 12A?
My lord, 12A, because my lord, what has happened, the transaction is of such a nature, primarily this suit is against the guarantors who had showed me certain kind of an asset which they were holding, on the basis of which loans were extended by me. Now, my lord, now today in May 2015, after carrying a deep forensic audit, it has transpired that the asset on the basis of which actually I had parted with substantial public money, they are now alienating and parking it somewhere else. It has gone to their family members, it has gone to the entities owned by them and few companies in Hong Kong.
How it can be parted with? Because you have not kept them this documents on lien.
My lord, this was a guarantee on the basis of a net worth certificate where these assets have been shown, showing that look, my liquidity is so high and I am having such assets, I am holding such assets, monies have been taken from me. My lord, today my claim vis-a-vis the entirety of the account is almost 2,934 crores. My lord will kindly come to page 59.
So why you are not initiated the surface?
My lord, vis-a-vis the main company, proceedings before the NCLT has been initiated. So, my lord, a portion of the amount has been recovered therefrom, but my lords, the guarantors are also there today. So, my lords, they are also entitled to, as per the loan documents, to repay the balance sum of money which the bank has not yet recovered. And my lords, this is happening on purpose. They are alienating the assets and coming and telling the banks that I have no funds or no assets with me. And when we actually carried out a forensic audit, it appears that those assets, which are valuable shares of a company, they have transferred it to their wife. Wife has transferred to a company in control of the wife. That company again transfers it to another company. And now some of the assets are actually being held by a company which is in Hong Kong, again owned by them. That is the problem.
Where is the forensic report?
My lord, the forensic report is there. My lord, I have pleaded about the forensic report at page 60. My lord, page 60, line, fourth line. The preparation of the said forensic report took a considerable period of time. My consultant ultimately handed over the report on or about 15 May 2025. And my lord, this it is certain from the report. The entire web of transaction has now been placed before the plaintiffs, the 10 public sector banks.
Public sector banks.
My lord, all the plaintiffs are PSUs, my lord.
And who are the defendants?
My lord, defendants are primarily guarantors, their family members, entities in control of them, and few companies also in control of them but situated abroad.
Who is the principal borrower?
My lord, principal borrower is defendant number 27. Well, a meager amount of money has been recovered vis-a-vis defendant number 27 through the CIRP process before on NCLT.
Kanpur.
Well, now they have shifted their registered office address after the CIRP process is complete.
From where the loan was obtained?
Well, loan was obtained, my lord, from Calcutta.
Yes.
Ultimately, it's only a try. Ultimately, it will be a Vijay Mallya 2. It's only a try, Miller.
That's
why now
that-
everyone has become clever. So
that's why I'm saying
insolvency is took time. So Miller, it's A to B, A to B, Miller B to B's family, Miller B to his company held by B's family members, thereafter to a foreign entity which is actually controlled by him. So now people have become clever. If Lordship goes, Miller, we advocate goes for a car loan, Miller, how many things are asked? People have now become clever. They show X in their balance sheet, Miller, at the time, Miller, obtaining loan. Miller, on the basis granted, after obtaining loan, Miller, A to B, B to B's family member, then C's family member who has a company in Hong Kong. Miller, its shares have all gone there, which is actually held, Miller, by A's son, Miller, which is in A's in control.
So that I don't have any remedy, my lord, before IBC, I have to file, my lord, the old process suit, and it will take years to come.
Why you not gone to the IPC?
I've gone, I've recovered nothing against the main company.
So what you will find from here?
My lord, at least, my lord, the shares, my lord, it's defend number 26, my lord. If I get some restraint order, they may come to the table, my lord. That's the
Shares are there in,
my lord, the shares of the defend number 26, which is the prime company.
that is there.
It's functioning. Now they were holding size shares, my lord, in different number 26, gave it to their wife gave to the controlling company, they gave it to Hong Kong company. Well, that's the reason, my lord. Now Supreme Court, we are, my lord, fortified. Supreme Court says don't dismiss the suit, keep it in abeyance. That's Dhanbad fuel.
Senses when suffering for the plaintiff. The plaintiff has prayed for leave under clause 12 of the latest patent 1865 on the ground that part cause of action arose within the jurisdiction of this court and part cause of action arose outside the jurisdiction of this court. The plaintiff has also paid for leave under clause 12 under section 12A of the Commercial Court Act. Commercial Court Act on the ground that the plaintiff has obtained have obtained the forensic report only on 15th May 2025, wherein the plaintiffs came to know the defendant number 1 to 25 in general and defendant number 1 to 4 in particular are seeking to deal with, alienate and transfer their shareholding assets and the properties in various companies and the entities including the defendant number 26. Counsel for the plaintiff submit that if the plaintiff will go for the mediation process, there is every chance that in the meantime the defendants will transfer their all shares and assets, and the plaintiff will be badly prejudiced if in future the plaintiff will file the suit. Considering the submission, made by the counsel for the plaintiff for use the pleading, this court find that sufficient pleadings have been made to a grant of leave under section 12 capital A of the Commercial Court Act. Considering the above, leave under clause 12 of the latest patent 1865 as well as leave under section 12 capital A of the Commercial Court Act is leave under clause 12 of the latest patent and it is granted and leave and dispensation dispensation under section 12A of the Commercial Court is also granted, taking into the considering the urgency pleaded in the plaint. Full stop. Plaint is admitted subject to scrutiny by the department.
Order to. I'm in process of filing the yes.
Filing.
I apply for the plaintiff.
Yes.
14 and 15. But today morning.
Number?
14 and 15, both of them will take together. Today morning, we have received an email from the advocate of the defendants saying that they are withdrawing from the matter. This is the email we have.
You are for the defendant.
I'm for the plaintiff. Lordship on the last day directed them to file an affidavit disclosing what property they have, whether the property is encumbered or not, what is the value of the property. And today morning we received this. They are avoiding the court, Lordship may protect me to the extent of the prayers made in this application.
Due to compelling, I have tendered my no objection certificate in CS Council. I am no longer appointed to defense. Sense appearing for the plaintiff. None appears on behalf of the defendant. Counsel for the plaintiff submit that today morning, the advocate on record of the plaintiff has received an email from the advocate on record of the defendant, wherein it is mentioned that due to compelling circumstances, it was informed that the appearing advocate representing the department is withdrawing from this suit on behalf of the defendant. Let the email dated 19 June 2025 be kept with the record. As the advocate appearing for the defendant has withdrawn his power on behalf of the defendant, accordingly, plaintiff is directed to issue notice upon the defendant, informing the next date of hearing and file the affidavit of service on the next date fixed. If after receipt of the information, none appears on behalf of the defendant, suit will be proceeded accordingly.
Will your lordship kindly make one observation as till the next date, the defendant will not take any step which would have any effect on this application.
That's why I have told you. That's why I have
Till the next date.
What?
There is no till the next date. If the defendant could not transfer any sum mentioned in this application, that's till the next date.
Already order is there.
No, that's the previous order lordship had passed in respect of one of the bank accounts. We do not know whether that bank account has any balance or not.
As the advocate appearing for on the last occasion, the learned advocate appearing for the defendant has given undertaking before this court that he will file the affidavit disclosing the details of the accounts and valuation of the property, but has not filed the same and has withdrawn his power. According, the defendant is restrained for the time being for dealing with any of the property and the bank account till the next date of hearing.
I'm grateful. But one correction.
Leave the matter on.
Sorry.
On 27th June.
Two corrections in your lordship's last order. 12th June 2025 order, if your lordship takes paragraph 3, at the last line, the order dated 10 September 2020, it would be 2024. And one more correction in paragraph 5 of this order. The second.
Counsel for the plaintiff press for the defendant press.
Defendant.
Record an order. Counsel for the plaintiff draw the attention of this court to the order dated 12th June 2025, wherein in paragraph 3, the date, the last line, the date is wrongly recorded as 10th September 2025 instead of 10th September 2024. Thus, the date shall be read as 10 September 2024. Simultaneously, in paragraph 5 of the order dated 12th June 2025, this court has recorded the plaintiff press for 3 days time, but it should be recorded as defendant press for 3 days time. Accordingly, in paragraph 5 shall be read as the defendant press for 3 days time instead of plaintiff press for 3 days time.
Grateful.
My lord, 16, my lord, I had almost concluded, my lord, my application for leave to defend. Only one thing that I wanted to point out. Only one thing I wanted to point out, my lord, that it may be that my application is premature, because I would like to contend that the writ of summons under Form 4, which was served on me, was not done in accordance with Order 37. Order 37 says, my lord, the plaint has to accompany the writ of summons and it has to be served on me. Now, my lord kindly takes the plaint once. My lord will see, kindly comes to page number 13 of that plaint. Page number 13 of the plaint, my lord.
Yes.
My lord will see that when the plaint was filed, there was a mistake. Documents relied upon by defendant, that was changed to plaintiff. Now, that is, the correction is there in my lord's plaint. My lord will see that the application for leave to defend that I had filed is numbered GA2. There was a GA1. That GA1, I believe, was taken out by the plaintiff. I did not find any orders uploaded on the website. My lord, I believe that certain corrections were made or amendment was made. The plaint which was served on us, my lord, was the unamended one. I have got the original writ of summons which I have received, my lord. My lord will see this writ of summons was issued sometimes in September 2024, 9th of September 2024. This, I believe, was subsequent to, my lord, the corrections being made in the plaint. The plaint that I have, my lord, the original printed copy to the
Yes.
the plaint that was served on me with the writ of summons, my lord, is the one without the corrections. Now, my lord will also see the last order. My lord will see, my lord had passed an order on 5th of July 2024 prior to issuance of the writ of summons, by which, my lord, 8 defects were permitted to be corrected. That, my lord, will find in my lord's order of 5th of July 2024.
5th of July?
5th of July 2024.
So দেখো suit my 5th
এই
of
order
July
order আছে 5th of July 2024 টা আমাদের কাছে আছে, do we have it? My lord will see as many as 8 defects were found by the department, my lord, and leave was given to correct, and this was corrected, I believe. Thereafter, my lord, the writ of summons which was sent to me, my lord, was not with the corrected plaint but with the uncorrected plaint. So the writ of summons was not served in accordance with, my lord, the provisions of order 37, which is extremely strict. Now, my lord will see another order was passed by my lord on 28th of April 2025, where my lord found out that there was this discrepancy, and my lord directed service of the corrected copy of the plaint on me, which was done so under a forwarding letter of, my lord, 28th of April 2025. On the same day that the order was passed, on 28th of April, my lord had directed them. I have received the corrected plaint now. But fact remains that the writ of summons which was sent to me was not with the correct copy of the plaint. I am supposed to take out my application for leave to defend within 10, enter appearance within 10 days after being served. That service, perhaps, my lord, that my lord will decide, is perhaps not in accordance with order 37. My lord knows that order. Yes,
it's correct. I can accept your submission, but after the 28th April, when the corrected copy was served to you?
Yes, my lord.
When the copy was served?
28th of April itself, on that day itself, yes. But that was not accompanied by the writ of summons as per order 37. It's a very technical point. I understand. I leave it to my lord. I'm just saying that my application today, that may itself be premature. The time might not have come, because my lord will see if there was a question, if there was an order saying that the writ of summons was waived or service was not required. Because if it is 10 days or 11 days, I have sought for condemnation of delay of 1 day. Even that is being objected to by my learned friend. I had to take all points on behalf of my client. I have taken it. Now I'll leave it to my lord. That's the last point that I had. That's why I might say that I'll finish it in 5 minutes. And I had, my lord, indicated on the last occasion yesterday, my lord, that defendant number 2 is a director, should not be saddled with a decree in respect of a loan granted to defendant number 1 company. I conclude my submissions, my lord, on behalf of the.
May I start?
দেখি বলে কত করে বলছি তুমি তো আজকে বলবে না পরে বলবো সাড়ে 9টা ফিক্স
হ্যাঁ বল যা বলবেন জজ সাহেব হোয়াটএভার ফিক্সড আছে ঠিক খেয়াল করে
আমার এছাড়া আর কিছু বলার ছিল তুমি সিনিয়র ব্রাউন থেকে পয়েন্ট দিতে পারো না
Yes.
When I start that whatever I don't know whatever I can start tomorrow, I can start now.
Come tomorrow.
And that will be as well. And finish it in 15-20 minutes tomorrow.
Each one কি মামলা না আমাকে
আজ 2 p.m. 2 p.m. you are free?
2 p.m. আসবে করে দাও
Come at 2 p.m.
2 p.m.
Come at 2 p.m.
হ্যাঁ tomorrow 2 p.m. আজকে 2 p.m.
আজকে 2 p.m.
Then the material instruction is single or double.
Can I keep to 2 p.m.?
No, 2 p.m. 2 p.m. 2 p.m. আজকে করে দেবো ready I'll do it today only.
Okay.
Grateful to my lord.
Do it today only.
Next.
My lord, may I take the original writ of summons back, my lord, and the ওটা আমাদের
ওটাও কি হচ্ছে
Witness action.
No problem. কালকে একটু বেশি ছিল।
নাম হচ্ছে ললিত আগরওয়াল।
Resume, huh?
ঠিক resume।
Page 18.
30.
Page 18 to insurance policy. 88. Page 84.
Yes.
Yes, Manoj. So
Start.
kindly give me one more. Page 84. Copy of the insurance policy. But yesterday, but till page 83 of the judge's brief of document were adduced. But may I start from 83 of 83 of the which shown a document, a copy whereof appears at page 94, page 84 to 93 of the judge's brief of document. Please tell my lord as to what is this document.
The first is the insurance policy issued by United India Insurance Company Limited.
Insurance policy issued by
United India Insurance Company Limited in favor of Austin Private Limited, valid up to
Austin Private Limited.
Austin OSTERN Private Limited, valid up to 3rd August 2020. And the second set of attachment is quotation for the fire policy issued by our broker, which is the basis for issuance of the main policy.
Yes.
What do you have to say about the contents of these document?
They are true and correct.
How have you obtained this document?
These are photocopies of the second set is photocopy of the email. The first one is a copy of the policy, which is original is already submitted.
But may this document be tendered in exhibit?
Exhibit W.
It's the original document which is produced.
Exhibit W.
Collective.
Collectively.
Collective.
Shown a document, copy whereof appears at page 97 to 102 of the judge's brief of document.
These are newspaper clipping.
Excellent. What is this document?
What is this document?
These are newspaper clippings regarding Amphan, which caused havoc in the state of West Bengal and Odisha on 20th and 21st May 2020.
How have you obtained this document?
These are the newspaper clippings, photocopies of the newspaper published.
Who has made the photocopy of this
newspaper clippings?
Photocopies of the news published.
I have made the.
Who has made the photocopy of this document?
I have made the photocopies.
Yes, next.
What do you have to say about the contents of this document?
They are true and correct.
May this document be tendered. The newspaper clippings.
Exhibit X.
These are photocopies made from.
Check for identification.
Very.
X for identification.
Start from 94 to 102 मतलब
97 are the newspaper clip. Shown page 94 to 96 of the judge's brief of document. 94 to 96. What is this document?
Page number 94 to 95 is the information given to our insurance broker by email dated 26th May 2020 regarding the damage, and the mail dated 26th May 2020 at 19:17 hours, forwarding the same mail by our insurance broker to the insurance company.
What do you have to say about the contents of this document?
The photocopy of the emails, original, have been submitted yesterday.
Do you stand by the statements made in your emails?
Yes.
Have you given any affidavit under section 65B of the Evidence Act 1872 in support of this document?
Yes.
May this document be tendered.
Exhibit X. না ওটা তো হয়ে গেছে এটা Z Y exhibit Y page number 94 to
Shown page 103 to 106 of the judge's brief of document.
103
to 10.
What is this document?
This is an email from me to the insurance surveyor, Kothari Insurance, dated 17 June 2020, giving reply to their queries. One 103 to 106. And on page 105 is an email dated 27 July 2020 from me to the Kothari Insurance Surveyor, giving reply to the email.
What is the document appearing at page 106?
Page 106 is the reply to the email of Kothari Insurance Surveyor, written by me to Kothari Insurance Surveyor.
What do you have to say about the contents of these documents?
They are true and correct.
Have you given any affidavit in support of affidavit under section 65B of the Evidence Act 1872 in support of these documents?
Yes.
May this be tendered. 103 to 106.
Z
Shown page 107 of the judge's brief of document. What is this document?
This is a brief profile of the company Austin Private Limited.
Who has prepared this document?
I have prepared the document.
What do you have to say about the contents of this document?
They are true and correct.
Is this the original document?
Yes.
May this be tendered.
exhibit AA
Shown a document, a copy whereof appears at page 108 of the judge's brief of document. What is this document?
This is a letter written by me to Kothari Insurance Surveyors, attaching there with a pen drive containing 9 photos and 6 videos.
Where are the attachments of this document?
The attachment is submitted to the surveyor and a copy is also exhibited.
What do you have to say about the contents of this document?
They are true and correct.
Do you see any signature on this document?
Yes. Is signed by Kothari Insurance Surveyors, dated 18/6/2020.
Do you see any other signature on this document?
Yes, it is signed by me on behalf of the plaintiff.
Can you?
On behalf of Austin Private Limited. Austin Private Limited.
Can you encircle your signature on this document in red ink?
Yes.
Yes. अपना signature.
May this be tendered.
Exhibit BB.
Yes, next.
Shown documents appearing at page 109 to 118 of the judge's brief of document. What are these documents?
But
109 to 118.
Page number 109 is the floor layout of the ground floor of Austin Private Limited. Page number 110 and 111 are the machine floor plan pertaining to thin wall container manufacturing unit of Austin Private Limited. কত পয়সা যাচ্ছে?
118.
Page number 112 is the manufacturing flow diagram for the thin wall containers. Page number 113 to 118 are the production reports on 20th March 20, 20th March 20, 19th May 20, and 20th May 20. That's it.
Who has prepared this document?
I have prepared the documents.
What do you have to say about the contents of this document?
They are true and correct.
Would the defendant have a copy of this document?
Yes, it has been submitted in the claim file.
How was it? Well, may this be tendered.
Exhibit CC collectively.
Shown a document, copies whereof appear at page 119 to 142 of the judge's brief of document. What is this document?
This is audited annual accounts of Austin Private Limited for the financial year ending on 31st March 2020.
Who has prepared this document?
These are the copies of the audited accounts prepared by the company and signed by the auditor.
Do you see any signature on the on these documents?
Yes.
Whose signatures are they?
The balance sheet is signed by 2 directors of the company namely Mr. J.P. Agarwal and myself, and countersigned by the Chartered Accountant, Mr. D.R. Agarwal, on behalf of Agarwal Maheshwari and Company. Agarwal Maheshwari and Company, a chartered accountancy firm.
How do you know that these documents have been signed by the other persons except yourself?
The signature are known to me in the usual course of business.
Can you encircle your signature on this document in red ink?
Yes.
All the pages.
All the pages. All the
My lord, the signature of the chartered accountant, that cannot go, my lord.
His signature.
his own signature.
His signature. His own
His,
signature.
yes.
His encircle of his own signature.
Even the other signatures can go in. It would be in a different ink. Even the other signatures would go in if he has vouched. Kindly encircle the signature of the other persons you have named in answer to the previous question.
Stated, but you put that type of question.
But he has answered that
What?
he knows the signature and the signatures are known to him. He has answered.
What is the answer? Who signed? And he mentioned. Okay.
That is why I put it this way.
That will go.
Lord,
Blue ink.
I object to this.
Okay,
I also
that
go.
will-
I also go by the affidavit of admission and denial of the documents, but at the same time, I object to this.
Signature of only auditor.
Yes, my lord. Because director may be known to him because he is.
Signature of ठीक है वो करने दीजिए. Signature of director
Second.
is objected by the defendant. Signature of the auditor.
Yeah, Mr. J.P. Agarwal. Another guy.
Now it is encircles the signature of Mr. J.P. Agarwal, blue ink.
Yes. Next.
What do you have to say about the contents of this document?
They are true and correct.
I am showing a document, copies whereof appear at page 143 to 167 of the judge's brief of document.
No.
After the vote. থেকে 167. 143 থেকে
This is
Yes.
This is audited annual accounts of Austin Private Limited for the financial year ending on 31st March 2019.
Who has prepared this document?
This prepared by the company and signed by two directors of the company, namely Mr. J.P. Agarwal and myself,
Yes.
and countersigned by the auditor, Mr. D.R. Agarwal, on behalf of Agarwal Maheshwari and Company.
How do you know that the persons named by you have signed the document?
Because they have been signed in front of us.
What do you have to say about the contents of this document?
They are true and correct.
Kindly encircle your signature on this document in red ink.
Dependent document exhibit हुआ.
But I'm seeking, there are similar documents, 3 documents. I'm seeking to exhibit all of them together.
Not similar objection I will give to this.
Signature of the auditor is objected.
Kindly also encircle the signatures of other persons named by you in blue ink.
I'm signing for encircling for Mr. JP Agarwal as well as the auditor of the company
In blue ink.
in blue ink.
Look, accept it.
Accept it.
Yes, next.
Is this the original document?
There is a copy of the original document.
Who has made the copy?
I have made the copies.
Shown a document copies whereof appears at page 168 to 188 of the judge's brief of document. What is this document?
This is audited annual accounts of Austin Private Limited for the financial year ending on 31st March 2018.
Who has prepared this document?
This document is prepared by the company and countersigned by me and another director, Mr. JP Agarwal, countersigned by the auditor of the company, countersigned by the auditor of the company, Mr. DR Agarwal.
What do you have to say about the contents of this document?
They are true and correct.
How do you know the signatures of the other persons named by you in answer to the previous question?
They are known to me in the usual course of business.
Please encircle your signature on this document in red ink.
My lord, same objection. My lord.
एक साथ ही करते हैं, बार-बार लिखना। हाँ, 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 हाँ।
Yes,
Is this the original document?
The copy of the original document.
already stated.
Already.
Yes, the previous question. Or a document again?
First question, see? No. Take
The previous document. Who has made the photocopy?
I have made the photocopies.
Contents?
None.
What do you have to say about the contents of this document?
They are true and correct.
But the documents appearing at pages
109.
sheet gulo 119 to 188 may be tendered.
As exhibit DD collective.
Shown a document copies whereof appear at page 189 to 197 of the judge's brief of document. What is this document?
This is the monthly stock statement submitted to Axis Bank for the 30th for the month ending on 30th November 19 by Austin Private Limited.
Who has prepared this document?
I have prepared the document and signed by me.
Can you encircle your signature on this document? What do you have to say about the contents of this document?
They are true and correct.
Do you see? Sorry. Do you see any other signature appearing at page 189 of this document? Any other signature or stamp?
Yes, it is acknowledged receipt of the same by Axis Bank Limited on 24th December 2019.
How do you know that it was received by the Axis Bank?
Because we have to submit every month.
Is this the original document?
Yes, this is the original document.
May this be tendered.
Exhibit E.
This is original of the office copy. Original office copy.
Original office copy.
Exhibit EE.
আরেকটা প্রশ্ন যাবে। How was this office copy made?
Is made from the photocopy of the original document which we submitted to bank.
Shown documents copies whereof appear at page 198 to 206 of the judge's brief of document.
This is again,
what is this document?
This is again stock statement for the month ending on 31st December 2019 by Austin Private Limited for the thin wall container division submitted to Axis Bank Limited.
Who has prepared this document?
I have prepared the document.
Do you see any signature on this document?
Yes, it is signed. This is signed by Mr. JP Agarwal, another director of the company. Yes.
How do you know his signature?
It's known to me in the usual course of business.
Can you encircle his signature in blue ink?
Witness encircles the signature of JP.
What do you have to say about the contents of this document?
They are true and correct.
Is this the original document?
This is a copy of the original document. Submitted to the bank is a office copy original.
How was this office copy made?
It's a photocopy of the original document which we submitted to bank.
Who made the photocopy?
I have made the photocopy.
Do you see any other signature and stamp on page at page 198 of the judge's brief of document?
Yes, it is acknowledged receipt by Axis Bank Limited on 13 January 2020.
How do you say so?
It has been submitted to them in the usual course of business every month.
May this be tendered.
Exhibit FF.
Shown documents, copies whereof appear at page 207 to 215 of the judge's brief of document. What is this document?
This is again stock statement for the month ending on 31st January 2020 for the thin wall container division of Austin Private Limited, submitted to Axis Bank Limited.
Who has prepared this document?
I have prepared the document.
Do you see any signature on this document?
Yes, I have signed the document.
Can you encircle your signature in red ink? What do you have to say about the contents of this document?
They are true and correct.
Do you see any other signature and stamp at page 207 of this document?
Yes, it is acknowledged received by Axis Bank Limited on 13 February 2020.
How do you say so?
And it is the office copy original.
How do you say that it was received by the Axis Bank?
The signatures and stamps are known to us in the usual course of business.
Who made the office copy?
I have made the office copy from the original.
May this be tendered.
Exhibit TG.
Shown documents appearing at page, copies whereof appear at page 216 to 224 of the judge's brief of documents. What is this document?
This is again a stock statement for month ending on 29th February 2020 for the thin wall container division of Austin Private Limited, submitted to Axis Bank.
Who has prepared this document?
I have prepared the document.
Do you see any signature on this document?
Yes, it is signed by Mr. J.P. Agarwal, another director of the company.
How do you know his signature?
It is known to me in the usual course of business.
Can you encircle his signature in blue ink? Do you see any other signature or stamp at page 216 of this document?
Yes, it is acknowledged received by Axis Bank Limited, dated 16th March 2020.
Is this the original document?
It's an original office copy.
How was this office copy made?
It's a photocopy of the original submitted to the bank.
Who made the photocopy?
I have made the photocopy.
What do you have to say about the contents of this document?
They are true and correct.
May this be tendered.
Exhibit HH.
Shown documents, copies whereof appear at page 225 to 233 of the judge's brief of document. What is this document?
This is again a stock statement for the month ending on 31st March 2020 for the thin wall container division of Austin Private Limited, submitted to Axis Bank.
What do you, who prepared this document?
This is prepared by me.
What do you have to say about the contents?
They are true and correct.
Can you see any signature on this document?
Yes, it is signed by me.
Please encircle your signature in red ink. Do you see any other signature or stamp at page 225?
Yes, it is acknowledging receipt of the same by Axis Bank Limited on 15 June 2020.
How do you say so?
It is known to us in the usual course of business.
Is this the original document?
It's the original office copy.
Who made the office copy?
I have made the office copy from the original.
May this be tendered.
Exhibit II.
Shown documents, copies whereof appear at page 234 to 242 of the judge's brief of document. What is this document?
This is again a stock statement for the month ending on 30th April 2020 for the thin wall container division of Austin Private Limited, submitted to Axis Bank.
Who prepared this document?
I have prepared the document.
Do you see any signature on this document?
Yes, it is signed by me.
Please encircle your signature in red ink. What do you have to say about the contents of this document?
They are true and correct.
Do you see any other signature or stamp at page 234 of the judge's brief?
Yes, it is acknowledged received by Axis Bank Limited on 15 June 2020.
How do you say so?
Because it is the signatures and stamps are known to us in the usual course of business.
Is this the original document?
It's a original office copy.
Who made the office copy?
Made by me.
May this be tendered.
Exhibit JJ.
Shown documents, copies whereof appear at page 243 to 247 of the judge's brief of document. What is this document?
This is a CS Chartered Accountant Certificate for the stock as on 30th April 2020 for the division of TWC of Austin Private Limited.
TWC.
Thin wall container.
Who has prepared this document?
This is prepared by us and countersigned by Mr. Vivek Jaiswal, Chartered Accountancy firm.
How do you know the signature of Mr. Vivek Jaiswal?
It's known to us in the usual course of business.
But this signature cannot go. Objected.
Signature of the chartered accountant is objected.
Please encircle the signature of Mr. Vivek Jaiswal in blue ink. What do you have to say about the contents of this document?
They are true and correct.
Would the defendant have a copy of this document?
Yes, it is submitted to them.
Where is the original document?
Original document has been submitted to them in the claim file.
Who made the photocopy?
I have made the photocopy.
And may this document be tendered.
Exhibit KK.
Shown documents, copies whereof appear at page 248 to 252, 253 and 254 of the judge's brief of document. What is this document? What are these documents?
This is again a stock statement and book date statement and book date. Stock and book date statement as on 20th May 2020 for the TWC division
Who has prepared the documents appearing at
for the TWC division of Austin Private Limited.
Who has prepared the documents appearing at page 248 to 252?
It is prepared by us and after verification countersigned by the auditor.
Do you see any signature on this document?
Yes, it is, main document is signed by Mr. Vivek Jaiswal, a chartered accountant.
Do you see any signature?
Yes.
On the pages appearing at, on the documents appearing at pages 249 to 252?
Yes.
Whose signatures are they? 249 to 252.
They belong to Mr. Vivek Jaiswal.
Do you see any other signature appearing at page 249 to 252?
Yes, it is signed by me.
Kindly encircle your signature in red ink. Your signatures. Kindly also encircle the signature of Mr. Vivek Jaiswal in blue ink.
Same objection.
Objected regarding signature of auditor.
What do you have to say about the contents of this document?
They are true and correct.
Would the defendant have a copy of this document?
Yes.
Is this the original document?
This is a copy of the original document.
Who made the photocopy?
I have made the photocopy.
Where is the original document?
Original have been submitted in the claim file to the defendant.
The documents appearing at page 248 to 252 may be tendered. I'll ask separate questions for the other documents. 248 to 252.
248 to
252.
250. Exhibit LL.
LL. Pages
248 to 252.
Yes.
252.
Shown pages 253 and 254. What are these documents?
This 253 and 252 are wooden number which a chartered accountant has to generate before issuing. Okay. For our UDIN
UDIN.
number which a chartered accountant has to generate before issuance of a certificate. Issuance of a certificate.
How have you obtained these documents?
They are given by the chartered accountant along with the certificate.
Along with the certificate.
Where is the original document?
It's a e-copy. It's a downloaded.
E-copy.
Have you submitted any affidavit in support of these documents in terms of Section 65B of the Evidence Act 1872? 65 capital B of the Evidence Act 1872?
Yes.
1872.
Yes.
Yes.
Yes. So may this document be tendered.
Exhibit
253 and 254 together.
MM. MM.
Yes.
Shown documents, copies whereof appear at page 255 to 354 of the judge's brief of document. (255 to 354). What is the document appearing at page 255 and 256?
It is the list of plant and machinery, molds installed at the factory and molds installed at the factory of Austin Private Limited, Austin OSTERN Private Limited, TWC Division.
TWC
Division.
Who has prepared this document?
This is prepared by us.
What do you say about the contents of this document?
They are true and correct.
Where is the original document? Is this the original document?
Yes, this is the original document, printout.
This is the printout of the original document. Have you submitted any affidavit in support of these documents in terms of section 65 capital B of the Evidence Act 1872? 72.
Yes.
What do you have to say about the contents of documents appearing at page 257 to 354 of the judge's brief?
They are the photocopies of plant and machines imported by TWC division of Austin Private Limited, which are installed at the factory premises.
Are these original documents?
No, they are photocopies of the original documents.
Who made the photocopy? Who made the photocopies?
These are submitted by Austin Private Limited to us.
Who made the photocopies?
These are given by Austin Private Limited to us.
Where are the original documents?
Originals are with Austin Private Limited.
Would the defendant have copies of these documents?
Yes.
Would the defendant have copies of these
This
documents?
is leading. Would the defendant have copies of this? This is leading.
Taken inspection. They have taken
No,
inspection.
no,
That's not
inspection is, that is different.
He's already stated.
Very well, I'll reframe the question.
Not to take that.
A question. Were these documents delivered to the defendant?
Yes, they were delivered.
How were they delivered?
A part of the claim file submitted to them. Yes, yes, they were delivered as a part of the claim file.
As a part of the claim file.
What do you have to say about the contents of all these documents? Appearing at from page 255 to page 354 of the judge's brief. To 354 of the judge's brief.
They are true and correct.
255 to 354. Actually, the university was below. Where? Then may this document be tendered. Collective.
255 to 354.
Shown documents, copies whereof appear at pages 354. Shown documents, copies whereof appear at page 355 and 356 of the judge's brief of document. What are these documents?
These are the quotations received for the granules, damaged granules, received for damaged granules and damaged plastic boxes. And damaged plastic boxes.
GRANULES, granules and damaged plastic boxes. Who has prepared these documents?
We have prepared the document. It's not actually, we have received the document from the buyer, from the brokers.
But this is objected. This document is objected, although you have objected it, at the same time we are making.
How have you received these documents?
Yes, they are obtained by us, but after showing the damaged goods. After showing the damaged goods.
Are these original documents?
Original have been submitted to the surveyor in the original claim file. To the surveyor in the original claim file.
Are these photocopies of the originals?
Yes.
Who made the photocopies?
I have made the photocopy.
Have you compared the photocopy with the original document?
Yes.
Yes.
Were these documents delivered to the defendant?
Yes, it's a part of the claim file.
What do you have to say about the contents?
They are true and correct.
May these two documents be taken.
Exhibit.
You're objecting?
This is a third party document. He's saying that
with objection. With objection as the document is a third party document.
Exhibit OO collectively. দুটো document. Two documents.
হ্যাঁ দুটো collective. Shown documents, copies whereof appear at page 357 to 363 of the judge's brief of document. Excellent. Lord, may I take the document back to check the page number? I'll only check the page number from the judge's brief.
357 to 360.
না না এটা তো তুমি একটা 3-4 পেজ আছে
Yes, I'm so sorry. এটা দিয়ে দিন। $357 to $363. 363. What are these of the judge's brief of document? What are these documents?
The first page is details of the raw material damaged during Amphan, and the remaining pages are the invoices for the procurement of the raw material.
Who has prepared these documents?
This is prepared by me.
What do you have to say about the contents of these documents?
They are true and correct.
Are these original documents?
The first page is the printout of the Excel sheet printout, and the remaining pages are the photocopies.
Have you submitted any affidavit in support of the document appearing at page 357 of the judge's brief of document in terms of section 65B of the Evidence Act 1872?
Yes.
Where are the originals of the documents appearing at page 358 to 363? Where are the originals of the documents appearing at page 358 to 363 of the judge's brief of document? 63.
They are with Austin Private Limited.
Who made the photocopies of these documents?
I got the photocopies from Austin Private Limited.
Have you compared the
Copies from Austin Private Limited.
Have you compared the photocopies of these documents with the originals?
Yes.
Are the contents, what do you say about the contents of the photocopy and the original?
They are true and correct.
Were these documents delivered to the defendant?
Yes. It's a part of the claim file.
May these documents be taken.
Because it's Austin, he's for the claim now. So the contents is objected, although we have made objections to the admission.
May this document be tendered.
Exhibit
PP, collective.
PP, objection with regard to the contents of the document.
But should I continue? Lordship has a fixed matter at 12:30.
How many documents further?
But these bunch of documents. If my learned senior friend could have agreed, we could have done this.
No, processing. You for the September, you're not done. What can be done?
No, it's our fault.
Could have been in the commission, my lord. Anyway, I won't comment.
Yes, next.
But tomorrow is fixed. But tomorrow it will not be concluded.
12:30.
Tomorrow it is at 12:30. It may not be concluded.
Let come tomorrow. We'll see.
Wait for that.
Census when suffering for the plaintiff. Census when suffering for the defendant. Plaintiff witness is present. Examination chief resumed. During the exam, please step down.
Thank you, madam.
During his examination, documents were exhibited, being Exhibit W W to PP. Due to paucity of time, examination chief could not be completed. Accordingly, chief is deferred. Let the matter appear on 20th June at 12:30, na? At 12.
Grateful, my lord.
खड़ा होके कर लेता हूँ मैं तो।
Lord, I'm for the respondent number 1. Our arguments were over. Lord, the plaintiffs were supposed
My
to make
lord, yes, my lord. I beg to appear for the plaintiff in this matter, my lord.
Yes.
My lord, from what just to recall, my lord, the submission which was made by the learned senior advocate appearing for the respondent and petitioner was essentially that the disputes between the plaintiff and the defendant numbers 1 and 2 are covered by the arbitration clause, and therefore, my lords, the matter should be referred to arbitration.
That is
Now, my lord, I have
Yes, that is a question
My
raised
lord.
by the other party. That is-
Yes. So, my lord, before I show the documents, my lords, I would like to summarize my submissions. I have three principal submissions. First, my lord, that this is a case where there are both parties and non-parties to the arbitration clause who have been arrayed as defendants in the suit. Secondly, the cause of action, my lord, against the parties cannot be bifurcated from the cause of action against the non-parties. And thirdly, even qua the parties, on their own admission, I'll show the pleadings, the cause of action is not arbitrable in its entirety. Now, my lords, first, my lord, I would invite your lordships to the section 8 petition itself. Kindly have, my lords, para 16 at page 18. Para 16 at page 18. I'll just read, my lord. The section 8 petition, my lord, on which we are addressing arguments, my lords. That is GA number 2.
Yes. Page.
I'm just it is at, my lord, para 16 at page 18, my lord.
Yes.
It is submitted that plaintiff has also filed GA1 of 2021 in the suit seeking interim reliefs against the defendants. Amongst these, plaintiff has sought an injunction restraining your petitioner and respondent, defendant number 2, from taking any steps or further steps towards defendant number 2's ongoing voluntary liquidation process under the Insolvency and Bankruptcy Code 2016, and proper forum to claim such relief would be either National Company Law Tribunal Kolkata or National Company Law Appellate Tribunal New Delhi. Now, my lord, this is not a Order 7 Rule 11 application. It is not their case that as on date, my lord, they have not filed an Order 7 Rule 11. So, my lord, on their own admission, at least this relief, my lord, cannot be sought in arbitration. Now, I would like to show another paragraph, my lord. Kindly have paragraph 10 at page 6, at page 16.
Yes.
They say in their petition under section 8, by filing this suit, plaintiff seeks to club the issues and claims against your petitioner and the respondent number 2 that arise squarely under the termination agreement on the one hand, and respondent numbers 3 to 14 on the other, who are not parties to the arbitration agreement. The suit should be dismissed due to misjoinder of parties, as the respondent numbers 3 to 14 have been added only with an intention to avoid the arbitration proceedings. So this is their other contention, which was perhaps not argued at length, but they are saying that 3 to 14 have been added only to avoid the arbitration proceedings. Now, before I part with this section 8 petition, kindly have for a moment the two relevant clauses which I wanted to show. The termination agreement, my lord, is at page 83. It begins. If my lord would come to page 88 of the same the petition under section 8.
Yes.
If my lord has page 88.
Yes.
My lord has page 88.
Yes.
Yes, my lord may just kindly bear with me since I'm operating from a soft copy, but it's taking some time to reach. Now, page 88, my lord will see clause 3.1. 3 says condition precedent to termination. 3.1 says each party shall take all measures and do all acts and deeds, matters and things consistent with this agreement as may be required to ensure that all the events contemplated under Part A of Schedule 1, actions to be taken on or prior to termination effective date, are completed or waived in writing by the investor, and all documents evidencing such completion have been delivered to the investor to its satisfaction prior to termination effective date. Now, kindly have page 102 of the same document, which is the schedule. PDF का page 102. PDF इससे नहीं होता. Kindly have clause at page 102. Kindly have clause 3C. This is the schedule, and this is the undertaking which the club has which has been agreed between the parties. Club and or the club nominee shareholders shall undertake the following actions on or prior to the termination effective date. C says club ensures that players will obtain no objection certificate from the company along with signed copy of mutual termination agreement executed between the respective player and the company. If the club would like to engage or continue to engage with those players who were having contractual relationship with the company on or prior to termination effective date. Now, in this background, my lord may kindly have my affidavit in opposition to the section 8.
Yes.
Kindly have the paragraph 4 begins at page 5. Kindly have paragraph 4C first. Paragraph 4C appears at page 6.
Yes. Yes.
Moreover, there are 14 defendants to the instance suit, and the defendant number 1 is only one of such 14 defendants. All the defendants are admittedly not parties to the aforesaid agreement. Only the plaintiff, defendant number 1, and the defendant number 2 are parties to the aforesaid arbitration agreement referred to and relied upon by the defendant number 1 in the said application. Then my lord will have paragraph 4D. The defendant number 1 is thus seeking a bifurcation of the subject matter of the disputes between the parties to the suit, and the same is not permissible under provisions of section 8 of the said act and or in law. Defendant number 1 is also seeking a bifurcation of the parties to the suit, and the same is not permissible under provisions of section 8. Then my lord may have 4F. 4F. 4F is at page, sorry, not 4F. This is paragraph 4I. 4H, sorry. The said act does not provide for splitting or bifurcation of cause of action into a part that can be referred to arbitration and another to civil suit. For reference to arbitration, the suit should be in respect of the matter which the parties have agreed to refer and which comes within the ambit of arbitration agreement. The words a matter indicates that the entire subject matter of the suit should be subject to the arbitration agreement between the parties. Defendant number 1 has failed to satisfy the aforesaid parameters in the said application filed by it in the instance suit. Now, my lord may have the gist of the dispute if my lord has paragraph 14 at page 10. Kindly have, my lord, page 10, paragraph 14 of the same document.
Yes.
First line may be ignored. The basis of the plaintiff's case in the instance suit will be evident from a perusal of the plaint filed by the plaintiff in the instance suit, and for the sake of brevity and to avoid prolixity, plaintiff is not repeating the contents of the plaint, but the same may be treated as part of the affidavit. It is pertinent to note that defendant numbers 1 and 2 had informed the plaintiff and or had represented to the plaintiff that inter alia there were no actions, claims, investigations, proceedings pending before defendant numbers 3 and 4 and or any of their disciplinary bodies or judicial bodies or government authorities by any of the players, coaches, staff members, including defendant numbers 5 to 14 for or in connection with any club sporting activity, and or such players, coach, staff members, including defendant numbers 5 to 14 would not and or could not have claimed against the plaintiff East Bengal Club in respect of the club sporting activities. In fact, it had also been agreed by and between the plaintiff and defendant number 1 and 2 that any expenses or liabilities which may arise arise or accrue in future in respect of or in connection with the aforesaid players, coaches, staff members, including defendant number 5 to 14, would be borne by defendant numbers 1 and or 2, and plaintiff would remain indemnified and would not be liable in any manner whatsoever in respect of the aforesaid claims, demands, expenses, liabilities. It was in these circumstances that plaintiff entered into the said agreement with defendant number 1 and 2. The plaintiff would not have entered into aforesaid termination agreement had such representations not been made to it by the defendant number 1 and 2. It is also pertinent to note that in terms of share subscription and shareholders agreement dated 5th July 2018, entered into by and between the plaintiff, defendant number 1 and defendant number 2, the parties thereto had inter alia agreed the termination of the aforesaid agreement would not relieve any of them from any obligation or liability accrued prior to the date of the termination. And I will make good this when I show the plaint. Kindly now, just one last para I wanted to show. Paragraph 18 at page 12 of this same document. Save what are matters of record and save as would appear therefrom allegations connected para 9. I deny that the plaint demonstrates that dispute and cause of action of the plaintiff against defendant number 1 and 2 arises under or relates to the termination agreement, or that disputes between the plaintiff, defendant number 1 and defendant number 2 are entirely distinct or independent or severable from the plaintiff's dispute with defendant number 3 to 14. Now, I will just, and further submission that the plaintiff disputes with all the defendants instance 2 are intricately linked and cannot be bifurcated or severed as is being sought to be contended. Now, kindly have the plaint, which is annexed to the affidavit in reply, my lords, to the section 8 petition. Now, kindly have first, my lord, page 45. It begins at page 25. Kindly have page 45 is where the plaint begins.
Yes.
My lord will note at the very outset, my lord, that the plaintiff is East Bengal Club. Defendant number 1 is Quest Corp. Defendant number 2 is Quest East Bengal Football Club. And defendant number 3 and 4 are the All India Football Federation and the FIFA. And defendant numbers 5 to 14 are all individuals. They are players, various players who are playing for the club. Now, kindly have.
What is the prayer in the plaint? Against
My
all
lord,
the defendants?
yes, my lord. The prayers are sought against other defendants also.
What are the prayers against the other defendant, 5 to 14?
Kindly have, my lord, the prayers are at page 79. Page 79 of this same document, my lord, are the prayers. And I'm just coming to that one. In a moment. Yes, my lords will see. First prayer is decree of declaration that plaintiff is not liable for the claims of defendant numbers 5 to 14. B is decree of declaration that clause 4.4b of the termination agreement does not extend to the claims of defendant numbers 5 to 14. C is declaration that defendant numbers 1 and 2 are liable to indemnify the plaintiff for the claims of 5 to 14, more fully stated in paragraph such and such above, as well as the claims which any other person has made or may make against the club in respect of club sporting activities and or contracts entered into by such person with defendant number 1 and 2. And D is declaration that the plaintiff is entitled to reimbursement from defendant numbers 1 and 2 for all payments made and or costs incurred towards the claims of 5 to 14. E is mandatory injunction directing defendant numbers 1 and 2 to indemnify the plaintiff for the claims of defendant number 5 to 14, more fully stated in paragraph 35 above, as well as claims which any other person has made or may make against the plaintiff in respect of club sporting activity and or contracts entered into by such persons with the defendant number 1 and 2, including all costs. Decree of mandatory injunction restraining defendant number, directing defendant 1 and 2 reimburse plaintiff for all payments and or costs incurred to claims of defendant number 5 to 14. Then my lord will see G, a decree of mandatory injunction directing defendant number 3 and 4. These are also non-parties.
Yes.
The injunction directing defendant number 3 and 4 to proceed against defendant number 1 and 2 in respect of claims of defendant numbers 5 to 14, as well as claims which any other person has made or may make against the plaintiff in respect of club sporting activities and or contracts entered into by such persons with defendant numbers 1 and 2. Then again H, a decree of permanent injunction restraining defendant numbers 3 and 4 from acting upon or in furtherance to or taking any action against the plaintiff in respect of claims of defendant numbers 5 to 14, as well as the claims which any other person has made or may make against the plaintiff in respect of club sporting activities and or contracts entered into by such person with defendant numbers 1 and 2. A decree of delivery and cancellation of orders passed by defendant numbers 3 and 4 being part of annexure S hereto and the same be adjudged null and void, then decree of delivery of cancellation of email dated August 5, 2021, sent by defendant number 3 to the plaintiff, being annexure Z hereto, and the same be adjudged null and void. Now, against these prayers, if my lord has, I'll just show a few paragraphs. My learned senior on the other side has shown most of it, but just a few paragraphs to explain, at least make an attempt to effort to demonstrate that it is not as if this is clever drafting or this is intentionally this has been done just to avoid the arbitration clause. Now, kindly have, my lord, paragraph 8 at page 55.
Yes.
It was thus expressly and impliedly agreed between the plaintiff and defendant number 1 and 2 that in consideration of what has been stated inter alia para 7 above and in particular para such and such, all expenses and all liability to East Bengal Club which may accrue to East Bengal Club during subsistence of the aforesaid share subscription and shareholders agreement or thereafter on account of actions of defendant 1 and 2 would be borne exclusively by defendant 1 and 2 and plaintiff would remain indemnified. Then my lord may have paragraph 10, which is at page 56. As a matter of fact, the plaintiff and or its nominees on the board of directors of defendant number 2 were not even informed of appointment of players, coaches, groundsmen, and other staff, and all appointments were made by defendant 1 and 2 jointly in the name of defendant number 2. Such appointments, include the appointments of defendant numbers 5 to 14 herein. The plaintiff has recently managed to obtain some of the copies of contracts entered into by and between defendant number 2 and defendant number 5 to 14, and copies of the same are marked is not party to any of the aforesaid 11 contracts. Then my lord will see paragraph 13 at page 57. The arrangement and or relationship between plaintiff and defendant number 1 and 2 are sought to be unilaterally terminated unceremoniously by defendant 1 without any heed to the sentiments of fans. Plaintiff, however, hoped that the least the defendant 1 and 2 would be to settle the outstanding sums due and payable to the club under the aforesaid MOU and aforesaid share subscription and shareholders agreement. It was also expected that new sponsor, etc. Now, this is not relevant. Now, kindly have para 18. Para 18. Now, this is kindly here onwards, my lord, the plot thickens. If my lord has page 58, para 18, the plaintiff immediately thereafter went through the agreement to find the defendant number 1 had mischievously inserted the following clause in the draft agreement. Now, kindly see clause A. Neither the investor nor company shall assume responsibility or obligation in respect of club sporting activity, both past and present, from the effective date. Now, this was the problematic clause. Then at paragraph 19, the plaintiff by its email dated May 2020, copy whereof is annexed, sought amendment of the above clause in the following manner. Then my lord will see it is redlined. So both past and present is strike through. Then my lord will see on the next page, page 60, that portion which says if on the effective date there are any actions, claims, investigation, proceedings pending before AIFF or any other disciplinary bodies or judicial bodies or government bodies as regard any action, inaction of the club or its players, neither the investor nor the company shall bear any liability, responsibility or legal obligations in respect of any such proceedings, and the club shall be solely responsible for the manner in which such proceedings and or further liabilities arising therefrom would need to be. Now, this was strike through in our email. We said that this is not acceptable. Yes. Now, kindly see para 23. What happens after this? Para 23 at page 61. Now, para 23, on July 9, 2020, the plaintiff through its advocate sent a detailed email to the defendant number 1 and on its advocates, copy whereof is annex, referring to the said clause in the following manner. In clause 4.4b, reference to the amended clause, we would request the investor to make a disclosure regarding the pending proceedings, if any. A fair disclosure in this regard would address our client's concerns and obviate the necessity of any further negotiation. So we said that you make a disclosure, since you're saying that no past liabilities will be borne by you, so at least disclose what are these liabilities. So then after we write this mail, this is paragraph 23, then my lord will see para 24 on the next page. By an email dated July 11, 2020, copy whereof is annexed here to and marked O, defendant number 1 and 2's advocate sent following sought to address the aforesaid issue in the following manner. Many thanks for your comments. We agree with your assessment that margin of difference is quite low, and with the intent to proceed swiftly to execution and closing, we have revised the draft attached in clean and black line, largely in line with your comments. With respect to the last 3 outstanding items, we believe that there is no conceptual disagreement. We have tweaked the language to better reflect the intent of the parties and have included comments setting out a. Kindly see after that, significantly against clause 4.4, the following comment was added. While Quest is not aware of such proceedings at present, the club is well represented through its 4 club nominees and aware of all company and club sporting activity matters. So now, my lord, they make this representation that they are not aware of any other proceedings at the moment. Now, 2 more paragraphs I'll show. Paragraph 26, which is at page 63. On July 14, 2020, defendant's lawyer acting for both defendant number 1 and 2 responded in writing to the above comment in the following manner. The investor and company are not aware of any proceedings pending before the AIFF or any of its disciplinary bodies or judicial bodies or government authorities. Further, company had terminated contracts with 21 players, coaches, technical staff through mutual termination agreements, and for 8 players, coaches, technical staff, the agreements were avoided on account of frustration owing to COVID-19 pandemic and consequent cancellation of matches. Now, after this, my lord will find at paragraph 28, which is at page 69, the final termination agreement was executed on July 16, 2020. Copy of the same is annexed. Aforesaid termination entered into in Maidan tent. Now, to further signify that there was no natural continuity of contracts entered into by the defendant number 2, agreement in part 1, schedule 1, part A, clause 3C, which I had read, my lord, contained a condition that players who had entered into contracts with defendant number 2 would have to execute fresh agreement with the plaintiff in the event the plaintiff wished to retain their services, and such player would also have to obtain a no objection from the defendant number 2 besides executing a mutual termination agreement with the defendant number 2. So, my lord, this was the understanding, my lord. And today, my lord, these liabilities, according to us, my lord, which are now on account of various third parties, were not disclosed to us. We were not privy. We may be right or wrong. That's a matter of trial. We were not privy, my lord. We were not aware that these contracts, these liabilities would arise. And now these liabilities on account of various third-party claims, my lords, is now being foisted upon us. Now, the question is whether we have sought prayers today, my lord, against the AIFF, against the FIFA, and specifically in respect of the claims of these various third parties. Now, it is a matter of trial, or if they tomorrow, if they move an application saying that no cause of action is made out against these parties, then of course we'll have to defend that. But on the face of the plaint, my lord, there are reliefs sought against various third parties. And in fact, I'm also instructed that the AIFF and FIFA have also found the termination of Quest to be erroneous. But be that as it may, my lord, we have sought claims against third parties in respect of the claims of the third parties, which cannot be adjudicated without their participation. And so therefore, my lord, for the purposes of a section, and in fact, if my lord sees, we have given a tabular at para 35, we have given details of these as on date of the filing of the suit, what is the status of these various claims. And we have also said, my lord, that whereas settlements, etc., have been entered into, or what is the stage of the proceedings, those details we have given. So, my lord, our humble submission is that first, the suit is, there are parties and also non-parties to arbitration clause in the suit. Secondly, prayers are sought against non-parties. Thirdly, there are prayers which are dependent on an assessment of the defenses that these third parties may take. So in this light, my lord, our submission is that the cause of action against these third parties cannot be bifurcated. And today it is not the manner in which the petitioner submitted it, as if the whole dispute can be referred to arbitration. But our submission is, my lord, that firstly, the whole dispute cannot be. They have themselves said that we have sought reliefs which can only be sought before the NCLT and NCLAT. So that is not arbitrable in any case. Secondly, the entirety of the matter even otherwise cannot be referred because there are non-parties. Thirdly, the part of the dispute which is arbitrable is so interlinked with the part of the dispute which is not arbitrable that there cannot be a bifurcation, and part reference cannot be made. Now, in this light, my lord, I have a few judgments, my lord. The first judgment which I would like to cite is, my colleague is in court, he'll hand over, 2003 5 SCC 531. Kindly have this judgment. I am relying upon paragraphs 15, 16, and 17. Para 15 says, this is at, my lord, page 536 and page 6 of the SCC printout. Para 15 says the relevant, para 15 of the judgment, the relevant language used in section 8 is in a matter which is the subject of an arbitration agreement. The court is required to refer the parties to arbitration. Therefore, the suit should be in respect of a matter which the parties have agreed to refer and which comes within the ambit of arbitration agreement. Where, however, a suit is commenced as to a matter which lies outside the arbitration agreement and is also between some of the parties who are not parties to the arbitration agreement, there is no question of application of Section 8. The words "a matter" indicate that the entire subject matter of the suit should be subject to arbitration agreement. Now, kindly see para 16. The next question which requires consideration is, even if there is no provision for partly referring the dispute to arbitration, whether such a course is possible under Section 8 of the Act. In our view, it would be difficult to give an interpretation to Section 8 under which bifurcation of cause of action, that is to say, the subject matter of the suit, or in some cases, bifurcation of the suit between parties who are parties to the arbitration agreement and others, is possible. That would be laying down a totally new procedure not contemplated under the Act. If bifurcation of the subject matter of a suit was contemplated, the legislature would have used appropriate language to permit such a course. Since there is no such indication in language, it follows that bifurcation of subject matter of an action brought before a judicial authority is not allowed. And lastly, para 17, secondly, such bifurcation of suit in two parts, one to be decided by arbitral tribunal and other to be decided by civil court, would inevitably delay the proceedings. The whole purpose of speedy disposal of dispute and decreasing the cost of litigation would be frustrated by such procedure. It would also increase the cost of litigation and harassment to the parties. And on occasions, there is possibility of conflicting judgments and orders by two different forums. Now, kindly have 2015, my lord, 2015 14 SCC 444. Just one para, my lord, I'll show from this judgment. Paragraph number 11. In fact, these judgments suggest that you cannot bifurcate at all. The attempt of the trial court, para 11, my lord, I'm reading. My lord has para 11.
Yes.
Kindly have, my lord, para 11. The attempt of the trial court and approach made by the High Court in bifurcating the cause of action is fallacious. It would only lead to delaying and complicating the process. The said issue is also no more res integra, and this judgment I had just cited. Now, one interesting aspect, I read these paras already, so I'll not repeat myself. But my lord, one interesting aspect is why I'm relying upon this 2015 judgment is because this judgment, my lord will see, is in the context of a domestic arbitration.
Correct.
One, so that Sukanya was actually in the context of an international arbitration, but here the Supreme Court has applied this principle of non-bifurcation of cause of action even in the context of a domestic arbitration.
That is settled law. That cannot be segregated. If the court finds that the other party has been made, there is a cause of action, so it cannot be segregated. But only the court has to see whether you have made the other party, whether they are the necessary party, or only to avoid the arbitration proceeding, you have made the party in the suit. That is
Then, my lord, I will not bother your lordship. My lord will not be presumptuous enough to cite more judgments, but I'll just hand over, my lord. First is Supreme Court.
No problem.
The Twilight Properties, my lord. This is arising out of the Calcutta High Court only. Kindly see, my lord, Supreme Court order, Supreme Court judgment, where, my lord, this aspect has been considered. And my lord will see.
Yes.
Page number 2 onwards, during the pendency of the suit, an application under Section 8 was filed by Respondent 1 for referring. Trial court declined to refer that there is allegation of fraud, even to such and such. Being aggrieved, the Respondent preferred civil revision, and the learned single judge allowed the revision on ground that the plaint cannot be filed, drafting and couching in a different manner to oust the arbitration as envisaged in the clause 15 of the development agreement. Being of this view, it allowed the application under Section 8 and directed trial court to do the needful for referring the parties to arbitration. Having heard counsel for the parties, we are of the considered opinion that when there is allegation of misrepresentative fraud and also involves the persons who are not parties to arbitration clause in a case of present nature, it should be appropriate that the suit filed by the plaintiff should be adjudicated first. It is further noticeable that High Court, without dwelling upon the aforesaid issues, has come to the conclusion the plaint cannot be filed in such a manner to oust the arbitration clause. We are disposed to think that such an approach is not correct, and therefore we are inclined to set aside the order. So, my lord, this is the Supreme Court. Here also the High Court had proceeded on the basis that that this was by clever drafting, my lord, it was couched, but Honorable Supreme Court disagreed with the Honorable High Court's view and said that, my lord, that this was erroneous. Now, lastly, my lord, there is one last order, recent order, my lord, which I wanted to show, which my lord will find in, this is the case of Manjushri Kandani, which is an order passed by a coordinate bench, where my lord will see the consideration is at page 5 of the order. Kindly have page 5. The learned honorable coordinate bench has said, since the defendant numbers page 5, my lord, since the defendant numbers 1 to 18 have not been able to demonstrate that there exists an agreement for arbitration in writing between all the parties to the suit, covering the disputes involved in the suit, the present application cannot be allowed. So, my lord, learned single judge has also taken this view. There are some judgments, my lord, like I can say Lindsay Properties, my lords, where this learned coordinate bench has taken the view that it can be bifurcated, but in the facts of those cases, the learned single judge has taken that view that it could.
That is settled. That is settled. If
My
the
lord.
find that already stated, if the court find the other party is also having a cause of action, so it cannot be the part cannot be referred to the arbitration. Part cannot be decided in the
Yes, my lord. So, my lord, that is my humble submission.
My lord, if a take could be given for Mr. Banerjee to come and respond, my lord, any day, my lord.
Only one question he has raised with regard to the
Bifurcation.
But the other parties having cause of action.
But I've taken note of it, my lord. We'll respond any day your lordship fix will come.
Suffering for the plaintiffs, counsel for the plaintiff concluded his of the defendant, counsel for the defendant, is for accommodation according case is adjourned. Let the matter appear. When
Lord, except for the 26th of June and 3rd and 4th of July, any day your lordship may keep the matter.
My lord, I have some difficulty in the last week of June. If it can be kept in July, my lord, I'll be very grateful.
Your court is over. Your court is over.
Yes, my lord, today, my lord, my lord. Yes, my lord, today the court has risen. At least one of the learned single judges have risen. The other have taken advantage of that, my lord. The second, the other court is in session. Yes.
14 जुलाई का 15 जुलाई का टाइम है 14-15 जुलाई कोई टाइम है
My lord.
14th July 11:30
My lord.
Next.
I appear for the defendant applicant. Good. The application for extension of time to file the written statement, my lord. If your lordship comes to your lordship's last order once.
What? You are for the plaintiff.
But my learned friend is for the plaintiff. I am for the defendant.
Well, the defendant has made an application for extension of time to file written statement after transfer of the suit from non-commercial to commercial.
Your
Now-
lordship last order of 7th May, Lord, kindly comes to paragraph 6.
A report where it revealed that someone was served upon the defendant on 21st March and the defendant has entered appearance in that. If specific stand in opinion, it is placed in the list of defendant and said deputy and because find that
Transfer or alteration? My lord, I'll just indicate I have taken instructions, my lord. I also could not find any order by which, my lord, it was directed to be placed as an undefended suit. But, my lord, I have got cause list, my lord, of 25th of November, which shows that it had appeared as an undefended suit, my lord, as well as on, my lord, 4th of December 2024, my lord, when it was placed under the heading of undefended suits. I did not find any formal order, my lord, because, my lord, the writ of summons was served in the year 2016. I believe this is a changed brief. I believe it was mentioned, and, my lord, perhaps there is no order there, but it was placed in the list as undefended, my lord. That I have found out.
Lord,
yes.
Apropos this, my lord, this submission as regards placing it in the undefended list, my lord. If your lordship can take up
chapter 10 rule 24 of the original site rules once.
Undefendant suit.
Single bench. Chapter 10 rule.
Chapter
10 rule 24. 10.
Chapter 10 rule 24.
Rule 24. There are 4 scenarios given in chapter 10 rule 24 where a suit can be marked as undefended. First is, my lord, where the defendant fails to enter appearance.
Where the sole defendant or all defendants being these fugiaries have failed to enter appearance. B. So whether this it is deemed or order.
No, my lord.
Now here the question is whether it is admittedly there is no written statement. Admittedly.
May I just indicate, my lord, the 4 scenarios given in chapter 10 rule 24. My lord.
Correct.
First is, my lord, where the defendant fails to enter appearance. I have entered appearance here.
Correct.
Second scenario is, my lord, where if it's a order 37 suit,
it is
where
not there.
This is not an order 37 suit. Third is, my lord, if it's a suit under order 20 or chapter 12 rule 6.
Correct.
Rule 6 has been deleted in 1977.
Correct.
Fourth scenario is where there's an order of the court.
Correct. Whether an order has been made to transfer of the undefendant list.
So, my lord,
unless we otherwise
here in that case scenario, since my learned friend says that he has not come across the order, and second is he shows that from the cause list that the suit was placed under the undefended list. Lord will kindly call for the records of from the registrar whether there was such an order or not. Because that order has to be filed. Lord, if your lordship continues to read rule 24, that order has to be filed. Only then the department can mark it as undefended.
Correct. That's I'm telling.
So your lordship will kindly call for that record order.
Chapter 10 rule 24.
Yes.
Yes.
My lord. My lord, I don't think there is any order. My lord will call for a report from the department, my lord. I have tried my level best. Even if there was an order, it would have been uploaded. I do not find any order. So, my lord, calling for a report will possibly, my lord, delay the matter further. Now, let us proceed on the fact. The only difficulty that my learned friend would have faced is that if there was an order placing the suit in the list of undefended suit, he would have had to make a prayer for recall of that order. Now that there was no such prayer, but let us proceed on the basis that there is no such order, my lord. I do not have any objection to that.
So,
but entering appearance in 2016 and application taken out in 2024, that is something that is
No, my
needed.
lord.
The case was transferred here.
Yes.
No, my lord. Your
Yes.
lordship will now
Let them place their application.
Kindly come to the orders one by one, my lord. Your lordship will kindly come to the orders one by 25th November 2024.
Page?
No, 26th from the bunch of orders.
You're given the bunch of order?
But I believe it was there last time.
My lord, the order is of 4th of December 2024 at page 7 of the petition, my lord. IAGA number 2.
Bunch of order.
Just the bunch of orders once.
Bunch of orders on shop code লাগাও না?
না না।
দুখানা অর্ডার তো না এইটার এইটা দুটোই আছে পিটিশন আছে
দাঁড়া আমি একটা একটা করে দেখাই যাচ্ছে
দাঁড়া তুই কর
What is the order dated?
25th November 2024. It was marked as CS.
25th November
2024.
Order for files. The judgment in the suit was passed on admission in respect of the order dated. The department is to furnish report on the date of drawing of the decree. Leave is given to the supplementary affidavit.
Possibly that this is the date of the cause list, my lord, which my learned friend has referred to.
So what do you want? 24th November
So
2024?
it was still a non-commercial suit, my lord.
Correct.
Now, my lord, will kindly come to the next order, my lord, 4th December.
Yes.
As submitted by Mr. Such and Such for the plaintiff, the suit is transferred to commercial division since the disputes partake the character of commercial one. The department is directed to take necessary steps in this regard. The suit will appear in the list on 16th January 2025.
Yes.
So, my lord, 4th December 2024 was the order by which it was transferred. The transfer took place possibly, my lord, since it is now numbered as 824, my lord, and if your lordship remembers that subway suit, that is 827. So around that time, that was filed on the very last day, my lord, I remember that. Your lordship. So, my lord, it was just about end of the month of December.
Okay,
just
824 it has been given.
Yes.
Suit
Now,
number is given 824 com.
824, my lord. 16th January's order, my lord, records it has been converted. Now, my lord, I have taken an application to file the written statement, my lord. My lord, 16th January's order once, my lord. Statement of truth and the list of documents are filed by the learned counsel for the plaintiff. So as on 16th December, the entire procedure to convert it into a commercial division was completed. The suit will appear on the list on 28th February 2025 for further orders. If your lordship sees, we were represented over there on that day. Accordingly, leave is granted to the defendant to file appropriate application. Remember, we had sought leave to file our written statement upon conversion. So the Honorable Coordinate Bench had granted us that liberty to file. We have filed that on 24th January. Lord, 24th January, our application was on record. So this is that application, Lord, and kindly comes and takes the application once.
January. Year 2.
Year 2.
12th February.
10th February, the master summons was taken out.
12th February, filed on 12th February. Affirmed on 30th January.
My lord, sorry, I'm so sorry, my lord. 10th February 2025 was the date when the master's summons were taken out. The master had signed. 10th February was the date when the master had signed the master's summons. So, my lord, if your lordship.
10th February master summons.
Yes, my lord. If your lordship takes up the master's summons.
Master summons. Yes.
10th February, it was signed by the learned master. And it was filed thereafter.
Filed on 12th February.
12th February. Now, my lord, if your lordship sees that if the entire process of converting a suit from the commercial
show me after transfer of the suit from the regular division to commercial division, further direction is to be given to file written statement. Show me what is the provision. The argument which you are making, you are telling that is a mandatory provision, the notice is to be, and the written statement chance is to be given. Show me where is the provision under the commercial code.
No, my lord.
Once it is filed in the original civil division 4 years before.
Similar circumstance, two cases, my lord, I will cite. One of the Honorable Supreme Court and one by a coordinate bench, my lord, of my lord's court, my lord, which my lord, I'm so grateful to my learned junior, my lord, kindly comes to my lord, Commercial Courts Act, section 15.
If the court intends to frame a fresh guidelines.
So, my lord, then in that case, my lord, let me cite these two judgments, my lord. May I just, this is 2022. 2022 SCC online 1877, my lord. तो copy लग गए? अच्छे?
Large process.
हाँ.
Yes.
Lord, the facts would appear from Lord, paragraphs 3, 4, 5, 6, 7, 8. Plaintiff in that suit, my lord, had also relied on the 2019 judgment of the Honorable Supreme Court, my lord, paragraph 12. Thirteen is the relevant paragraph. Thirteen is the relevant paragraph, which says that, but we do not agree that the suit that became a subject matter and dispute in the 2019 judgment appears to have been filed before the commercial court and not before the normal civil court. Insofar as the normal civil courts are concerned, it is a proviso to the order 8 rule 1 CPC which applies. In Salim Bar Association, this court had held that the proviso to rule 1 order 8 CPC is directly and not mandatory, and section was carved out in such and such to this rule by the court insofar as the commercial disputes are concerned by invoking the second proviso of rule 1, sub-rule 1, rule 1 of order 5. Therefore, to apply the same principles to a matter where the suit was instituted before a normal civil court and transferred to the commercial court after expiry of 120 days would be to give a complete twist to the interpretation given by the 3 members bench of in Salim Bar Association, proviso of to order 8 rule 1. So, my lord.
Yes.
So, my lord, the defendant was given an option. Here, my lord, one more thing which is very important here is, my lord, while the suit was a non-commercial suit, there was orders which said that as against defendant numbers 3 and 4, it will go ex parte. As against defendant numbers 1 and 2, it will be deemed to be an undefended suit. So, my lord, here, that is why I said, my lord, if your lordship calls for the record, whether there was an order.
Leave aside, he is admitting that, leave aside that.
So, my lord, the Honorable Supreme Court in a far worse situation had granted liberty to the defendant to file the written statement and contest the suit. Here also, my lord, I am seeking, since he's conceding that he couldn't find any order. Lord, I have a better case, my lord. My written statement is already on, is ready, my lord, affirmed. Lord, if your lordship grants me liberty.
When it was affirmed?
My lord, it was affirmed on 30th January. So, my lord, 16th, if the order was of 10th of December, 30 days from 10th of December takes us to about 8th of January.
You are appeared with the regular division.
No, my lord, we have not appeared before the regular.
How you appeared at the time of transfer?
No, my lord, we had entered our appearance. There was an application under Order 12, Rule 6, where the decree was passed for part of the claim. Now, my lord, will kindly
Order 12, Rule 6 only on the basis of the plaint, not the written statement.
No. Because their pleading is.
What has happened to Order 12, Rule 6?
Well, it was allowed.
So what has happened?
No, they are executing that decree.
So they are having the decree. So what you want to contest now?
No, it's for the part sum, my lord. His claim is about 51 lakhs. He got a part decree of 19 lakhs. Now he's wanting the remaining. So I want to contest the remaining.
So you are not challenging that part decree?
No, my lord, he's executing it.
No, you are not challenging that?
No, I have not challenged that.
Not paid also?
He's executing.
Not paid also?
No.
Reason for not paying, my lord, may I just indicate? Reason for not paying is, my lord, he has filed a execution case before my lord's court. It was listed today also, my lord, before the court room number 9.
Court number
9. But there we have taken one small little point that it cannot be executed before this honorable court. Reason being, my lord, I have disclosed my affidavit of assets. I have said I have everything in Bhubaneswar. I am staying in Bhubaneswar.
You filed an application 47?
Not really in the nature of 47, but I am seeking that this decree should be executed before the court where I am residing. So this is the only thing. I am not standing in the only stand that I have taken is this honorable.
Yes, where is our court's order?
No, this is the court. This is an unreported judgment. Coordinate bench has a judgment.
Yes.
So, my lord, here also your lordship has seen that the suit was marked undefended during when the suit was pending before the regular division, my lord. After conversion, my lord, applications were made, my lord, for recall of that order, refused. Then once the suit was converted into a commercial division, the honorable coordinate bench had granted an opportunity to file the written statement. My lord, I am seeking the same prayer, my lord. Yeah, now lordship will kindly just gives me a moment. They are saying that this is if your lordship says that why I did not take any steps, my lord. If your lordship just sees, this suit was filed in 2016. they get a part decree in 2016. No steps were taken from 2016 to 2024. 25th November was the order. Your Lordship has seen that. But now they want the remaining part. So, my lord, my humble prayer is, my lord, if your Lordship allows me to contest the remaining part, my lord, by filing my written statement, this is my submission.
May I reply, my lord? Or should I come back whenever? Whatever. I can do it after the 2 p.m. matter also.
His is 2 p.m. Then we can. He has a 2 p.m. fixed matter, my lord.
After that, we can continue if my lord so pleases, or I can continue now.
Yes,
my
come. Pass.
Very well, my lord. I'll come back after the 2 p.m. matter only.
May I have your lordship to mention a matter? Lordship, day before yesterday, your lordship was kind enough to give us leave to fix the matter at 2 p.m. today, but due to a small fault, it was not, the paper could not reach yesterday in time. Today, the papers has reached the court. The CS number has.
No,
my
no, no,
counsel-
no, no. They've lost the
Lordship,
chance. I
let-
fix
Lord-
another matter.
Lordship.
Your Lordship, may
2 p.m. ছিল
2 p.m. আমাদের
missed out, my lord. My lord will kindly takes my petition, IAGA number 2. One defense that I had forgotten to point out, my lord, is mentioned in, my lord, subparagraph G at page number 6 of my petition, my lord. Where I stated, this is my defense with respect to the interest that has been claimed in the plaint, my lord. Plaintiff in paragraph number 7 of the plaint has stated that the agreed rate of interest was 10% per annum. However, the plaintiff in paragraph number 16 of the plaint is claiming interest at the rate of 24% per annum. The stand of the plaintiff is contradictory, and as such, no summary degree can be granted to the plaintiff on this ground. At least, even if it is a partial leave to defend, my lord, even then, my lord, the interest aspect is such that it cannot be granted in a summary manner. And, my lord, after this, my lord, under order 37, my lord, usually one has to demonstrate that there is a tribal issue. Otherwise, my lord will not give me leave to defend. So, my lord, tribal issues, I just wanted to summarize. One was that whether there is any liability on the part of the defendant number 2 in meeting the claim of the plaintiff, my lord. The second one is whether my lord, the claim of the plaintiff is barred by limitation. I had argued yesterday. Third one is, my lord, whether the plaintiff is is entitled to the claim for interest at the rate of 24% per annum. My lord, just one judgment I just wanted to indicate. This covers, my lord, two aspects why I wanted to show. One is, my lord, the aspect that the defendant number 2 is not liable to her for the claim. And this also enunciates the principles of Order 37, my lord. It's a judgment reported in 2022, Volume 3, SCC, page 294. 2022, Volume 3, SCC, page 294. My lord will kindly come directly to paragraph number 27, my lord. The analysis by the court. This was in case where, my lord, leave to defend was refused, my lord, and a decree was passed, my lord, in respect of a claim arising out of sale of goods.
Yes.
Kindly see paragraph 27. For what has been noticed herein before, two principal points call for determination in this appeal. One, as to whether the plaintiff was entitled to maintain a summary suit under Order 37 CPC for the claim in question. And second, as to whether the appellant defendant number 2 has rightly been declined the leave to defend. The question concerning maintainability of the suit filed by the plaintiff as a summary suit under Order 37 CPC need not detain us much longer. This is for the simple reason that, as per the plaint averment, the matter is based on written contract arising out of written purchase order issued by the appellant on the instruction and on behalf of the defendant number 1. And the plaintiff had raised the invoices against such supplies under the purchase order. The plaintiff had further pointed out the 2 checks were issued by the defendant number 1 for part payment. Now, my lord will kindly come to paragraph number 29. The assertion of the plaintiff had been of joint and several liability of the defendants. In this case, my lord, by reading the plaint, it is not clear whether defendant number 1 is being held to be solely responsible or defendant number 2, whether it is jointly or severally. The question as to whether the appellant was acting only as an agent of the defendant number 1 in relation to the supplies in question and had no monetary liability as sought to be raised by the appellant could be a matter of his defense. This is also my defense, my lord, that the defendant number 2 in the capacity of director was not liable. Could be a matter of his defense. This aspect relating to the nature of defense shall be examined in the next question, but such a proposition of defense by the appellant cannot take away the entitlement of the respondent number 1 plaintiff to maintain the summary suit. My lord will thereafter kindly come to paragraph number 31. In regard to the question of leave to defend, as noticed, the High Court has observed that the appellant would not be entitled to such leave because no tribal issues were arising out of the defense sought to be taken by the appellant. The High Court has also observed that the defense were frivolous and vexatious and were raised only in order to deny the just dues of seller of the goods, that is the plaintiff. According to the High Court, while applying the principles for grant of leave to defend, paragraph 31, as delineated in IDBI trusteeship, the appellant was not entitled to leave to defend. Thereafter, my lord will see that the court has discussed the principles of Order 37 in paragraph number 32.32 McCulloch Engineers. The principles enunciated in McCulloch Engineers is given in 32.1 to, my lord, 32.1. I'm not reading that because, my lord, it was subsequently modified by the subsequent judgment, which is at paragraph 32.2. In IDBI trusteeship, this court modulated the aforementioned principles and laid down as follows. Accordingly, the principle stated in para 8 of McKillop case will now stand superseded given the amendment of Order 37 Rule 3 and the binding decision of 4 judges in Mikhiram case as follows. If the defendant satisfies the court that he has a substantial defense, that is a defense that is likely to succeed, the plaintiff is not entitled to leave to sign judgment and the defendant is entitled to unconditional leave to defend the suit. 17.2, if the defendant raises tribal issues indicating that he has a fair or reasonable defense, although not a positively good defense, the plaintiff is not entitled to sign judgment and the defendant is ordinarily entitled to unconditional leave to defend. The third category, my lord, even if the defendant raises tribal issues, if a doubt is still left with the trial judge about the defendant's good faith or the genuineness of the tribal issues, the trial judge may impose conditions both as to time or mode of trial as well as payment into court or furnishing security. Care must be taken to see that the object of the provisions to assist expeditious disposal of commercial causes is not defeated. Here, my lord, it is already a commercial suit. Care must also be taken as to see what that such tribal issues are not shut out by unduly severe orders as to deposit or security. If the defendant raises a defense which is plausible but improbable, the trial judge may impose conditions as to time or mode of trial as well as payment into court or furnishing security. As such, a defense does not raise tribal issues. Conditions as to deposit or security or both can extend to the entire principal sum together with such interest as the court feels the justice of the case requires. 17.5, if the defendant has no substantial defense and or raises no genuine tribal issues and the court finds such defense to be frivolous or vexatious, then leave to defend the suit shall be refused and the plaintiff is entitled to judgment forthwith. 17.6, if any part of the amount claimed by the plaintiff is admitted by the defendant is to be due from him, leave to defend the suit even if tribal issues or substantial defense is raised shall not be granted unless the amount so admitted to be due is deposited by the defendant in court. So, my lord, these are the principles I just wanted to show. Paragraph 33. It is at once clear that even though IDBI trusteeship, this court has observed that the principle stated in para 8 of McKillop shall stand superseded in the wake of amendment of Rule 3 of Order 37. But on the core theme, the principle remains the same, that grant of leave to defend with or without conditions is the ordinary rule. So, my lord, leave to defend is, my lord, usually the ordinary rule. And denial of leave to defend is an exception. Putting it in other words, generally the prayer for leave to defend is to be denied in such cases where the defendant has practically no defense and is unable to give out even a semblance of tribal issues before this court. Now, my lord, 33.1 relates to this facts of this case. Kindly sees, I just want to kindly comes to that, my lord. Fifth last line from that paragraph 33.1. Therefore, as my lord found it, therefore the trial court may impose conditions both as no time or mode of trial as well as payment into the court of furnishing security. In the fourth eventuality where the proposed defense appears to be plausible but improbable, heightened conditions may be imposed as to time or mode of trial as to which as also of payment into the court of furnishing security or both, which may extend to the entire principal together with just and requisite interest. Now, kindly, my lord, paragraph number 33.2 from the middle of that paragraph, my lord, it is only in the case where the defendant is found to be having no substantial defense and or raising no genuine tribal issues coupled with court's view that the defense is frivolous or
settled
yes,
issue now.
yes, just one
There is
portion
no
that the
new things are there. It is a settled issue. If the court find that you have a defense, the court have a 3 options.
yes, my lord.
If court find have a defense, either with leave with condition or without condition or no leave.
Yes, my lord. So there are four aspects by which my lord may decide this application depending upon what my lord is of the opinion of regarding my defense that I have pleaded in my application. Last, just wanted to show, my lord, paragraph 36 and 37. 36, my lord, will see the effect from the middle, my lord. The effect and impact of an admitted position of the plaintiff that payments were indeed made from time to time by the defendant number 1 seems not to have been gone into consideration of the trial court and the High Court while denying leave to the appellant. The same considerations which weighed with the courts to deny the leave to defend to defendant number 1 could not have been applied ipso facto to the case of the appellant. Rather, those considerations in our view make out a case of triable issues qua the appellant. 37. In the totality of the circumstances of this case, we are clearly of the view that the appellant has indeed raised triable issues, particularly concerning its liability, and defense of the appellant cannot be said to be frivolous or vexatious. In the aforesaid view of the matter, we are inclined to hold that the appellant defendant number 2 ought to be given granted the leave to defend the claim made in the suit concerning its liability, and to that extent, the impugned decree deserves to be set aside. Well, principles and, my lord, the similar aspect whether the liability can be fixated on the other defendant as an agent. Admittedly, I am a director. Otherwise, what will happen, my lord? Every liability of a company will be foisted on the directors or shareholders, which is against the principles of company.
Okay.
Those are my submissions. My lord, may I give a copy of the judgment and may I take back the book?
My lord, on the issues that were raised, I believe what I understood, my lord, the main thrust of the argument is to take defendant number 2 out of this decree, if at all, if the passes. Now, so for the misjoinder of parties, the defendant number 2 is not a necessary party, is no privity of contract, these are others. The second is the no cause of action, limitation, the TDS acknowledgement, and the interest payment. These are the submissions. Now, the first thing, my lord, in this judgment which was handed up just now, my lord, a BL Kashyap, my lord, this one, this has recorded the guidelines which are after the Mechalak and Kiranmoy Dashi has been 17.132.2, 17.1, 17.2, 17.3, which is that page, my lord, which says a substantial defense, paragraph 32.2 of the judgment, which is quoting IDBI trusteeship. Substantial defense, likely to succeed. Second is fair defense, a positively good defense. If the doubt is left to the trial judge about the defense, then condition to be imposed, pay money, timeline. 4 is a plausible but improbable defense. It's a plausible but improbable defense, then also imposing condition. 5th is no substantial defense is raised or no genuine triable issue, judgment is forthwith. The 6th one is, if any part of the amount claimed by the plaintiff is admitted by the defendant, due to him, the leave to defend, even if the triable issue or substantial issue is raised, shall not be granted unless the amounts were admitted or due is deposited in court. So these are the 6 broad guidelines. Now today, my lord, we come to the issues which are raised one by one. Now, if we take their petition, if we take their petition, my lord, lordship will not find any defense or a triable issue raised by defendant number 1, because this application is made by both of them. Admittedly, he is a director, not a publicly quoted company. It is a private limited company, a small family-owned company, which are private limited companies, controlled by a family, whatever. There is a document which we call a mercantile document by which he has taken the loan. Defendant number 2 himself has issued the check. He has signed the check. And I have said in the pleading that there must be a natural person on behalf of artificial person to speak. This natural person is defendant number 2, who has done all the negotiations. And he has induced me to give this loan to his own company.
Where is the case?
In the plaint.
Against the defendant number 2 in the plaint.
I'll just show you. I'll just take it. Now, if we see the pleadings in the order 37 that leave to defend, there is no defense at all, any triable issue raised on the merit of my case. There is nothing raised. So that I take it that even the submissions which are always restricted to here, paragraph 2A is on limitation of the order 37 that leave to defend application. 2A is on limitation. 2B is of misjoinder of parties. Misjoinder is defendant number 2, the director. 2C is no cause of action. 2C is no cause of action because the check which has given, the check is not presented for encashment. That is the reason. I'll answer each of them. D is the TDS certificate which has he has issued. He says that there is no TDS certificate issued after 2017-2018 financial year. The document will speak. And the last is, he says the balance confirmation is on 31st of March 2019. These are all extending the limitation point. Then in next page, my lord, F is, there is a loan. He says that balance confirmation date in November is once again the limitation point. Yes, he says there is no mercantile document. One difference is taken in F. There is no mercantile document. The last in F, there is no document whatsoever next to show that the same, there is no mercantile document. G is agreed rate of interest is 10%. However, the plaintiff in paragraph 16 of the plaint is claiming interest at the rate of 24%. So no summary degree can be granted. Next, my lord, paragraph 3. Now H is, we had gone for a mediation. It failed. So that is pre-institution mediation. We have a non-starter report. C is, 3. 3 is, in the reasons aforesaid, the defendant number 1 has a plausible defense. So these are all nothing on merit of the money that we have taken. How will you repay me if the debt? So, and it continued that, and then 5 is, he has received the writ of summons, and they have entered appearance. They should have entered appearance within 10 days. This is a 1-day delay. I am not at all on the delay because the Civil Procedure Code grants levered discretion on the court to extend the time. So I cannot on that 1 day, 2 day, I am not at all on those. Now on these points, my lord, she will first come to my plaint. I'll just take the documents first and then I'll take the first is page mercantile document, page 38 of the plaint. This is the first, which we call a mercantile document, by which the loan was given of 2014.
Yes.
This is from my client to Skipper, short-term loan of 30 lakhs, principal amount towards a commercial loan for a period of 120 days. Issued a post-dated check of PDC. So now one submission was made that there is a security check was given also. Yes. So this is the security check mentioned here.
Yes.
This is the security check which is mentioned here. And the rate of interest is also mentioned, 10%. The rate of interest is mentioned as 10%. Next, no, 47. Lordship, just a minute, man. Lordship can mark here, the check which we are saying now is not the same dated check. So this is the security check or the PDC check given at the time of the loan was given, because the loan was to be reported in 120 days. The next page is page 39. It starts from 39. This is
the check which has been mentioned. No, there is no. Yes.
This check is not deposited. This check is not there's a different check. That check was given to return the money. That is at page number. Now I'll show you that.
No, this page 38.
Yes.
These are 30 lakhs. 3 lakhs. 30 lakhs.
It was initially given because the timeline was 120 days.
Correct.
The money was given in the month of June.
Correct.
Repayment is in October.
September. Yes,
1st of October. Yes. So this is the initial given.
Correct.
The next check which was not deposited, page 47. Page 47 is another check of 2019 dated.
Yes.
So this check is not the security check, which is, though not pleaded, but oral submission was made. And this is signed by the defendant number 2. I must admit that this check was also not deposited to bank, because that's the defense taken, that unless you deposit the check, how can there be a cause of action?
Yes.
To give a straight answer to this, I say, if I deposit the check and if there is a dishonor, that gives a cause of action for a 138 proceeding. But your issuance of a check is a separate cause of action. We admit the liability. So the cause of actions are different. Obviously, there is no 138 here. Now we come back to the documents. Now page 40 on.
So if you go by your submission, page 38 mention document and issue a post-dated check.
Yes.
Post-dated check. So what is the number of the post-dated check? And you are telling that this has been given on 1st of October 2019.
Now this is post-dated check date is given in page 38. PDC date.
Where it is the date?
Well, it is 1st of 2024 in the box. Page 38.
Page 38.
Page 38.
Yeah, okay.
Yes, the check number is not there, but the check date is there.
Okay.
Now, Malat, from page 40 is the balance confirmation. Page 40 onwards, the balance confirmation starts, which continues
page
40.
Yes.
Page 40 is the balance confirmation up to 31st of March 2019.
Yes.
Then, Malat, I think it has been annexed in a reverse manner. Be that, Malat, page 42.
What are the
page 42 is once again page 40 is up to 31st of March 2019. Page 42 is 31st of March 2015. So it's a annexed in a reverse manner.
What is the page 41?
It's a KYC because we are a NBFC company, some KYC compliance
Page
of Reserve
40 is
Bank.
balance confirmation.
Yes. Signed, sealed. There is no dispute on these. No dispute raised. Nothing raised. So 41. Then page 42 is the balance confirmation signed by both the parties in 31st of March 2015.
Yes.
Page 42. Page 43 is a balance confirmation of 31st of March 2016.
Yes.
I'll go ahead. Page 43, 43 is 21st of March 2016.
44 also.
44, 45.
Yes.
46. 46 is a confirmation which comes up to 31st of March 2019.
Yes.
And then, so up to 2019, a balance confirmation is there. Because I have to meet the point of limitation. That's the reason I'm. Then comes 47, the repayment check, which is in October 2019. Because up to March, the balance confirmation comes. In October, the repayment check comes in. Now, Malad, page 48. Page 48 onwards is because they paid me interest, because they have deposited TDS. Page 48 is the interest payments that they have made. It's a complete ledger. Page 48, you will see the ledger in the top. 1st April 2014 to 18th August 2023.
Yes.
It's a complete ledger. Now, it starts from entries are there. There is no dispute. Which is most important is page 49, no, 40, sorry, 50. Because after all entries have been, the last payment of interest is on 18th of June 2019. This is the entry, Mala, that you will see by Karnataka Bank receipt. That we received in the Karnataka Bank, in our Karnataka Bank.
Yeah.
63,173. This date is most important because limitation will.
So how you can say this is a Karnataka Bank amount of the this
amount they have paid us. They have earlier paid us also. The earlier one was 30th of March.
Okay.
60,000. These are not disputed also. These I've showed you the leave the application for leave to defend. So the last payment of interest is on 18th June 2019.
63,000.
Yes, but this date becomes important, may not be the figure because of limitation, because we have to reach to the limitation point. So here the last paid of interest is at page 50. Now the TDS. TDS starts from page 51, which is the deposit, and I get the 26 AS form. Now in TDS, এটা কোন পেজটা এত কটা দেখিয়ে কোনো মানে নেই। Yes, but you will see that TDSs are all once again from the year. The first one is financial year 2014-2015, because the financial is important. The first, they deduct TDS and their name is appearing. Their name is there, man. কোথায় দেখিয়ে দিও নেমটা দেখাতে পারবে? দেখো, yes, দেখাচ্ছি। Page 53 mark করা আছে।
The name is appearing at page 53. Yes.
Just a minute, কি কাণ্ড, the photocopiers, so কি সব বেরোচ্ছে দেয় না,
Black.
Yes, কালো কালো। So page 53 is their deposit TDS. The next page 54 is the financial year 2015-2016.
Yes.
এখানে এন্ট্রিটা দেখিয়ে দাও। Here the entry I just, yes, entry at page 57 is the top one. Page 57, the
Where is the name?
Page 57.
Page 57.
Page 57, the first one, skipper.
Yes.
So this is for that year.
Yes.
Now, Lord, you will come to page 58, which is, thank you, page, yes, page 58 is for the financial year 2016-2017.
Yes.
The entry, page 58 is the starting form at page 660. 60, last entry in the bottom. It continues till the next page.
Yes.
Next page, my lord, 2017-2018 at page 62. Page 62 is the financial year 2017-2018. At the page, at page 64, the last
Serial number 25.
The last entry at serial number 25, whatever. Yes, the last entry.
Yeah.
So they paid me interest. They deposited TDS. So this continued. So this is up to 31st of March 2018. The balance confirmation is 31st of March 2019. And the last interest payment is in June, 18th of June 2019. Now, keeping...
When you filed the suit.
Yes. Now, there's a date. Today is the commercial suit and standard operating procedures e-filing date is the, this I have brought from this is available on the website that now there a copy there. The filing date 21st of May 2014. The standard SOP which is prevalent is the day you upload all the documents with the court fees is the filing date, because we don't have a control beyond that. Because I have a judgment of the Sarkar has passed. Your responsibility ends. Why upload it? So the filing date is 21st of May 2014. Now there's some calculation which is required, my lord. If my lord's pleasure to, I just tell you, my lord, the date. Now the last interest is paid on 18th of June. So my limitation starts from 19th of June 2019. 19th of June 2019, and I continue with the limitation till 19th June 2019 till it continues till 14th of March 2020. because from 15th of March, COVID. So 19 June 2019 to 14 March 2020 is 269 days.
269 days.
269 days. Then my limitation that COVID ended and I have to go from 1st, which will also kindly take a note, from March. 1st March 2022, and I filed on 21st of May 2024.
Yes.
So this is 8 with up to 20th, the 21st I have filed.
20 May.
Yes, 20 May, 8, 1, 2 days.
812. 812 days.
12 days. So adding these two.
So 269
plus 812.
812
is 1081 days.
1081 days.
81. And 3-year limitation is 365 into 3 is 1095.
Yes.
This is also without prejudice because I went to mediation first. So that it stops, the limitation stops to have the second proviso. Now my mediation non-starter report is at in the plaint, last annexure to the plaint, page 146. চেক ধরে গিয়েছো একটু চেঞ্জ করে দিলাম ঠিক আছে হ্যাঁ
Mediation started September.
Yes. So this is the non-starter report. It starts from.
No, it starts in application for pay institution 26 September.
Yes, my lord. Absolutely. So it's under no stretch of imagination. It can be said that this is time bar or limit time bar. Yes, time bar.
Yes.
So this is my answer to the
Limitation
point.
point.
Answer to the limitation. This is my answer to the limitation. Now কি বললাম ওরা একটা পয়েন্ট নিল yes so another issue was raised, the TDS acknowledgement. TDS is not an acknowledgement of debt, that because we are going on the interest payment, so TDS is any event earlier than that, so that's not an issue. Now the check I have also said, Malad, they have issued the check, there is no denial that they have issued the check. Cause of action for 130 did not arise, not for your liability. Now I will come to the straight point, I think only, and there is no defense on merit. There is no defense on merit. The straight issue, how did I make defendant number 2 a party and what are the pleadings in support of that? My pleadings in the plaint. No. Pleadings in the plaint, tumi ja korecho bhai. Oh, actually before that, because the issues has been raised, along with the writ of summons, a copy of the plaint was served. And there were some defects which cropped up later, and pursuant to my lord's order, it was resent to them on 28th of April. Now, my learned friend has made an alternative argument that this can be a premature application. If it is premature, let him withdraw the application. I'm defending his application. It's his choice whether he makes it premature or he can withdraw his application, but leave to defend. So he has, so he can withdraw it. What I feel I'll do in my suit. I don't have a prayer here. So if he is not withdrawing his application and is contesting his application, first is, what are the defects? If Lordship looks into the plaint, somewhere is gone in as defendant, it should be defendants, singular, plural. That's the only mistake. It's singular and plural. Main paragraph, which is paragraph 15, Lordship will kindly see the paragraph 15 of the plaint, which is first the prayer portion, the claims. I ask, is there any change or amendment to the prayer portion, or what are the corrections the department told us to do, whether it's substantial or it's only procedural or technical. There is a decree for a sum of rupees 4298 as pleaded in paragraph 15 above. Now we come back to 15 at internal page 6 of the plaint. Here it says, in the circumstances aforesaid, paragraph 15, in the circumstances, the plaintiff is entitled to claim and claims rupees such and such as on 31st of April 2024 as due and payable by the defendants. So it becomes jointly and severally. To and in favor of the plaintiff as per the calculation made herein below.
There is no correction.
Now I just once I'm in this paragraph, 30 lakhs is the principal. Now this what they have done, there should be inner column, outer column. 29 lakhs minus 16 lakhs. So you can record, but this comes 1298,221. And then that figure is 42. So they have not given the quotient. They've given the breakup is not given over here. And এটা 29 minus 16 is 12. Lordship will say, I'll explain. Principal amount is 30. Add interest, we have added at 10%, which is the contractual, 29 lakhs. Less is 16 lakhs, which is paid to us. So 29 minus 16,
What remains?
what remains is 1298. 1298,221.
30 plus 1290.
এটা তো করোনি।
আমি না ওটা Lord.
29 minus.
This might have been done, Mr. Roy Chaudhary.
That's why, my lord. The disclaimer is fast.
आगे disclaimer के वाली।
Foremost. I knew, my lord, that is.
Now, when I was looking into, and I came in after Mr. Mukherjee made all these submissions. Thankful to him. I came in because of Mr. Mukherjee's submission. So the breakup is the quotient is 12,98,221. 30 lakhs plus 12,98,221 gives us 42,98,221. So this is the
So minus 29 minus 16, what would be the
12,
12,
98,
98?
221.
Okay.
Then 30 plus 1298 is 42.
So 42.
Yes. So I am till today I am claiming 10% only, which is the contractual rate. Whatever interest is always before the court. I cannot. Yes, I have claimed 24%. That is always the discretion of the court. I have claimed as per the contractual rate 10%. Now the corrections which are there, my lord, which are the singular plural. Some department has raised this is singular plural. I stretch it to a bit extent.
You have made the plural, that's why he has come.
One thing.
If you not made the plural, that he could not have.
Countable.
Singular plural means very small thing.
That's
But what happens is that the difference is one person will pay 30 lakh or two persons will pay 30 lakh. Then it becomes bigger in issue.
Your company will pay 30. That your company will pay.
Okay.
Now, Malak. Now, on the pleadings. On the pleadings, how did I make defendant number 2 a party? Because I must admit, the loan was given to defendant number 1. The mercantile document is with defendant number 1. That I cannot. Rubber stamp of defendant number 1, separate legal entity, I cannot argue something which is, it's there. Now, how do I plead him? Paragraph 3 of the plaint. There is some pleading. Paragraph 3 of the plaint. That's what I said, Malad. It is the representation of defendant number 2 that he is one of the director, and the defendant number 1 is a family company, carries on business of furnishing products. This is one of the famous furnishing shops in Calcutta, Malad.
Shut down.
No, I don't want to shut down. If you can give me some upholstery, upholsteries. I don't want to shut it down. Now, so this is the representation. paragraph 4 is also relying on the representations made by the defendants and believing the same to be true and correct, the money was lent and advanced. I cannot improve this further. So paragraph 3 and paragraph 4. And yes, a company has to be represented by a natural person.
Yes.
And then paragraph 9, I say they have failed and neglect to pay after the balance confirmation. And it continued further. The TDS acknowledgements and everything. So this is the paragraph where I have pleaded why defendant number 2 is a proper and necessary party for me. So it has to cover I am missing any points. I am missing out any point, Bolo? Non-joinder cause. So yes. So there cannot be, you cannot say that I don't have a cause of action. Misjoinder I have covered, limitation I have covered, the last payment I have covered, the interest I have shown. HRR key point is. Okay, now may not be. I'll tell you. But once complete facts. When the writ of summons was sent, the application was made to leave to defend. It was discovered there's some typographical mistakes. We have served them the plain pursuant to order of court. Even 10 days have lapsed from 28th of April. Because the order of court and writ of summons can't be served twice unless it has come back unserved. So that is the rules provide.
Today I have decided that.
You have decided. YouTube.
No, judgment.
Okay.
Deliver judgment.
Oh, for judgment. Ki decide kare Bhagwan jane. So
unless the court dispensed with.
Oh, yes. Compulsory. Yes. When we joined, it was a mandatory. The seniors or the advocate and because you say you record that. The such and such appearing, formal service is dispensed with. Yes.
No, and this point is also decided in one matter. What has happened? The same thing. Plaintiff appeared, taken the brief. Court has in that case, court has dispensed with.
Okay.
My order. Dispensed
formal
with.
record.
Dispensed with. Subsequently, application was filed that though it was dispensed with, that the correct application was not served.
Correct plaint.
Correct plaint
was not served.
Then I decided it is not a proper service.
I made that argument today, my lord. Dispensation. No dispensation here.
No, that's why.
And I made it. So even if the plaint was served today, they were also 10 days have gone in. Then you can argue this matter is premature. In that event, in that context, that this is a premature application. Today, both the defendants has applied before the court, and both the defendants.
How you said once the amendment or this correction has been carried out, how the old plaint has been served? That is the problem.
One more thing that was disturbing
that
me,
is
my
a
lord.
hurdle to you.
One more thing that was disturbing me, my lord. GA number 1, I do not find any order. This is GA number 2, which I had made. But GA number 1,
that is extension of time to lodge writ of summons. It was in the department only.
Master's summons.
Masters.
Because I was presuming that was the amendment.
That's before the master. That is before the master.
If it is, that is the crucial because here also the court directed to serve the copy, but not dispensed with. First thing, second thing.
No, writ of summons was lodged and served.
Lodged and served.
Served, but with the
that is not the correct service. No?
That
is not the correct service.
Because but I couldn't have issued or caused to be issued a second writ of summons because the first one has already been received by them.
No, then you have to make a prayer before the court.
Is not done because today I cannot turn the clock back what has been done because
that
this is
one hurdle.
That is one hurdle I admit, Malad. That is one hurdle.
One hurdle regarding writ of summons.
Now today writ of summons, but if you look into he received one writ of summons. He received a copy of the plaint with a writ of summons.
That order, that is also one order, my order. Unless writ of summons means sufficient service with regard to the total document.
Everything is served.
But the amended was not here, no? Without the amendment. What you are
it will correct it. The
না,
court
না,
will
সেটা
correct it.
একই জিনিস হচ্ছে।
They have taken the point.
They have taken that point, but will that, I just asked the question to myself, my lord. Today we are defending this can be, if I stretch it, in a normal suit, I didn't receive the corrected plaint. There has been a substantial changes later. The liability has shifted or many things have come in. I've not received a summons. So in a commercial, my 120 days clock did not start. I'm not required to file a written statement in that context, because the next action is written statement timeline. So I need not file a written statement because the correct copy has not been summoned. Today, you have accepted the writ of summons and you have approached before the court. You have surrendered to the jurisdiction, making this application. And after the corrected copy of the plaint has been served, now today you making a parallel argument, it may be premature. It's your case, you have to make a call. You cannot leave it on the court. It's like alternative case. You have to opt it.
That ground you not make out in the application. That you not.
My lord will see that this was discovered during the pendency of the application after affidavits were exchanged. My lord will see that I had filed my application sometimes.
No, it's in November 2024.
And November 2024, and the order was passed, my lord, in April 28th April 2025, few months back. It was discovered during arguments, my lord, because while I was placing, my brief was not matching with my lord's. That's when it was discovered.
That's there, man.
Because this corrections and everything happened even before the writ of summons was served on me.
But this I'll tell you, my lord, this, if you lordship, I can take your lordship through the changes. It's only a typographical or human error, the apostrophe S, 3-4 places. And I showed you the paragraph 15 and the prayer portion. There is no change. It is not that annexures are not there or any other things. So this, and if they run a case that it is premature because they have not received writ of summons, then they have to, court cannot decide. This is your case. If it is premature, you have to withdraw it. And then your time starts, then whatever happens, then you have to, then I say this plaint was served or a second writ of summons comes in. So on merit, a person who is approaching the court on merit, what he has disclosed. He has disclosed nothing on merit. Going by, once again, the 6 principles of IDBI trusteeship, that I say that I come under 17.5, because I am carrying a IDBI trusteeship separately, but once it is quoted there is no point in multiplying, my lord. That BL Kashyap. BL Kashyap, paragraph 32.2. Now, what's happened in BL Kashyap is, facts must be different. Yes. Now, 32.2, which is quoting paragraph 17 of McCulloch. Let's kindly turn over to the next page, 309. I come under 17.5 and 17.6. If the defendant has no substantial defense and or raises no genuine triable issue, court finds such defense to be frivolous, vexatious, then leave shall be refused and the plaintiff judgment forthwith. Because the plaintiff is here, has to be a judgment will follow. 17.6. If any part of the amount claimed by the plaintiff is admitted by the defendant to be due from him. So I come under 17.5, also 17.6. So on the both these legs of Order 37, the principles, I'm entitled to, and then it should be a judgment. Now, if it is admitted and they raise a tribal issue, then you deposit the entire money in court. Then they deposit the entire money in court. So,
what is the amount?
It's 42 lakhs. It's 30 lakhs plus the interest, plus then minus the figure. I go by 10%. And I have asked for pendentality and other things. Those, if this decree, if I get this, others we can, pendentality and other things are principal amount and whatever the interest amount as per 10%. So these are my submissions, and on what I have said, that on this, the singular and plural, the defendants, they have taken the point misjoined. I have addressed that. It covers another district. These are my submissions, man.
Well, I'll take 1 minute in reply, and I only want to show one page, page number 4 of the plaint.
If suppose,
my lord,
not the court has not made up the mind. If suppose,
my lord,
you have taken your case, if the defendant number 2 is not there, if the court pass a decree of the defendant number 1, what would be your answer to that?
But my defendant number 2 only has 2 additional defense. One is no privity that the defendant number 1 couldn't
That's what I'm
take.
telling.
Yes, my lord.
If suppose if your submission is accepted, the defendant number 2, there is no perfect claim made out, and no decree can be passed, and find that the decree can be passed against the defendant number 1, what would be your submission on that?
Well, I had argued that non-disclosure of action, cause of action for
that is there. No,
yes.
I am not on merit. With regard to this point, if suppose if the court go, yes, decree is to be passed, and find that yes, your submission can be accepted with regard to the defendant number 2, decree cannot be passed, what is your response on that?
My lord is, if I've understood my lord correctly, my lord is saying that my lord is satisfied that defendant number 2 has a plausible defense, but defendant number 1 does not. My lord, then I'll have to fall back on the writ of summons only. I have to be candid. Other than that, I don't have anything. In fact, this 1-minute submission that I was trying to make is on that basis only. Kindly see page 4 of the plaint once. These corrections which are stated to be minor in nature and technical, my lord, makes a world of difference. Kindly sees, my lord, paragraph number 8. However, the defendants, so this is defendant becomes defendants, defendant number 1 becomes all the defendants, failed and neglected to keep its commitment of timely repayment of loan amount along with the agreed interest and time and again sought for extension of time. In this context, the defendants, now it has again been changed, has unequivocally and unconditionally accepted the principal amount of financial assistance of rupees 30 lakh. So this, and my lord, then they rely on all these, my lord, confirmations. So this is an assertion of extension of limitation period on the basis of acknowledgement. Before the correction was made, it was only defendant number 1. After, my lord, defendant number 2. So, my lord, the entire nature of the plaint changes because initially it was only against the company. After correction, it became against the defendant number 2 also. So, my lord, once I have received the incorrect plaint as per the writ of summons, my lord kindly checks the order 37 rule 3.
No, but again, if you say that the incorrect plaint has been received, correct, but what about your contention raised in application? You have accepted that you file this application within 1 year, one day delay. You have accepted that you received the writ of summons.
I have accepted the writ of summons. But what is the writ of, is the writ of summons the only document that was to be given?
Writ of summons, on receipt of that you have filed within 10 days you have to file, but you have not filed. 11th day you file, you have prayed for one condoning of 1 day.
Yes, my lord.
Correct.
Yes.
So for that period you accepted, till the filing of this you accepted, you have received the writ of summons. You have not taken the stand because you have no knowledge whether
based on the knowledge that I had to make that statement.
Now,
yes, my lord.
Now the knowledge comes.
Yes, my lord.
And you have, when the argument, the court has directed to give the copy, corrected copy.
My lord.
Corrected copy has been given in terms of the order to you.
My lord.
So what would be effect of that order?
My lord, that made me aware of the entire scope of the plaint after I filed my
Because
application.
the plaint and only the defense, because the defense you are taking, that you already taken in your application, defendants and defendant.
My lord.
That you already taken.
My lord, I understand what my lord is going through my lord's mind. Order 37, my lord, is my lord kindly sees order 37. It has extreme consequences for the defendant.
Correct.
I don't even have the right to file written statement unless the court permits me to do
Correct.
so.
That's
a strict interpretation.
I am
That is why, my lord. That is why, my lord, kindly sees order 37, rule 2, sub rule 2. The summons of the suit shall be in form number 4 in appendix B. The summons of the suit shall be in form number 4 in appendix B or in such other form as may from time to time be prescribed. The defendant shall not defend the suit referred to in sub rule 1 unless he enters an appearance, and look at the consequences, my lord, given. In default of his entering an appearance, the allegations in the plaint shall be deemed to be admitted, and the plaintiff shall be entitled to a decree for any sum not exceeding the sum mentioned in the summons, together with interest at the rate specified, if any, up to the date of the decree, and such sum for such costs. Now, my lord, rule 3, procedure for appearance of the defendant. In a suit to which this order applies, the plaintiff shall, together with the summons under Rule 2, serve on the defendant a copy of the plaint and annexures thereto, and the defendant may at any time within 10 days of such service enter an appearance either in person or by pleader, and in either case he shall file in court an address of the service of notices. Unless, so my lord, if I don't do this, everything will be admitted. Rule 3 specifically provides that the writ of summons must be accompanied by not only the plaint but the annexures and all documents. Admittedly, the plaint which is before my lord was not the plaint that accompanied the writ of summons, which is mentioned in sub-rule 2 of order 37. So, my lord, I would humbly submit that the writ of summons has not been served on me in accordance with order 37 rule 2 sub-rule 2 read with order 37 rule 3. These are my submissions. And as had my lord had indicated also while the matter was going on, and I had argued also, yes, I have received a copy of the correct plaint after it was noticed. But there was no dispensation of issuance of writ of summons. The writ of summons which was served on me along with the plaint, my lord, is defective.
No,
that service was not waived.
That's why again 2 questions to you.
My lord.
So if the writ of summons which you received, that is not correct writ of summons was served to you, the correct plaint was not served to you, and the corrected plaint which you have been received during the hearing of the case on April 24th of April 2025.
Yes, my lord.
But the plea which you are raising with regard to the defendant and defendant, you already taken the plea in your application.
My lord, my humble submission would be
one thing. One is this, and second thing, once you have already taken a decision and you have not filed, you have not, even when you came to know, you immediately not filed an application for dismissal of the suit for lodging of the writ of summons
within 10 days. I understand, my lord. Answer that question right now, my lord. I would be entitled to again file an application for leave to defend or enter appearance once again the writ of summons is served on me in accordance with law. What was given was a plaint. That was not a writ of summons in the form, specifically form 4 as mentioned in sub-rule 2. And rule 3 mentions in a suit to which the order applies the plaintiff together with the summons under rule 2 serve the... So 25th April, I received the plaint but no writ of summons, and in September, I received the writ of summons, but not the correct plaint.
And again, the question would be on 24th April, you received.
My lord, I leave it to my lord.
No, I am because this is
an interesting point of law, although it appears to be very technical in nature, my lord. But order 37, my lord has seen, is very strictly to be complied.
That is
because the consequences.
One order is passed, consequences will follow.
My lord.
In order 37, that's why all the point is to be taken into consideration.
Because if my lord is thinking otherwise, my lord, what will happen is that even if a plaint is incorrect or there is some error in the plaint or some documents not given, that can be rectified by a simple order of court under section 151. One will apply and say, we haven't given these documents, we'll give these documents. But this way the defendants, it would appear to be unfair given the strictness of the nature of order 37. Everywhere else, my lord, section 148, my lord may extend the time, inherent jurisdiction, my lord may extend the time, save and accept written statement in a commercial suit. My lord, but otherwise, my lord, this order usually, my lord, is extremely strictly construed. If it is because the plaintiff has to take a decision whether to file a regular suit or a suit under order 37. In fact, my lord, there are certain other conditions also which says that the plaintiff must make that averment that there is no defense of the defendant, there is no tribal issues. If those are not there, I'm asking this question to myself, will my lord be able to pass a summary decree if, let us say, my lord, order 37 rule 2 sub-rule clause B is not followed, where they have to say that no relief which does not fall within the ambit of the rule has been claimed in the plaint, and the following inscription under the title, that is under order 37, and my lord, no defense is given. If these are absent in the plaint, will they get a decree under order 37? These are my humble submissions.
Okay. Thank you.
And so far as the director point is concerned, my lord, every company is an artificial company, cannot work without a natural person. Somebody has to go and negotiate and sign on behalf of the company, my lord. Just that, my lord, I would say that does not disclose a cause of action against me. But I'm grateful to my lord.
The defendant number 1 received it without the correct one.
But that is not the plaint today. The one that has been received is not the plaint today.
What about the defendant number 2? Writ of summons was served.
It is served on both. Served
No,
on
that
both.
that we admit, that we admit.
That we-
But
yes,
with
yes.
both,
It is not
it
the
was.
case.
There
It
is
is
served,
suffering for the
served on both.
when suffering for the defendant. Plaintiff has and defendant has filed an application being GA Com 2 of 2024. Hearing concluded. CAV.
Sorry. তুমি তো 40 মিনিট বললি। Obligement. Grateful to.
3 PM लो तो होगा नहीं 3 PM में क्या है 3 PM तो देखे टाइम मिलेगा तो
Lord, before your lordship takes up the 3 o'clock matter, my lord.
yes, yes.
Lord, we just had a word, my lord. I have some personal difficulty for which I'll have to leave, my lord. If it could be taken up tomorrow, item number 17.
Not today कर दो उसको हाँ
Come back. Read.
May it please your lordship.
अच्छा एक रिकॉर्ड कर लो ऑर्डर आइटम नंबर
17.
Sensation suffering for the plaintiff, sensation suffering for the defendant. Counsel for the parties are argued at length, but due to paucity of time, hearing could not be completed. Let the matter appear tomorrow.
Much appreciated.
Yes.
May it please your lordship.
Item
Lord,
number?
This is item number 12.
12, yes.
Fixed at 3 p.m. Lords, I appear for the plaintiff in this matter. This, my lord, is a money suit for price value against services rendered on the basis of a
tender
work
matter?
order. Yes, my lord,
Okay.
this is the tender matter. Lordship will recall. If your lordship will allow me 60 seconds to quickly recapitulate my submission.
necessary,
Not
sir.
necessary. May I then straight away
No,
take
no,
your
no.
lordship to the
Cover.
claim that I was
What is the
addressing your
file दो
lordship
उसमें?
on?
वो नहीं ना मेरा नोट
That is for refund of security deposit and earnest money deposit, my lord. I had, my lords, shown your lordship that a sum of rupees 41 odd lakhs was paid as initial earnest money deposit while participating in this notice inviting tender, and that a sum of rupees 45 odd lakhs were withheld while making payment of the RA bills. Altogether, 9 RA bills were raised. RA bill numbers 1 to 8 have been paid. RA bill number 9 has not been paid.
Yes.
That was my first claim, which I've already placed before your lordship. Moving forward to the second limb of my second claim, my lords.
Yes.
That is return of the security deposit and earnest money deposit. Your lordships had indicated on the last occasion for me to place those correspondences through which it can be culled out that the respondent failed to discharge his end of the obligations,
Yes.
which in turn prevented me from discharging my obligations in totality in
Correct.
terms of the work order, my lord. Now, today, the contract bestowed upon the respondent authority with 3 major obligations. One is to provide unfettered access to the site, my lords. Until and unless I do not have access to the site, I will not be able to carry out any of the construction activities thereat. Second, my lords, is to provide design and drawings. And third, my lords, is to make payment of the RA bills that I was raising on a monthly basis within 30 days, my lords. Once every month is how it has been worded. So now it is my case today that they have completely failed to either provide either provide designs and drawings to me in a timely fashion. Even after the contractual period has ended, there are correspondence to the effect wherein I keep calling upon them to provide me the designs and drawings. Then, my lords, there are multiple correspondences with respect to the delay in payment of RA bills and non-payment of a few of these RA bills altogether. I will first, my lords, take your lordship to the work order that is there. Your lordship will kindly have, my lord, page 7 of my convenience volume. This is Exhibit B, my lord.
That you already pointed out. I take a note of.
Just one thing in that I wanted to indicate, my lord.
You are
that
in
quickly is
Exhibit
that
K.
It was my duty to provide a layout. The moment a work order was issued in my favor, I had to, within 7 days, provide a layout of the entire area and the basis on which the work had to be carried out. for which I called upon the respondent to provide me reference points. So, my lord, why this assumes significance is because only once I have the reference points will I be able to prepare an entire layout. Now, I write letters to the respondent. Your lordship will recall February 2018, the work order has been issued in my favor. April 2018, September 2018, November 2018. 3 letters I write to them, please provide reference points. Please provide reference points. The points that you've given are incorrect. So, your lordship will kindly appreciate this was the first step. This was the most basic step upon issuance of the work order that was to be conducted. Now, my lord, your lordship will have page 7 once. There are no clauses. It's in a paragraph wise manner, my lords. This is the second paragraph, my lord. You are accordingly requested to arrange for commencement of the work immediately and to take the layout within 10 days from the date of issuing this letter. So, for preparing the layout, I needed these reference points. Would it be your lordship's pleasure if I place these letters before your lordship?
So layout, when you place the layout?
The layout I have sought for the reference points on the basis of which I had to give the layout. So until unless the respondent authority does not give me the reference point of the areas, I will not be able to prepare the layout altogether.
Correct.
So for this, I have written them letters.
Yes, which letters?
Yes, my lord, your lordship will kindly have. This is Exhibit E. This forms a part of page 75 of my convenience volume. This is volume 1, my lord.
Page number?
Page 75, my lord.
Yes.
Lordship has page 75, my lord. May I please? This is to bring to your notice and kind attention that despite the arrival of final revised pile foundation drawing list, we find a bit difficult to start the work as the survey of the is still no complete. It is the earnest request from our engineering team that apart from the building distance and from boundary given to us, we are to be furnished with at least 2 or 3 reference points in and around our site to facilitate our survey expedition.
When the work order was issued?
Work order was issued in February 2018, my lords.
February 2018.
Yes. To be precise, 9th February 2018, my lord.
You issued the letter in April.
April. Before that, verbal communication was happening with respect to the same, my lord. This forms a part of Exhibit E, my lord.
Correct.
Then your lordship will have, my lords, page 76, the page after this.
Yes.
Yes, my lord. Page 76, your lordship will have.
That is Exhibit E.
This, my lord, is Exhibit E as well, my lord. This is a letter dated 5th September 2018. I am calling for a set of designs and drawings from the respondent authority. And then they say, your lordship will have, thank you for issuing below listed drawings to us, Narayan Kumar, who's the plaintiff, on 1st September 2018. I've listed all of that out. Your lordship will then again on 24th November 2018, my lord.
So this is the first you received the building plan?
Yes, my lord. These are the set of documents that I have received, which were not complete. So because of which I have then subsequently again written to them. Your lordship will have main building plan, bus stand. These are the list of drawings.
Yes.
Now your lordship will kindly have the last document, page 77, in this regard.
Yes.
This is a mail dated 24th November 2018, addressed to the chairman of Bongaon municipality. We have received drawings for A block on 1st November 2018. However, the same work could not be started as there were few difficulties on the layout of the same. The survey, as conducted by the third party, has been executed at site and detailed drawings as requested is attached herewith for your perusal. Kindly go through the same and let us know how to proceed with the same at the earliest. So, my lords, your lordship will see that November 2018, the entire layout is ready. on the basis of the reference points that they have given, and then we seek for their approval towards the designs and drawings, and then how the further proceedings have to have to follow. And this entire work period is for a period of 365 days.
So you have given the layout on 24th of November.
Layout is ready, I say, my lords, on the 24th of November.
Correct.
I give them the designs and drawings for their approval. And I give them the third party survey also by way of this mail for their approval.
Correct. But you have stated that you have received the drawing A block dated so and so and so.
Correct.
And what about this page 76? What has happened after receipt of the letter?
I will, my lords, I'll tell your lordship. So these are a list of designs and drawings that we've received. While I'll address the issue of designs and drawings, that is just subsequent to this. I'll take your lordship through what has transpired after this. So this is only with respect to the reference points that is there. So the first bit of it is failure to provide reference points. Then is designs and drawings, and then is RA bill payments.
So that's why I'm asking, you have received the building, whatever the plan drawing, you have received the drawing on February 2018. No, September to the 1st September 2018.
18.
Correct. So after September 2018.
5th September 2018, my lord.
1st September. You have written to 5th September, but
Yes.
you have stated that on 1st September. And
Right.
okay, thank you for issuing the bill on
1st
of
November. This is only for block A, my lord.
whatever it
Yes,
may
madam.
be. So this you have received on September, and you have writing the letter on 20. What has happened to the September to November after receipt of the drawing?
My lord, I'll tell your lordship. September to November, your lordship will see I have written to them saying that the drawing.
Because in November the 77 again you are telling that you have received the drawing of block dated 1st September November 2018.
I'll tell your lordship, my lords. The drawings in which there is an inconsistency or that the plaintiff feels that there is elaboration required, we write to them on the basis of those drawings. The drawings in which we feel that it is complete in all its nature, we go ahead and continue with the work. So only those drawings in which there are inconsistencies does the plaintiff raise an issue with the respondent, with the defendant. So this is the sum and substance of it. All that I want to indicate from this is that I cannot perform my end of the obligation. My lords, I'll tell you, lordship, if a contract provides for reciprocal promises and a party refrains from discharging his reciprocal promise, then the contract becomes voidable at the person who's aggrieved, and he's also entitled to compensation, my lords, for the loss that he's incurred because of the non-performance of the reciprocal promise. My lords, this is section 54 of the Indian Contract Act. This is the basis on which I want to place my case before your lordship today. First, reference points work order provided for providing a layout. I needed reference points for that. You failed to, in a timely manner, provide me the reference points. That is why it's come down all the way to November 2018.
But that's what I'm telling. Your work order was February.
Correct, my lord.
Correct. Then April, there was some
I write to them on April, my lord.
April comes, there was some communication.
Yes, my lord.
Correct.
Please provide reference points.
Then thereafter, then September you are getting the plan.
Yes, we are getting some drawings, my lord.
Drawing. You are getting the drawing. So September to November, what if you have got the drawing and you do not get the reference? So what has happened to September to November? That is the question that is to be seen, because
Yes,
you have to prove your case. You are prompt from the day
Correct,
one
my
for
lord.
executing
Correct.
the work.
Correct, my lord.
What they have done, that
Bowed
will
down.
reflect from the record, because they are not appearing. So that's why from the date of issuance of the work order till the November 2018, the work order, the reference was not given to you.
Yes.
So but you got the drawing. You got the drawing on 1st September 2018. And second letter you have issued on 24th of November. What has happened these
I've conducted the survey by way of a third party.
Where is that?
There I've written this, my lords, in page 77. Your lordship will have
So you have conducted the third party. Have you informed the authority? Yes, you are not giving that, and I am conducting a third party. Where is that?
So I'll tell your lordship, my lord. I have conducted the survey, and then whatever impediment I have faced while conducting the survey, or on the basis of the outcome of the survey, is something that I have intimated to the respondent authority by
Where
this
is
mail.
that
My
survey
lord,
report?
allow me to just read this mail once before your lordship, my lord. This is at page 77.
Yes, I am there only.
Yes, my lord. We had received a drawing for A block dated 1st November 2018. However, the same work could not be started as there were few difficulties on the layout of the same. The survey, as conducted by the third party, has been executed at site, and the detailed drawings, as requested, is attached herewith for your perusal. Kindly go through the same and let us know on how to proceed with the same at the earliest. As for the main building, many thanks for giving the go-ahead on pile cap casting at site. The same was started on 10th November 2018, post getting the green signal on such and such. So there are multiple jobs. I'll tell you, Lordship, my lord, the GIS job enumerated construction of bus terminals and residential complexes at Gandhipalli, which comes under the Bongaon municipality. So the work is happening. Not that the work is not happening. There are instances of delay on particular spheres. That is what I am indicating before your lordship. Now, my lords, if your lordship kindly has the issue of designs and drawings, your lordship will find that it was the duty of the respondent to provide me the design and drawings. The engineer in charge was the supervisor. Without his consent, I could not lay a brick at the construction site, my lords. I have time and
without the, I fail to appreciate here. Without the drawing, how the tender process is started.
My lord, so I'll show you
how you put the tender amount.
Your lordship will kindly have page 17 of my convenience volume in this regard. This is exhibit C, which forms a part of the contract. My lords, this your lordship will have clause 11. This will answer your lordship's query, my lords, a very pertinent query. So what they have very smartly done is that they have kept this aspect open. Your lordship has page 17, my lord. I am indicating clause 11, my lords, before your lordship.
Yes.
Placing clause 11.
Yes.
The contract shall execute the whole and every part of the contractor, that will be contractor, it's written as contract. The contract shall execute the whole and every part of the work in the most substantial and workmanlike manner, and both as regards material and otherwise in strict accordance with the specifications. The contractor shall also conform exactly, fully and faithfully to the designs, drawings and instructions in writing relating to the work signed by the engineer in charge and lodge in his office, to which the contractor shall be entitled to have access at such office or on site of the work for the purpose of inspection during office. My lords, this is clause 11. Now clause 12. The engineer in charge shall have to make any alterations in omissions from additions or substitutions from original specifications, drawings, designs and instructions that may appear to him to be necessary or advisable during the progress of the work, and the contractor shall be bound to carry out work in accordance with any instruction which may be given to him in writing, signed by the engineer in charge, my lords. So, two things come out of this, my lords. The engineer in charge is the whole and sole operator of the instant project, under whose supervision the project will be executed, and that we cannot proceed without the consent of the engineer in charge. Now, just one more clause which will answer your lordship's query. Clause 24 at page 22, my lords. These are conditions of contract which I am placing before your lordship.
Yes, 24.
Yes, my lords.
Yes.
All work to be executed under the contract shall be executed under the direction and subject to the approval in all respects.
Page 24.
Page 22, clause 24, my lords.
Yes.
All works to be executed under the contract shall be executed under the direction and subject to the approval in all respects of the superintending engineer, work circle of the such and such municipal engineering for the time being, who shall be entitled to direct at what point or points and in what manner they are to be commenced and from time to time carried on. So I am completely at the instance of the respondent authority.
I am not telling that. See, for the construction of the building or any construction work, if the administration want that this building is to be constructed or the bridge is to be constructed or whatever is to be constructed, what? First, the administration and the PWD persons, they will measure and they will, if plan will be approved and amount sanction will be approved, that is the preliminary sanction. On the basis of that, the tender will be floated.
Correct.
Correct. And thereafter, the contractor will be there, and on the basis of that plan, the work is to be executed. In the meantime, the plan is to be changed on anything that the superintending engineer, the executive engineer, or assistant engineer who will be the in charge in terms of the contract, that can be done, and it will be informed to the contractor. Now this is to be changed like this and that. So that's why I'm telling what. So you are telling with regard to you have participated in the tender, you got the work order, your amount has been sanctioned. So and you are telling that after that February your tender work order was issued, and September you got the plan. So how the work sanction was, and how this amount has been calculated by the planning section of the concerned department?
My lord, I'll tell you, lordship, there is a clause in the these contract documents which say that the drawings will be in a phase-wise manner disbursed. I'll
continue,
indicate that
continue.
clause.
Okay, no problem. Okay. You're on 77 then?
Yes, my lords. Now,
so what has happened after this letter, 24th November?
just
What will happen?
allow me. Thank you. Yes, ma'am. Now, your lordship will kindly have page 80 of my convenience volume. This is volume 1.
Yes.
We proceed on to 11th December 2018.
Yes.
That is a chronological extension of November 2018, the mail that I was placing before your lordship. This is December 2018, page 80, my lord.
Yes.
Pursuant to our side discussion on complications associated with the last drawing for Block A, we thank you for approval of revised version sent via mail on 4th December 2018. Our initial review of the same at site suggests that the same is okay and executable at site with present site boundary constraints. We are waiting for the hard copy to be given at site, post which we will call the third party team for survey of the same and mark the pile points in consultation of your team present at site. So then, my lord, this Block A issue is now resolved because we have given them the revised drawings in terms of the last mail and they've approved the same. So this is this. Now, your lordship will have the letter dated 5th February 2019, wherein I am calling upon them to provide me drawings for electrical, plumbing and duct details and other works that needs to be care of before slab casting, my lord. This, my lord, is at page 82. So lordship will see, like your lordship was indicating, all the drawings have not been given to me. Despite me asking for the drawings, I have been given these drawings in bits and pieces over a period of time. Now, at the end of the day, if the project is only for a year, it should be upon me how I have to complete and execute the project naturally so that the project is ready by the end of the year. If I'm not given these drawings or if I'm belatedly given these drawings, then naturally, my lords, it has an adverse effect on the execution of the entire project works. Your lordship will now, my lords, have page 82 of my convenience volume. This I'm addressing. It's a letter dated 5th February 2019, addressed to the chairman of Bongaon municipality. As discussed at site, we request you to furnish drawings related to electrical, plumbing, duct details or any other work which needs to be taken care of before our slab casting. We have already started with such and such work staging and shuttering of the same, it is very pertinent that we get the requisite details at the earliest so that it does not adversely impact the progress of our work at site. Malad. Again, another letter written dated 7th February 2019, my lords. This your lordship will have at page 84 of my convenience volume.
Yes.
May I, my lord? This is 7th February 2019 to Chairman Office, Bongaon Municipality. Subject reminder for requisite drawings to ensure smooth error-free work progress. So please initiate the process for getting the list of drawings requested on 19th May 2018, which shall allow us to execute the work with better planning and minimum errors. As highlighted in the previous letter, we have started the slab shuttering. However, as many
Exhibit E, bench. Yes, yes, continue.
Yes. However, as many architectural and structural drawings are not available, it is becoming increasingly difficult to continue this pace of work, and there might be many areas which will demand rework in the future. During the current process, we have executed the work as per the available drawings only, with no provisions for lintel, intermediate beams, chhajjas, etc., details of which were not furnished. So it is only on the basis of drawings that have been furnished, I have executed the work. This is the aspect of readiness and willingness, my lords, that I want to enumerate before your lordship.
Yes.
That I was at all material times ready and willing to give effect to my obligations in terms of the contract. So the basis the drawings that I have received from the respondent authorities, I have executed the work to the effect of such drawings. And this is something that I have in clear language enumerated and represented to the respondent authorities. That these are the fallacies, these are the drawings that you've given to me, and on the basis of these drawings, I have executed such and such work.
Have you sent in this letter?
I'm sorry, my lord?
Have you sent this letter?
This letter, my lords, is also accompanied by a mail your lordship will have on the next page, page 85. So a letter has been sent and a mail also be sent. So in the event there is no IC, there is no acknowledgement of
That's
receipt.
I'm telling.
So there's a mail also, my lords.
Where is the mail?
Page 85 your lordship will have.
8th February.
Yes, my lords. Same, purport and contents are the same. And then I've also attached the letter of 19th May 2018, which mentions the list of all drawings that I had sought for.
Okay.
So, your lordship will kindly appreciate 19th May 2018, I have sought for a list of drawings. And we are standing in February 2019. That is the last month on which I have to deliver them the project. I'm still asking for drawings. Then, my lords, there is a letter dated 13th February 2019. The same has been sent also by way of a mail dated 13th February 2019. This your lordship will find at page 86, my lord. Again knocking them, saying that please provide me the drawings. May I, my lords?
Yes. Page?
This is 86 and 87. 86, your lordship will find the letter, and 87, my lord will find the mail. The purport and contents of this, both the documents are identical, my lords.
Yes.
As highlighted in the previous letter, that a lot of things at site is getting delayed due to the pending drawings and clarifications. We are attaching a list of discrepancies within the existing set of drawings, which shall create issue for our progress of slab. And then these are, my lords, technical details that they have enumerated. Thanks for your continued cooperation. We request for the same on the above issue as well. So the parties are still in the process of ascertaining the designs and drawings and what will fit and what will not fit, because these have already not been provided to the plaintiff while it was participating in the tender. Just one last correspondence, my lords, I'll leave your lordship with. This is 11th March 2019. This your lordship will find at page 89 and 90, my lord. Same, 89 actually.
Yes.
Yes, my lords. May I just place this one? Thank you for your response to our letter dated such and such. We appreciate your take on our concern for progress of the site. As discussed previously, we have been running behind schedule for a long time pertaining to causes widely illustrated in almost all our previous letters, withdrawings, payments, site decisions, etc. You will be happy to note that post your payment, we have made all the requisite payments to our labor and suppliers team, which in turn has accelerated the work at site. In no time, the entire work strength shall be restored and the same extent as was prevailing a month back. It would be our earnest request for you to kindly provide us with the pending designs as discussed with you in detail already. Along with the same reduction in payment delays, hassle-free submissions of the bills will immensely help with the progress of the project.
Yes.
So, your lordship will kindly appreciate that the time period for the contract has elapsed. We are in March 2019 and I'm still writing to them. Please provide me drawings. Please provide me balance from. So this was the second aspect of it. The third aspect of it is RE bills, my lords. Your lordship will kindly conceive of a situation where I am working. This, my lords, is no small project. It is a project for 22 crores, my lords. Heavy machinery is required, manpower is required.
So what has
resources are
happened after the March?
My lords, after March, my lords, what happened is that they have told us to stop work, to then after a period of time to again resume work. Then to slow down work because they do not have the resources to pay the.
Where is that letter?
I will, my lords.
Slow downing the work. Where is the letter?
Your lordship will kindly have, my lord. Page 142. This is 11th July 2019. This is second volume, my lord. This forms a part of Exhibit G, my lord.
Page?
Page 142, my lord.
Yes.
Yes, sir. I write to them with the subject restarting of stopped civil work and bill payment of RA 7th. As per our discussion with your team at municipality office premises, we have been informed to conclusively stop the work till further notice on 13th June 2019. While we had slowed down the work on verbal requests even before that, we had been waiting for order to resume work for quite some time now and had kept the labor team on hold, by which
had been
causing us extreme financial losses. Also, just before slab casting, we had almost completed the tie beam on the back side of the building, which has been lying fully complete for over 2 weeks now. If we don't cast this soon, my steel shuttering items will be at risk in the oncoming rainy season. In the coming rainy season. Hence, we request you to kindly restart the work at the earliest, which it's not quite visible here, which
if not done now,
if not done now will engage
us in
deep
financial
financial and asset losses, my lords. And then we go out to say that these delays are costing us dearly, and there is ideal labor.
Yes.
And on the
then
your lordship will kindly have the next page, my lord, in this regard, my lords. This is the mail, same letter and mail, my lords. Then your lordship will have 144. This also forms a part of Exhibit G, my lords.
Yes.
19th July 2019. So the one that I placed before your lordship right now is 11th July 2019. This one is 19th July 2019. As described in the last letter, the situation is changing drastically at site for the worse. We are facing rampant thefts, violence threats, our management getting publicly abused and whatnot at site premises. The miscreants include local neighborhood, local suppliers, stroke vendors, political activists. Currently, we are being provided no security by the state, which is mandatory under the scenario. Also, as highlighted, our steel shuttering items are getting rusted with every passing day. It is our earnest request to kindly restart the stopped work so that we can finish the project in time, as this delay is causing us dearly financially and morally. Every day without work has a huge cost on us due to the establishments in place. We had received confirmation for payment from the team almost 2 weeks back now. However, our payments for the last submitted bill has not yet been received by us. This entire episode has cost us almost 2 months now and huge financial losses due to idle labor, machinery, management, team, and rampant vandalism. Request you to take prompt actions at the earliest to restore normals. These letters, my lords, in no explicit terms, uncertain terms, they state the situation that the plaintiff was facing at the site. It is like the respondent authority issuing a tender and then abandoning us altogether. My lords, your lordship has now.
What has happened to the work?
My lords, I have now abandoned the work.
Where is your amendment?
Yes, my lords. Your lordship will kindly have page 160, my lord, in
One?
this regard. Page 160 of my convenience volume. This is my letter dated 22nd June 21. But before, my lords, just a second. Before taking your lordship to this letter, my lords, I also wanted to take your lordships through a few more letters wherein they tell us to restart work again.
Where is that?
And then tell us to stop work, my lords.
Where is the restart letter?
Page 144, my lords, your lordship will have.
144 just your show.
144 just I have stored. Yes. Yes, page 145. I'm so sorry. This is also exhibit G, my lord.
It is your letter.
Yes, this is my letter. I am
asking for the restarting.
No, page 145 is I'm intimating them. Thank you for the green signal for allowing me to restart. Your lordship will kindly have this once, my lord. Thanks for your intimation.
Where is that? You have not annexed any of the letter of the authority.
No, I do not, my lords, have whatever documents I had. I am placing.
So how you can say how we can the court can presume where the letter they have given?
This, my lords, I'll tell your lordship, these documents have not been disputed by the respondent authorities.
Not disputed. That's why this is the undefendant suit. The court has to act as a defendant now.
I appreciate what's falling down from your lordship. I write to them, my lords, there's no contemporaneous objection to the purport and contents of these letters. This 26th July 2019, my lord.
Yes.
I write to them, thanks for your intimation to restart the work at site. We have received the payment in our bank
That's
account.
why thanks for your intimation to restart the work. Where is that intimation?
Well, then, these documents are something, my lords, I can only rely upon the annexures and the exhibits that I have on record, my lords.
No,
the ones that
see, you have how many documents? Four volumes, 6 volumes.
my lord.
You have given 6 volumes of document, but none of the document is of the authority. So it will be go against presumption will go against you.
No, my lords, I'll tell your lordship, whatever documents we have in our possession with
That is all your letter.
These are my letters. I've written to them. A few of the letters which they have written, that also we've annexed. The material ones I'll place before your lordship if required. But this transpires, we are writing them, we're corresponding with them through written representations, giving them an update from time to time of what is the status of the project and what are the issues because of which the project is being hindered. There is no reply, my lord. This is all telephonic. This is all verbal. They're telling me to restart. They're telling me to stop. That is why I'm trying to document all these.
You're sending the letter to the Ankan Sarkar. Who is Ankan Sarkar?
I'm sending this, my lords, to
Ankan
Ankon
Sarkar and
Sarkar.
Vikram Agrawal. Who are
Vikram
they?
Agarwal.
Who are they?
These, my lords, are the representatives of the respondent authority. I've also sent it to Bongaon PWD, my lords. Your lordship will find.
Where is
And then just below Narayan Kumar, your lordship will find Bongaon PWD, Bongaon Municipality PWD @gmail.com. And then I've CC'd it to these two individuals.
You're not sent to an executive engineer, assistant engineer, whatever it may. Okay. Yes, next.
Yes, my lord. So then they tell me to restart work, my lords, which I have documented here. Now your lordship will kindly have page 160, my lord. Before that, will your lordship have page 158, my lords? I'm sorry. Lordship will pardon me.
Yes.
This
158.
page 158. This also forms a part of Exhibit G, my lords. This is, my lord, a letter dated 28th July 2020. I write to the chairman of Bongaon municipality, saying that a fish market has now been sanctioned at the project site. May I just place this, my lord? Despite multiple reminders and discussions over the phone with Mr. Sada of your office, we are yet to see the payment in our account. It seems now that no efforts is being taken on our behalf to pay up the dues and last bill amount. We have seen it all here: violence, deliberate procrastinations, false commitments, threats, and above all, break of word and agreement. We are at very low point here now. We have faced severe losses and severe damage to our brand reputation in the area. While our team faces imminent threat till date by local vendors, which is increasing with each passing day. Now, on top of all existing problems, your lordship will kindly mark this one. Your team had given go ahead for a fish market, which stayed in the fourth week of May 2020 at our site. It resulted in plenty and material theft and pilferage at site. Post that, your team had given go ahead free access to the site to start their roadside vendor shops inside the campus of the site when there was so many materials lying at site. We have already suffered losses due to intermittent stoppages at site, mistimed payments, fund blockages, miscommunication, failure of commitment, etc. Now the losses due to theft as an added concern for us. We are not understanding on how we can move any further from this. We request you to kindly start the dialogue on way forward, and if there is any scope for revival of this project and the mistrust that has crept in here. Now, my lords, the opportunity cost that is also enumerated here. We might undertake large projects as compared to other petty contractors at municipality.
Okay, these are your
Yes.
representation. Where your you have cancelled that, withdrawn that.
Now, my lords, your lordship will have page 160, my lords. This is the
160 I
page right after this.
Huh.
I say that the project has now become unviable and that we are moving ahead. Page 409.
Page 160.
Yes, my lords.
Annexer.
This, my lords, page 160 is Annexure G, my lord. Exhibit G, I'm sorry. This 409.
160 Annexer G though.
Your lordship has this letter dated 22nd June 21.
Yes.
Yes, my lord. May I?
Yes.
The situation indeed has become unfavorable for business environment. We have highlighted local threats, thefts, rental losses, material scrappage, etc. in our series of 15 letters now. We have reached at a fag end of our efforts to revitalize this project. During this entire period of site being stalled and with suppressed speed of work, we have faced huge losses on account of idle machinery, manpower, and materials. Machinery is causing us losses of rupees 4,000 per day at site. Cumulative loss till date only account is over 15 lakhs. Now only on account of machinery, coupled with manpower and raw material losses, including shuttering and others, the figure goes beyond 35 lakhs in total. Considering, Malo, this is the important bit of it, considering the time-barred nature of the project and the unforgiving silence which has been here for past 2 years, the entire project has now become unviable. Rates in our contract is way beyond workable range. Moreover, our claims stands very tall as well. We sincerely hope that these tough times change and we can have a better future. Says that the entire project has become unviable and that the claims that we have now stand tall. Your lordship will see that I have participated in this project in 2018, wherein the work order was issued. We are standing in 21. My lords, the rates of all these objects change, of the manpower changes, so it does not become affordable or competitive for me to do the same project at the same cost which was there 4 years ago.
Yes, where is that your last order letter?
This, my lord, is the 22nd June.
Thereafter, 2nd July also the same letter was given.
Yes.
Kindly come to that. 22nd July, June. 22nd June.
This is 22nd June
Achha.
21, my lord.
Thereafter, no communication.
My lord, no. This and the same has been sent via mail, my lord. Then, your lordship, there's 22nd, there's 26th July 21
Correct.
as well. Your lordship will find that, my lords. Same thing. Now I request them to clear my outstanding dues, since the project has come to an end.
Yes.
That is what it is.
Yes.
So in terms of, I have exercised my right under section 54
Hmm.
because the contract was voidable at my instance, my lords.
Okay.
I've terminated the contract. And I've sought for the claims that I have before your lordship.
Yes.
So now, naturally, my lord, because the entire project is not over,
Hmm.
the no completion certificate can be issued.
Hmm.
If no completion certificate can be issued, that does not mean, my lord, that the respondent to the authorities today can unilaterally and wrongfully forfeit my security deposit and earnest money deposit that I've submitted for this project for no fault of mine.
Where is the claim? Print though. Print.
Lordship is having the plaint, my lord.
Outstanding payment, that is the running bill.
Yes,
Running
that is
account
the
bill
first
pending.
claim, that is the claim A. That I've
Unbilled work.
satisfied your lordship on.
So with regard to the how this is the 39 this running account bill, what is the annexes?
The running account bills, my lord. Just allow me a second.
That till 8th they have paid, na?
Yes, all 8 RA bills they've paid, although belatedly, but they
yes,
have paid.
that is annexer and exhibit
Yes,
N.
my lord.
Uh,
9th RA
exhibit
bills
N.
they have not paid.
Okay, then with regard to the claim on account of the unbilled work, does
This I have not placed. I have placed claim C after that. That is for security deposit and earnest money deposit because
Correct,
it
that
was
is
a
over.
quicker claim. This I've just got done with. I've shown you I've indicated the instances where they failed to give effect to the reciprocal obligation,
Correct.
because of which I was not able to perform my obligation in the contract, my lord. This is, my lord, is the second claim. Your lordship will recall 41 odd lakhs towards EMD, 45 odd lakhs towards security deposit. And both have to be refunded now, my lords, because naturally the project has come to a standstill because of no fault of mine.
Correct.
Third, my lord, is the claim, claim B, my lord, which is the claim for extra work or the unbilled work that is there, my lord.
Unbilled work.
Yes, my lord.
Okay, now come on the next day on that.
Yes. My lord, this is kind of voluminous with a lot of documents. That is why it is taking some time, my lord.
Concession suffering for the plaintiff. Counsel for the plaintiff has argued the matter at length, but due to paucity of time, hearing could not be completed. Case adjourned. Let the matter affect you the date. 14 July at 3:40. 3:45.
14 July.
14 July, 3:40.
Grateful, my lord.
Next.
This was only, my lord, kept today. My lord, that affidavit has to be taken on record, evidence or affidavit, which lordship wanted, my lord. So we've done that. So special, okay, special officer.
No, advocate commissioner.
Advocate.
May I file my
commissioner.
report, my lord?
My lord, the report.
Earlier file করেছিলেন report, এটা শুধু এই evidence and affidavit।
The report is already on record. This is only, my lord, the evidence on affidavit which your lordship wanted. My lord, I can argue today and lordship can pass the decree today itself, or my lord, I can, since the suit is getting disposed of, I can come back on another day also, whichever lordship pleases. But my lord, this exercise, my lord, Lordship will kindly record, my lord. That has been done.
Yes. Sensation suffering for the plaintiff. Advocate Commission is also present and submitted report. Serve the copy. Have you served the copy?
Soft copy has been served, my lord. I will serve a hard copy with the
Serving the
letter.
Hard
to
copy
the
darkar.
counsel for
Hard
the
copy
plaintiff.
why?
Have you received the remuneration? Not. Yes.
I'm yet to receive
It has
it.
been
Receive any
transferred, it
notification.
has not. So that makes it more important, my lord, to have it on another day.
I will confirm it with them once I receive a notification, my lord.
File the report after serving the copy to London counsel for the plaintiff. Let the same be kept with the record. Counsel for the plaintiff prays for
IMPS শুরু সঙ্গে
fixing
সঙ্গে চলে
another date for argument. Let the matter appear on
Any day, my lord, for 10 minutes. That is all. Fix করে না।
10 minutes is a difficult.
10 minutes, my lord. Any day, 10 minutes, even 5 minutes. 115, হ্যাঁ। তুই পিছনে গিয়ে দাঁড়া, ওইখানে দাঁড়াতে পিছনে যাবো। Go at the back, একদম।
14th July 1 p.m.
মানে when?
14 July 1 p.m.
14 July 1 p.m. হ্যাঁ, আছি।
I am not discharging you.
No,
If
no,
you
please.
take the
no,
remuneration,
please,
then I will discharge.
let him receive. Mano, that is very important. 14 July 1 p.m. Wait.
Grateful.
So I am appearing on this point, but I have not received the copy of the application. We intend to move it expedited. I need to know, my lord, what. May I just say this, my lord? Mr. Gupta, Mr. Gupta is the arguing counsel in this matter. May it be not today. If we suffer the fate, serve a copy of the let us
There appearing caveat is there.
No.
It's a new motion. New motion.
Yes. We have. No caveat. Let us take an attempt, my lord.
Caveat is there. If
No,
no caveat is there, how it can be?
Caveat is not there, my lord, but I am praying, my lord, they can have a copy of the application. Yeah, I also don't know what. But our entire intent is to move it expedited. My lord will give us one opportunity any day subject to my lord's convenience. If we fail on that day, we shall serve.
Sensation suffering for the plaintiff, sensation suffering for the defendant, counsel for the plaintiff prays for time. Case is adjourned. Let the matter appear on 2nd July.
Oblige.
Next.
But my lord will not direct them to serve a copy of the
In the
application.
minutes.
No minutes.
Come on, that they will see.
Yes, my lord. Yes.
My lord, item number 99 for the plaintiff. my lord.
On behalf of the defendant, my lord, I was to take instructions from the defendant that whether they are willing to take the dealership in this matter, my lord.
Not only that, your lordship has also said that let the matter be taken before the mediation for the purpose of
No,
settlement.
that's why if they are taking,
Yes,
taking the
yes.
instruction, so here
That
now
is
the
our
matter
prayer,
can
my
be-
lord. That is our prayer.
Not
That is-
taken instruction.
I have taken instruction, my lord. That is what we are ready to take the dealership, and my lord, for that let the matter be referred to mediation, and we will, my lord, come up with
This
some
offer was
resolution.
already granted to them. It's been pending at their instance.
So you
This
do
is the
one
first time
thing.
that they have
You
said
do
this
one
in court.
thing. You come with an affidavit. You are ready to take the dealership.
Lordship would kindly
Come-
record
Can
his
that, no,
undertaking.
recording does not. I am recording, but you
Yes.
come with an affidavit.
Yes, Your
Two-page one-page affidavit. Come on that. Serve the copy to on the basis of the affidavit. I will dispose of. Then he
Yes,
will
and
take
we
up.
can
Lord,
discuss before
let
the
them
suit.
grant us a copy of the agreement which they want us to enter into.
That's why I'm telling you, come with an supplementary affidavit which you are ready to take.
Yes.
Then I will pass appropriate order, whatever
can-
the
yes.
agreement and all the formalities may complete. I will not dispose of. Then the formality completed,
Yes.
I will dispose of them.
Yes, grateful, grateful.
How soon?
Lord, one
Next
week,
week?
1 week time.
Next
my lord.
week?
1 week.
So applying for the plaintiff,
Lord, actually 2 week time because Lord, the person he lives 8 hours away from Kolkata.
Police staff counsel for the defendant submit that the defendant is ready to take the dealership of the plaintiff. Plaintiff agency, plaintiff
company.
Dealership of the plaintiff company. Accordingly, prays for time. to file supplementary affidavit. In view of the
Recording such undertaking.
supplementary affidavit by way of an undertaking that the defendant is ready to take the dealership of the plaintiff company.
My lord, only submission, it cannot be unconditional, my lord.
No.
Yes.
That's why I am
Yes.
not passing any order.
Grateful.
So let the supplementary affidavit be filed within 2 weeks.
And
Let
Lordship,
the
may an
matter-
advance copy be served upon us? So that
After serving the copy to the learned counsel
Grateful.
for the plaintiff, let the matter appear on 16 July.
16th July.
Okay.
Grateful.
I am appearing for the respondent number 2 and 3.
Yeah.
8 days, my lord.
Yes.
My lord, may I very briefly indicate this application is for substitution.
What is the
Nothing else.
application number?
IA 8, my lord. IAGA 8.
8. Yes.
8 of 2023. my lord.
Master summon or notice of motion? No, IA 8.
GA 8, my lord.
Yes.
Notice of motion, my lord. Notice of motion. There's an application for substitution. May I give a brief background? My lord, this relates to a partnership firm. In 2011, my lord, there's an arbitration clause in the deed which states, my lord, that arbitration can be entered into, but after, my lord, a finding on any aspect, dissolution cannot be gone into by the arbitrator. Arbitration started, my lord. There were disputes between the parties. While the arbitration was ongoing, my lord, disputes were there. The issue fell for consideration as to whether this is a partnership at will. But the honorable arbitrator, my lord, Justice Bhaskar Bhattacharya was the arbitrator. My lord, he rendered a finding that this is a partnership at will. My lord, we immediately, my lord, while the arbitration was ongoing, we issued a notice under section 43. Under section 43, my lord, dissolved the partnership firm. This is on 13th of July. The dates are very interesting, my lord. 13th of July, we issued this notice. We say the partnership firm stands dissolved now. 2 days later, my lord, we receive a notice of expulsion from the partnership firm. 2 days thereafter, my lord, the plaintiffs, they reconstitute the partnership firm. In the meantime, my lord, the honorable arbitrator terminated the proceedings because of the finding in the order. It's a, my lord, termination order which is more than 150 pages. Because everything is discussed, there's a finding there that this is a partnership at will. And it's also stated there that I can't proceed any further because after this, the dissolution aspect, there's a bar in the arbitration clause in the partnership deed. I cannot proceed with the dissolution. That's the finding. Section 32, termination, the proceeding is terminated. The plaintiffs initiate this proceeding challenging the notice of dissolution dated 13th of July. They say this notice under section 43 of the Partnership Act is bad in law. We file a counterclaim seeking a declaration that this is a partnership at will, this document is correct, and for the further proceeding under the rest of the provisions of the Partnership Act for dissolution. Dissolution. And there's an alternate prayer saying, my lord, in case you don't go by this, then it should be dissolution by court. The subsequent, my lord, prayers. This is the suit which is pending adjudication. I'm not going by the other aspects. In the interregnum,
Order of termination not challenged by any of the party.
Not challenged, my lord. Not challenged. In fact, my lord, there are subsequent proceedings here. In fact, there are interlocutory applications, several of them filed, because, my lord, the facts, the crux behind the entire dispute is, my lord, the corpus of the firm. On that date, my lord, of dissolution on 13th of July, my lord, there was a, from the accounts, it's evident, there was, my lord, 666.67 crores, which was due and payable to us. And thereafter, my lord, a lot of things happened. The suit is pending adjudication. The defendant number 1, my lord, is suffering from kidney failure. 2008 it started, 2010 he had a, my lord, transplant. It is again failed. At this stage, my lord, 2020 onwards is again suffering. Now, my lord, it's everyday dialysis. In Singapore, my lord, he is awaiting a transplant. He is running out of funds, doesn't have money. We have filed application. Those disputes are ongoing. That's GN9, my lord. Where, my lord, we could not have an order. My lord, there's an appeal. Appeal is, my lord. So that's a separate proceeding where, my lord, we are seeking money. But nothing of this, none of these petitions, my lord, can now be proceeded with unless and until, my lord, this substitution happens. Now, it's a simple substitution, my lord. We have stated, if your lordship kindly takes up our notes, we have filed it.
Defendant number 1.
The substitution of plaintiff number 1. As with the as of plaintiff number 1, my lord, may I hand over, my lord, notes which, my lord, will refer to. Skeleton notes, sir. No. Extra hand. Do you have one more?
Yes.
My lord, I'll give a quick background to this. During the pendency of the suit, my lord, on 16th of June 2023, plaintiff number 1.
Filed the suit. Yeah.
My lord, plaintiff number 1 is, my lord, Mofazullah Rahman. That's paragraph 5 of our notes. I'll refer to that, my lord, that will make it easier. Because the defense which has come in is very interesting. My lord, here is the case before your lordship. Plaintiff number 1 admittedly has, my lord, passed away on 16th of June. The heirs on record. My lord, before I indicate the details, 2 points they have taken. First is that the heirs have taken time saying that we'll first think whether we want to become a party to the partnership firm. We want to become a partner in the partnership firm. That's not an issue. But here the petition is very limited. Substitution in the proceedings, there's a right to sue. We have a counterclaim, my lord, which is pending. So our contention is that you be instituted, you have to be substituted in the suit. Their contention is, we don't want to, we are staying in different places. We don't want to come and be a partner in the firm. We say that we agree with you. That's exactly our contention. Because our contention is there is no firm. The point which they have raised, I'll show from the affidavits, the point is that we are not interested in being a partner in this firm. So we don't want to be substituted. That's not a choice that they have. It's a substitution in the proceeding, not in the firm. Today our contention, and I concede with what they are saying, you can't be a partner of the firm because our case is this, that the partnership firm is not there. But in the proceeding, you have to be. And why so, my lord? Now kindly permit me to indicate in details. Your lordship will only refer to the written notes. We have indicated everything in the written notes. But kindly take a paragraph 5 onwards, because the previous, my lord, part we have just encapsulated what I've told your lordship. Paragraph 5, my lord. During the pendency on 16th of June, the plaintiff 1 died. It's an admitted position. Since they were not taking any steps, defendant number 1 filed this petition for bringing on record the legal heirs. That's us, my lord. We have filed this petition. They were survived by wife, 2 sons, and 3 daughters. Details are given in paragraph 8 of the petition. So there's a chart which we have given. If your lordship is pleased to take up page 9, your lordship will find that page 9 of the application. I'm cross-referring, my lord, so it will become.
Yes.
Page 9, there's a table, my lord.
So plaintiff was only 1 when the original plaint was filed.
Plaintiff 1, 2, 3, my lord.
Originally.
3 plaintiffs, right? 3 plaintiffs, my lord.
3 plaintiffs.
This is the first plaintiff who passed away, my lord.
And who are the other plaintiffs?
The other 2, my lord, are
of the original plaint?
4 plaintiffs, my lord. I stand corrected. 4 plaintiffs, my
Who
lord.
are the other plaintiff? One is died.
Milord, others are Milord
My lord, I appear,
Saroj
my lord, for one of-
Yazdani,
I
Sheraj
appear
Yusuf.
for
They are
one
all
of them.
partners of the firm, Milord. According to them, Milord, they
the
are partners.
partners.
Yes,
How
Milord.
many partners were there in the partnership firm?
5, Milord.
5. You are one of the partner.
Total, kitna hai? We were one of the part. We were, Milord. There is no partnership firm according to us.
No, you were the one of the partner.
We were one of the
and you
partners.
dissolved that at will as per the.
My lord, my lord.
So thereafter they filed. All 4 partners are filed.
Yes, Milord. There are total 7 partners, Milord. 4 plaintiffs, 3 defendants.
Two of them are
Okay.
Two of Milord, the defendants.
So you want that the first partner's legal heirs to be brought on.
That's all, Milord. And defendant numbers 2 and 3, Milord, are supporting the plaintiff. So we are the lone warriors, Milord. Defendant numbers 2 and 3 are supporting the plaintiffs. They are all, Milord, together. But very small point I have indicated in that table at page
So
8.
instead of this, if they were supporting, you made them as a transpose and proceed with the matter.
Milord, plaintiff number 1 has also, Milord, the legal heirs have to be placed on record, and I'll indicate why. Milord, will kindly take up.
What is the suit? That is the cancellation. If the legal heirs, what legal heirs?
I'm very grateful, Milord. We have explained that in the notes. The reason why they have to come in, we have explained because, Milord, subsequently, Milord, because our counterclaim is on record. Our counterclaim, Milord, we have stated that pursuant to, Milord, the dissolution, the subsequent actions need to follow. Where, Milord, and we have explained, kindly permit me 5 minutes, Milord. From the notes, I'll make it very clear. This is paragraph 6 of the notes, Milord.
Yes.
In spite of the application being filed, plaintiffs and the other defendants in the suit had taken time on many occasions, did not allow the disposal of the application. Kindly, not on merits, paragraph 7. As per clause 9 of the partnership deed, this is very important, Milord, because this is what they will contend. And this, your lordship will find in the affidavit of D2 and D3. May I also correlate this, so, Milord, it will become easier. Clause 9 of the partnership deed, maximum 3 legal heirs of the deceased partner can be included in the said partnership business, and as on, and thus from 16th of October 2023, when the matter appeared before the Honorable Court, the advocate appearing for the plaintiffs requested the court to give 6 months' time to take a decision as to which 3 legal heirs would be included in the partnership. It's very important, Milord. On 7th of December 2023, matter was taken up again when the learned advocate drew the attention to the letter of 18 July 2023, when the legal heirs of the plaintiff number 1 requested for 6 months' time to take decision as to which of the 3 heirs. So, Milord, they have not disputed till then. The only contention was because there's a clause 9, which is, Milord, page 21 of the affidavit in opposition filed by D2 and D3. So, Milord, legal heirs requested for 6 months' time to take decision as to which of the 3 legal heirs. This was till 2024 January. Thus, further time was granted by the Honorable Court till 30th January. Milord, it was made clear by the Honorable Court that if you do not indicate anything, then we'll proceed in accordance with law. This order, your lordship will find at page 12 of the notes. We have annexed this order. If my lord kindly notes that, annexure A is page 12. This is that order we are referring to.
Yes. Yes.
So thereafter, stated in paragraph 9, Milord, plaintiff 1 had agreed to substitution by 3 of his legal heirs. Thus, plaintiffs have agreed to substitution, cannot oppose now, they are stopped. That's the first point, Milord. You have agreed once, you can't approbate and reprobate. Now, Milord, kindly take a paragraph 11 of the notes. 19th February 2024, this matter was again taken up, Milord, and a notice was served. Department has served notice on all the legal heirs. All the legal heirs received the notice. They appeared in court. But this, your lordship will kindly take up page 17. We have annexed the order with page 17 of the notes, Milord. Page 17, Milord.
Yes.
Thereafter, Milord, we have stated in paragraph 12.
Yes.
Paragraph 12, Milord, on 6th of May 2024, the Honorable Court directed defendant number 1 to make paper publications. We have done that. And that order we have, Milord, annexed at page 19. So paper publication is done. Thereafter, paragraph 13, Milord, 25th June 2024, it records publication has been made in terms of the order, affidavit of assets filed. This is annexure D. It's at page 21, Milord.
Yes.
Page 21. If your lordship makes a note, my lord, I'm sorry, I should have indicated the page number. It's page 21 of the note, my lord.
Yes.
There was 3rd of September, that's paragraph 14 I'm indicating, my lord. 3rd of September, matter was again, it was taken up. There was a liberty given to file supplementary affidavit. Paragraph 15, plaintiff agreed to the substitution, but now they have changed. Now, the legal part is, my lord, paragraph 16 onwards. Order 23, Rule 3. Since one legal representative of plaintiff 1 to the dissolved partnership has right to decide the legal heirs and legal representatives who will inherit the assets of the estate or the estate of the deceased partner. Apart from that, Order 22, Rule 10. Since plaintiff 1 has died during the pendency of the suit, there has been devolution of interest from plaintiff 1 through his legal representative. So we have referred to these two provisions. Thereafter, paragraph 17, section 50 of the CPC, we refer to, my lord, that judgment debtor dies before decree is satisfied. The holder of the decree may apply before the court which passed to execute this against the legal representative, given the definition, my lord, 211. We have referred to that. And over the page,
Yes.
got paragraph 18.
Yes.
In terms of section 46 of the Act, Partnership Act, on dissolution of the firm, every partner and or his representative is entitled, as against all other partners or representatives, to have the property of the firm applied in payment of debts and liabilities of the firm, and to have surplus distributed amongst the partners or their representatives according to their rights. We've quoted that. And paragraph 19, we've stated in terms of section 46 of the Act, once the firm is dissolved, if any such partner has died, his legal representative is entitled, as against all partners or their representatives, to have properties of the firm applied in payment of debts and liabilities, and to have surplus distributed amongst them, amongst the partners or their representatives according to their rights. Since the partnership firm stands dissolved, legal representatives, they are entitled to have the property utilized in payment of debts and liabilities, to have the surplus distributed amongst them according to the rights of the deceased partners, the rights of 25%, and thus representatives have acquired this 25% in the partnership firm and is entitled to pledge the assets of the firm to pay off the debts. And if there is any surplus, the legal heirs will get this 25% surplus. Thus, to the extent of 25%, they have acquired interest, and thus they are liable towards each and every partner under 46 for utilization of the property. This is where, my lord, it subsists. The paragraph 20, we have referred to 47, section 47, 48, and 50 of the Partnership Act. We have stated, my lord, once it is dissolved, the extent of shareholding of the deceased partner, legal representatives are liable. We have a counterclaim, my lord, in the proceeding. Thus, substitution is very much necessary to bring on record the legal representatives in view of the legal provisions which we have stated and section 50 of the CPC. Paragraph 21 is of extreme relevance, but this is where we deal with what their contention is. You will kindly note this, paragraph 21. The legal heirs of the plaintiff number 1 have filed affidavit wherein they have said that they do not want to be partners of the partnership firm. Even the defendant number 1 has not filed substitution application for making the legal heirs of the plaintiff number 1 as the partners of the partnership firm, and thus on the ground the legal heirs of the plaintiff number 1 cannot oppose substitution. I pause here for a moment. Our case is, you can't become a partner of the partnership firm. So if you don't want to become a partner of the partnership firm, we concede to that. You should not. Defendant number 1 only seeks substitution of, so my lord, paragraph 21 and 22, we have dealt with their contention. Only seeks substitution of the legal heirs, legal representatives. As the firm stands dissolved, the legal representatives are liable or entitled to pay off the debts of the partnership firm by utilizing the assets of the partnership firm and obtain surplus as per their shareholding. Now, this is our counterclaim. Our counterclaim is that letter of 13 July is correct. That declaration and the subsequent, my lord, remedies to which we are, lord, entitled. Then paragraph 23, we have stated, my lord, defendants, in their opposition have said that the legal heirs are not bound to be substituted in place of the deceased partner, as without the absence of legal heirs, any partner of the firm cannot decide their fate as to whether they should be added as a partner. So they can't decide on this, my lord. So it is not a point which we have made in this application. Our application is limited to substitution in the proceeding. We have encapsulated, my lord, thereafter paragraph 24, 25 and 26, my lord, we have again highlighted that there is a difference between the stand taken by the plaintiffs and defendants and the present law as it stands as on date regarding substitution. Paragraph 27, my lord, we have stated. We have relied on judgments now. I'll just indicate, my lord, the paragraphs. I'll not refer to the entire thing, my lord. Kindly see paragraph 27. We have laid down the proposition first. The defendant number 1 relies upon these judgments to show that this is the proposition. The decree for accounts and other decrees in the dissolved partnership firm is not a personal claim, and the dissolved partnership firm survives against the legal heirs, and substitution should be effected in such case. You also will find first judgment that we refer to the 1967 Supreme Court 1124. You also will find this at page 22 of the note. And the relevant paragraph, paragraph 14, I'll not read it out. That's page 31 at the bottom. It starts 3 lines from the bottom. So the judgment starts from page 22. Page 22, my lord. And the paragraph 14 is at page 31 at the bottom, my lord, 3 lines. Starts from there, my lord.
Yes.
I'm not reading this out, my lord. And the second judgment on the point, it starts from page 33. It's AIR 2022, Calcutta 201.
Yes.
But paragraph 9 at page 35, my lord.
Party?
35, my lord. Paragraph 9. Page 35, paragraph 9. 7 and 9, my lord. That's the concluding paragraph, 7 and 9.
Yes.
Both at page 35.
Yes. Yes.
The second point is, my lord, we say to the extent of the share of the deceased partner, partner is required to be substituted by his legal representatives, as they are liable to other partners to the extent of the assets of the deceased partner in the partnership firm. For this, my lord, we have relied on 3 judgments. The first is a Privy Council judgment, which starts from page 36.
Yes.
1934 Privy Council 134. The relevant part, my lord, is at page 41. Your lordship will find at page 41, after the first 2 paragraphs, at the left-hand side, there's a marking 142.
Yes.
It's from there, my lord. That's the relevant part, my lord.
Yes.
The second judgment which we have referred to is, my lord, a Punjab and Haryana High Court judgment, 1971. Punjab Haryana 186, starts from, my lord, page 45.
Yes.
Page 45 of the notes. The relevant paragraphs 5, 6, 7, and 8, my lord, starts from page 46 onwards.
Yes.
My lord, thereafter, it's a Gujarat High Court judgment, my lord, AIA 1994, Gujarat 206, starts from page 48. The relevant paragraphs, your lordship will find at page 49. 3 and 4, my lord.
Yes.
These are my very respectful submissions. Well, I'm not indicating in details, my lord, the affidavits that they have filed, but very quickly, my lord, may I, because the premise is this, my lord, that we can't be added for this reason. We have indicated in the notes. Your lordship will find this from the affidavit filed by P3. Their contention is at page 4 of this affidavit in opposition.
Opposition of defendant number 3.
Plaintiff number 3, my lord. This is affirmed, my lord, by Siraj Yusha on 6th of October 2023.
Yes.
Because the facts are stated in paragraph 6 at page 4, which is their contention.
Change around.
Yes.
Their contention, if your lordship takes up page 9, paragraph 13 onwards, this is what they have stated. They have also referred to clause 11, and their contention is this page 9, my lord, Roman 13.
Yes.
Please.
Clause 11 of the partnership deed dated July 18, 2019. This is something we are controverting, because we say this is not the partnership deed at all. Makes it apparent that all legal heirs of deceased would not be automatically be made partners of the firm. Instead, this is contemplated that in the case of legal heirs, deceased partners
suppose
exit
they are
the
not
same.
come forward the partnership, what would the effect?
The subsequent provisions which relate to dissolution and their rights, we have a counterclaim. So if we have a counterclaim specifically against the partner 1, then the legal representatives are liable. So 211 defines the legal representative, and we have also indicated in the notes that this is not different from under the CPC or the Partnership Act 1932. It's the same. So today, if I have a right against the deceased partner, this will not be fulfilled by anyone else other than the legal heirs. So my right to sue subsists. The only point which I have shown is if the right to sue subsists, if my challenge subsists, and there is a remedy in law to which we are entitled to, where it is the obligation of the partner who is deceased. This has to be fulfilled by the legal representative, the heirs. And that is why my prayer. They have tried to create an artificial distinction that we, being the legal representatives, we do not want to be involved in the proceeding because we don't want to be a partner of the partnership firm. Our contention is simple. We concede there because you can't become a partner of the partnership firm. It has been dissolved by us. So today you can't come and say that I want to become a partner of the partnership firm.
Yes.
That's all, my lord. My very limited. Today, a distinction is this. My prayer is that they have to be made a party to the proceeding.
As a representative.
I'm grateful. And their prayer is, you can't make me a partner in the firm. We don't want to. We can't. That's what we are saying. This is, my lord, because the firm doesn't exist.
Yes.
These are my very, very limited submissions, my lord.
Okay.
This is stated. I'm very grateful to my learned junior. It's in the affidavit in opposition filed on behalf of the legal heirs of the plaintiff number 1. This was pursuant to a leave given by the Honorable Court that they filed this affidavit. They've stated the same in paragraphs 9, 10, 11, and 12. It's only this. We have encapsulated this, my lord, in the. If your lordship so desires, my lord, will indicate. So this is the affidavit. It's not indicated. Affidavit in opposition filed on behalf of the legal heirs of the plaintiff number 1. Who has affirmed this? Just check that. It is affirmed, my lord, by Khalikur Rahman on
Yes.
27 January 2025. Paragraphs 9 to 12. Same thing, my lord. And this, my lord, clause which they are referring to, I told your lordship, my lord, there are 3 important days. 13 July is when, my lord, we issue that notice of dissolution. 15 July when they expel me. And 18 July when they reconstitute the partnership firm, which we say it can't be done. This is, my lord, referred from the reconstituted partnership deed, which we say it can't be.
Okay.
These are my very humble submissions, my lord. Very deeply obliged. Lord, one of those occasions when, my lord, I have served the written notes on my learned senior friends, which otherwise, my lord, we wouldn't, but then it's a point of law, so, my lord, we have done that.
Yes.
Deeply obliged.
My lord, one factual thing has not been pointed out. Kindly have a look at the application. My lord, I'll rely, my lord, on your lordship's judgment for dismissal, my lord, of the application. Kindly take GA8, my lord.
Yes.
Lordship has that, my lord?
Yes.
Kindly see the prayers.
So not an application for substitution.
Amendment.
And my lord, it's a proposed amendments only to the written statement and counterclaim,
Yes.
which is asked for. Now, my lord, kindly have a look at your lordship's judgment. My lord, in my lord Thakurani, should not have given him a copy, but I'm giving him a copy. Yeah, yeah. Now, my lord, kindly have a look at paragraph 1 and 2. The plaintiffs have filed the present application being GA4 of 2023 praying for amendment in the cause title, body and schedule of the plaint as mentioned in the proposed amendment annexed with the application. 2. The plaintiff submitted that plaintiff 4 died on so-and-so, leaving behind his wife so-and-so, and thus name of original is to be deleted and name of wife of so-and-so. Plaintiff 4 was also power of attorney holder and now so-and-so. Cause title after description, etc. Plaintiffs further submitted so-and-so. It is further submitted and prayer para 8 and prayer A is to by deleting the word and by incorporating so-and-so. Submits that the amendments are formal and will not change them, and cases are cited. Then, my lord, defendant filed by is not maintainable under law as the plaintiffs cannot substitute legal heir of plaintiff number 4 by way of amendment and also cannot add so-and-so by way of amendment. Defendants have a specific provision in the code for substitution of legal heirs and addition of plaintiffs, and the same cannot be allowed by way of amendment. Defendant submitted that I will change it. My lord, that's it. Then, my lord, para 11. Heard the learned counsel for the respective parties. I'll go slowly here, much slower than my lord, when my learned friend was spacing the judgments which do not apply. Peruse the materials on record and the judgment relied by the counsel for the plaintiffs. The plaintiffs have filed the application for amendment in the plaint as indicated in the proposed amendment enclosed with the present application. The plaintiffs by way of amendment also intend to substitute the legal heirs of plaintiff 4 and also intend to add plaintiffs 8 and 9. Then order 6, rule 17 is my lord quoted. Plaintiffs intend to elaborate the description of suit property in para so-and-so. In para 8, prayer portion of the plaint intend to pray for eviction, ejectment of through original pair was only for possession. This court finds that the said amendments will not change the nature. As regards deletion of the name of plaintiff number 4 on account of death of plaintiff number 4 and substitution of legal heirs of plaintiff number 4 and addition of the name of plaintiffs 8 and 9 are not permissible within the purview of the provisions of Order 6, Rule 17 of the Code. In the Code, specific provisions have been provided for substitution of the legal heirs of the plaintiff on the death of the plaintiff. In the said Code, there is also a provision having been provided for addition of parties. In view of the above, this court is of the view that substitution of legal heirs of plaintiff number 4 and addition of so-and-so is not permissible under Order 6, Rule 17 of the Code. In such circumstance, this court allows the prayer only with respect to amendment of so-and-so, prayer A and concise statement. As regards remaining proposed amendments, they are all rejected. So, my lord, now kindly have a look at, my lord, your lordship seen, my lord, their prayers. Kindly see what is, my lord, they are seeking the amendment, my lord, regarding. Kindly take, my lord, the GA 8. My lord, page 14, I believe, my lord.
Yes.
Page 14, my lord, in place of 1, my lord, 7, my lord, are mentioned. Then, my lord, kindly come to, my lord, paragraph 1, my lord, of the written statement. It's only, my lord, substitution being sought regarding counterclaim. Plaintiff number 1, plaintiff 2 to 4. Deceased. Then, my lord, kindly see para 2 at page 4. It's just the substitution of the names.
Yes.
Similarly, my lord, page 10, my lord, paragraph, my lord, 7, subparagraph F and H. My lord, where there's plaintiff number 1, there, my lord, deceased plaintiff number 1. And my lord, otherwise, my lord, substitution. Now, my lord, kindly have a look at, my lord, what are the prayers? My lord, this is, my lord, point number 1. On the face of it, my lord, this application, my lord, for substitution cannot be made in the garb of, my lord, an application for, my lord, amendment, my lord, of either the plaint or, my lord, the, my lord, written statement and counterclaim.
Yes.
Now, yes. Now, my lord, at page 11, my lord, your lordships would find, my lord, the prayers.
Proposed amendment indicated in red.
Yes. No, my lord, I'm showing the prayers, my lord, in the counterclaim.
Okay.
Now, my lord, kindly have a look, my lord. Prayers A, B, C, D. Preliminary decree for dissolution with effect from so and so of, your lordship has that, my lord, page 51.
Yes.
My lord, that's, my lord, the unamended portion. So, my lord, these were the prayers. Preliminary decree for dissolution with effect from July 13 of having registration and constituted by deed of partnership dated so and so. In Appendix D. Final decree for dissolution in Form 22. Then alternatively, having be constituted by deed of partnership be dissolved. Then, my lord, perpetual injunction restraining plaintiffs and defend numbers 2 and 3, so and so from carrying on any business with the assets of the partnership firm or in the name of partnership firm or deal with any asset. Perpetual injunction restraining plaintiffs, defend numbers 2 and 3, and other men assigns and so from selling any assets. Declaration that purported expulsion of one from so and so is illegal, null and void, all documents. Now, my lord, here your lordship's been told, my lord, and my lord, this is the affidavit also of, my lord, the heirs, my lord, which have been filed. And I'll show, my lord, the relevant clause here of, my lord, the partnership deed. My lord, kindly come to, in fact, I should show, my lord, the relevant clause of the partnership deed. My lord, after, my lord, the, my lord, expulsion, my lord, we stand by the fact that he had been validly expelled. And, my lord, that his notice for dissolution was bad, illegal, null and void. So, my lord, after he gets expelled, my lord, the plaintiffs became the only partners. My lord, the partnership firm was, my lord, reconstituted. Now, kindly have a look at that reconstituted, my lord, deed of partnership, my lord, which is, if your lordship comes to, my lord, my lord, affidavit in opposition.
Of plaintiff number 1.
Yes, no.
Legal years of
15 is the original one, then the reconstituted one. My lord, this was the original deed, page 15. My lord, the affidavit of plaintiff number 3.
Page.
My lord, could we continue next day, my lord? I have some problem, my lord.
Already 4:30.
Oh.
4:30.
Oh, I'm sorry.
So and so suffering for the plaintiff. So and so suffering for the defendant. You are appearing for the plaintiffs.
Plaintiff number 3, my lord.
Plaintiff
Only
number
plaintiff
3.
number 3.
And
I'm for the respondent numbers 2 and 3. 2 and 3.
2 and 3.
Defendant number 1.
Defendant number 1.
Plaintiff number added plaintiff number 1. Legal years of plaintiff number 1. No, plaintiff number 1. Legal years.
Plaintiff number. This is plaintiff. Counsel for the defendant number 1 has concluded his argument in connection with the date of 2020. The counsel for the plaintiff number 2 has argued the matter, and plaintiff number 3 has argued the matter. Then the due to procedure hearing could not be completed. Let the matter appear. Give the date. 17 July at 11:30.
Would it be possible, my lord, for an earlier date?
Sign, because the first week of the July, first week and second week, I will not be there. That's why.
Very deep.
Where my lord kind leave to mention a matter. My lord, this pertains, my lord, to a probate granted by my lord. This was in January 25. My lord will find that, my lord, this was subject to me furnishing bonds of two sureties, my lord. Now, my lord, I have, my lord, duly complied. This is an unfortunate case, my lord, where my lord, the in-laws and the husband died in space of 2 days during COVID. Now the widow along with two minor are there, my lord. Now, the department, my lord, is now insisting on a very strange, my lord, request that he has furnished, my lord, securities from HDFC Bank, Indian Bank, and, my lord, this is worth, my lord, 22 lakh rupees. The department now says that so far as HDFC Bank is concerned, we don't need a letter of lien from the bank. So far as Indian Bank is concerned, they would want it from the. This is strange, my lord. This is what, my lord, I have. This is, my lord, a format which the department has forwarded, my lord. Now, this is the bank. They are saying, my lord, they would not issue unless there is an intimation from the court. Now, my lord, I have given on affidavit the bonds, the fixed deposit receipts. What remains, my lord, after this? My lord, this letter, the department is insisting now, my lord. This perhaps is absolutely new, my lord. We have never seen this happen before, my lord. But I was therefore humbly submitting, my lord, everything has been done. My lord, this compliance has to be done. My lord, my affidavit is ready, my lord, with the fixed deposit receipts. My lord.
Why the bank is not giving the lien?
Bank says, why should I address a letter to registrar without being called for? So if the High Court asks us, we'll certainly give a reply. But there is no occasion for the High Court to write to the bankers asking for a lien, my lord. When I have myself tendered, my lord, the fixed deposit receipts, my lord. This is sufficient in my respectful submission. But
No,
this insistence.
In the bank, this form that fixed deposit.
Yes, I am giving fixed deposit receipts before the registrar.
Correct.
That is sufficient. Should be sufficient.
Correct, but that should be written as a lien. Otherwise, tomorrow.
But the difficulty here.
That is the see. My practically, I said this procedure is unknown to law.
Yes, my lord.
Correct. But I find from here this procedure has been adopted by
Now, my lord, my difficulty is ICICI. The department says ICICI Bank is not required, but for Indian Bank you have to take a. This is very strange, my lord. And now the bank is refusing. Now I'll have to. I can't. My lord, I have to file a suit against the bank. It remains. The bank is not. It has refused to issue unless there's a request from the High Court itself, which I don't think will happen, my lord. So it gets stuck forever, my lord.
You do one thing. You file an affidavit. You will not revoke this fixed deposit.
I'll file an affidavit.
File an affidavit.
My lord, kindly let this appear to be mentioned tomorrow, my lord. I shall
file an affidavit. It don't not accept. Come with. I will give the leave to that.
My lord, my only difficulty is kindly make it.
But if under
I'm so
compelling
deeply obliged.
circumstances, may I mention this matter? This is that Ujha's matter. Your Lordship will recall, Mr. Rupa Ghosh was addressing on behalf of the review applicant, and other side was led by Mr. Shaku Sen.
Mr. Sen
Now,
was
your
arguing.
Lordship was pleased to fix the matter tomorrow, your Lordship. Lordship takes up the regular side matters on the second half. Mr. Ghosh has requested if it cannot be, because he has some personal difficulty in the second half. He'll be there in the first half. Lordship, subject to your Lordship's convenience, if it can be taken up in the first half, otherwise, your Lordship,
It's better that your
day-
Lordship fixes any other date.
any other date, barring 26th and 27th. Any other day. Right, because he will not be.
Yes,
Absolutely. And he is to rejoin. He is to give rejoin.
They have concluded their submission. Mr. Sen is about to conclude his submission.
Yeah, let it to come tomorrow. I will see the diary. I will fix that.
Very
well.
I'm sorry.
Deeply obliged. Item number 23 of your Lordship's daily list today. If it could appear on Monday or any other day convenient to your Lordship. Your Lordship, tomorrow, if it appears tomorrow, I am item number 23, your Lordship. If it can appear any day to your Lordship's convenience except tomorrow, your Lordship.
Why? What is the problem tomorrow?
My advocate on record won't be there. So and also I have some personal difficulty.
Item 23.
Yes, your Lordship.
I don't have
the applicant is here also.
Son suffering for the plaintiff, son suffering for the defendant. As per the prayer made by the counsel for the plaintiff, the case adjourned. Let the matter appear on 3rd July. Which one? 23? Give the name.
Lord, may I have my Lord?
Defendant number 3. Yes.
May I, my lords, kindly, my lord, to mention, lord, the suit, lord, suit number CS 61. Your lordship had given leave today, my lord,
So
but
you missed the bus.
Lord, I'll just
Second
tell,
time.
I'll just, my lord, just 1 minute, my lord, my lord, because of some, my lord, procedure irregularities, my lord, this couldn't have been done.
So
The records are
so
before my
I
lord.
have time.
My lord, under presentation of plain, my lord, my learned senior friend from Bombay has come, my lord, for this matter, kindly, my lord. Just one indulgence tomorrow under presentation of plain, my lord, 10 minutes, the matter will be over, my lord.
Presentation of plan 2 minutes, but
GA1 will only, my lord, only, my lord, 3 documents will show, my lord, and my lord,
when I have
tomorrow, my lord, second of kindly, my lord. My learned senior friend has come from Bombay, my lord. Kindly, this much indulgence, my lord. I'm not seeking for further indulgence, my lord. It's, my lord, my lord, I admit that it was
already
our fault.
कल top में fix है ना? हम top में भी है ना?
Under presentation, not only 10 minutes will take, my lord. My lord, as I had indicated earlier, my lord, a pharmaceutical giant has been prestige.
2 days, Monday they
Lord,
must
my lord, every day it's happening, my lord. Every
Jasmine
day
Mukherjee will come.
stoppage, my lord, every day stoppage amounts to, my lord, lakhs and lakhs of losses for the pharmaceutical company, my lord. Kindly, my lord, just tomorrow, my lord. The executives, everyone, my lord, have arrived, my lord, to see the
3 PM है fix है
But 2 p.m. only, your lordship. We'll just take 10 minutes of my lord's extremely valuable time, my lord, and we shall be
okay,
done.
let us see. देख लेंगे
Lord, kindly, my lord, kindly.
Okay, it will be listed. Let me see what.
Very well, my lord. Extremely grateful, my lord.